Good morning, everybody. Oh, that hurt. Oh, did you guys see that? I hope it didn't break. Uh-oh. Oh, no. What did I do? Oh, it didn't break. Okay. That strap flapped up and hit me in the back of the head. Well, that was rude. Rude strap. I bought a chest mount for the phone so I can so Jill can watch me crochet and so I can take the phone on roller coasters. Crochet. Why have I started putting the 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 accent on the wrong part of the word? Oh man. It better not do that while I'm on a roller coaster. I'll lose my phone. Good morning, Carla, Jennifer, Jill. Judy had to take her sister to a doctor's appointment, but she did leave trivia. Margaret and Martha Ratliff have tried their best to move on with their lives while also maintaining relationships with their father as well as their siblings, except for Caitlin. Reports say Margaret is now based in LA, where she works in the entertainment industry. Martha is believed to have taken inspiration from her own experiences and is focusing on helping others by serving as a mental health counselor, psychotherapist in Colorado. Wonder why they moved so far away. This goes in the front, and that part goes over your head, and that comes around and hooks there. And one of the straps, well, now I don't know which strap it was, came undone from the back part from behind me and flipped up and hit me in the back of the head. Oh, I'll worry about that later. Hey Marty, hugs. I'm glad you're here. I found a Florida clip. Now, I see alligators, not I won't say all the time because I don't see them all the time, but I see them whenever we go down the river. They're everywhere. And like a 6-foot alligator. Yeah, you tell it, Jill. um a 6-foot alligator is a big alligator. That's probably on the bigger side of what I've seen. But like a 3-foot, 4-foot gator, yeah, you see them all over the place. Marty. Not that kind of strap on. So I saw this, and this is in Polk County, where my husband is from.
Is talking about on Facebook tonight. Take a look at this guy, an alligator probably bigger than you've ever seen, crossing a trail in a Polk County park.
Yeah, it really is an unbelievable sight, isn't it? ABC Action News reporter Ryan Raich caught up with the brave hikers who captured this big guy in action and explains the backstory of this monster gator.
It's the video that lit up the internet today. An alligator nearly as long as an SUV, sauntering from one marsh to another and stunning onlookers nearby.
It was just awe-inspiring.
Christy Buckley was just wrapping up a morning hike with her husband Sean when the gator started to move. That's them right there lying on the ground, capturing these still pictures from the other angle. And yes, he's just as big from that side too.
So my husband and I are calling him Godzilla because that's kind of what he looked like going across the path, yeah.
Crossing so slowly, his feet flopping with every step, and that tail dragging long behind.
He's so prehistoric looking. He's amazing.
And before you start calling this a fake, talk to the regulars at Circle B. The estimated 13 to 15-foot gator even has a name, and it's been around here for decades.
The big humpback is what everybody's calling him. His back is a little bit higher up than normal.
So check this out. Normally Circle B is a pretty quiet park. Not today. Everyone's heard about that gator and are actually making up their own parking spot just to get a peek.
We live nearby and we come out here, but we came out today because of that.
The trails on this protected, sprawling piece of land is a hotspot for hikers and photographers because you never know what you'll find. Like in this case last spring. This time around, Buckley says they never felt threatened and they were ready to jump to their feet if needed.
I probably should have been a little more afraid than I was. I was just so inspired by seeing this amazing creature.
A creature that almost looks to be from a different era. In Lakeland, Ryan Raich, ABC Action News.
That's an old gator. Old. They don't get that big unless they're old. Oh, yeah, it is. It's hump day. It's also Earth Day. No. I'll protect you from the gators, Jill. I didn't count again. Okay, so we've got, I think this guy has two. He does. He has two videos. So we're halfway through the first one, and then he has another one. And then Dr. John Butts. Man, I would have changed my name if that was my last name. Faison was bad enough. The kids in elementary school call me Phaser Laser. Can you imagine being named Butts? So then Art Holland comes back to the stand again. Good Lord, leave the man alone. Okay, so we have 1, 2, 3 witnesses, and then something outside the presence of the jury, which that might be the charging conference, so we could skip that. And then we have closing argument from the defense. So I guess they deferred. Prosecution deferred and decided to let the defense go first. That's 3.5 hours long. 3.5 hours, y'all. 3.5 hours. I texted Judy and I said, Rudolph's closing is 3.5 hours. How much of it do you think is him just repeating himself? And she said 3/4. And so then we've got an hour from each of the prosecuting attorneys. So 5.5 hours for closing arguments. and 3 more witnesses. So I hope we get through the rest today, but I don't know. I can't. I can't because it's on Court TV's website. I wish I could speed it up. I can't.
All right, for those of you who ever thought that this was a big world, I'm getting ready to give you an example of how small it really is. So we have a juror who was a neighbor of Mr. McElhaney.
It's not boa constrictors, Jill. It's pythons.
And if you think about it real hard, who's sitting on our jury, you can figure it out. But has to do with Mountaineer basketball. So
Okay,
she did not see his name on the witness list. Yeah, I know. She does not think it will affect her participation as a juror. I don't know if the witness recognized her, but
they're there though.
She does recognize that
And
they were
Panther.
next door neighbors. I think they stayed across the street from each other. And I'm paraphrasing what the deputy has told me. And the reason I'm paraphrasing is so if you want to make inquiry as to her knowledge, his knowledge of her, whatever, we can do so.
Well, could we have a few minutes to talk about it?
Sure.
Thank you.
Only when it's cold.
Yes.
Okay, you guys.
Well, actually, Mr. Harden went outside, but
You guys are distracting me. I gotta go back because I have no idea what they just said. Only when it's cold. It doesn't rain iguanas in the summer. And only if it's cold enough in the winter, which is not but a few days. So you're safe. Yeah, I'm not cool with pythons either. They're South Florida. You're coming to North Florida because you're coming to me. So, hey, Tricia. So no iguanas. Oh, Marty, why do you think we're so crazy? Look at everything that just was mentioned in the chat. Bears, panthers, pythons, gators, hurricanes. That's why we're crazy. Karens, yeah. It doesn't rain all the time. It only rains in the summer. I don't know why we're called the Sunshine State because it rains all summer long. Every day. Every day. And every year I say, why are we the Sunshine State again? Every day. I live out in the country. And I never see these things, ever. But apparently the people in the city are starting to see them. So I think I'm in a good place. Because, like, there was a python, I forgot how long it was, found in Ocala, which is an hour south. And I was like, oh crap. Don't tell me that they're starting to come north because I can't handle pythons. But that's the only one that I've heard of that's been seen this far north. So bears though are probably up here somewhere, but I've never seen a bear. Yeah. We're just south of Georgia where I live. We're like 2 hours south of Georgia. That's Georgia, not Florida. But I've never seen anything in the when I visited my family in the Keys, I did see, I want to say Gila monster, but that's not what it is. It was a giant iguana. I don't know. I have no idea. There used to be a thing in South Florida somewhere called Monkey Jungle where they had performing monkeys. Oh, but no, I've never seen any of these scary creatures in the wild except for like, I guess it was just a really big iguana, but we swore it was a Gila monster. It was so big. And my mom, we were in the Keys visiting my family, and my mom and my aunt had gone to the store, and it was me and my dad and my uncle, and we swore up and down we saw it, and my mom and my aunt refused to believe us. This iguana, it was a big, it wasn't like one of the little iguanas you see up in a tree. It was a big iguana. Like, it looked like a monster. We were all freaking out because we saw this giant iguana, and then nobody believed us. But that's the only thing I've ever seen in the wild. They chase cats? Seriously? So yeah, it was just an iguana that had gotten really, really big. It wasn't the kind that fall out of trees when it's cold. Because this one I don't think could have got up in a tree. It was so big. Oh my gosh, that's terrifying.
Whoever thought that this was a big world, I'm getting ready to give you an example of how small it really is. So we have a juror who was a neighbor of Mr. McElhaney. And if you think about it real hard, who's sitting on our jury, you can figure it out. But has to do with Mountaineer basketball. So she did not see his
Had to
name
take
on
her
the
sister to the
witness
doctor.
list. Yeah, I know. She does not think it will affect her participation as a juror. I don't know if the witness recognized her, but she does recognize that they were next door neighbors. I think they stayed across the street from each other. And I'm paraphrasing what the deputy has told me. And the reason I'm paraphrasing is so if you want to make inquiry as to her knowledge, his knowledge of her, whatever, we can do so.
Well, we have a few minutes to talk about it.
Sure.
Thank you.
Really? I've always wanted one.
Yes. Well, actually, Mr. Harden went outside, but I think he's asking the witness something, so you probably ought to let him finish doing what he's doing.
I saw a guy at a pet store with one in his pocket. He was walking around and the iguana sticking out of his pocket. I wanted one ever since.
I think they're asking that you approach the bench, Mr. Harden. He's asking to approach the bench. But you make a good point. If it wasn't clear, this was years ago in West Virginia. It's not now.
Yeah, and now that I understand that, I don't see any need to inquire.
May I go?
Yes, we're ready to go.
Professor McElhaney, I think you said that State's Exhibit 223 is actual size.
Approximately.
What's the width across that area there.
Yes, that's larger than normal, and I sized this by taking the 2.5 inch dimension
Yes, sir.
here and making that 2.5 inches.
I understand.
That makes this. I could give you an actual number. I measured it, but I forget what it was.
Hold on 1 second. We have a rule.
Yeah, it's about 7.5 inches, which is too large.
How wide is the average woman's head?
I'd estimate about 6 3/4 inches, 6.5 inches.
Okay, so that's about an inch too wide.
Yes. Now, I sized it from the dimension between this laceration here as approximately 2.5 inches.
I'm measuring this as almost 8 inches right there.
Well, 7 3/4 is. Now recognize though, see that that head is tilted. You see, so that the surface you're getting are at an angle. But the way I did it was to get that one dimension right. Now, that makes things a little big, because that dimension is probably measured by Dr. Radish along the curve.
Right.
And the foreshortening makes that then larger than it would be.
But for example, this thing is showing that the shaved portion of the head is like over 8 inches.
No. That's tilted. So you're seeing. So you're measuring. So it's tilted this way. So you're seeing this surface here and that surface there.
Yes, sir.
So you're measuring on a diagonal.
In other words, you're not saying that from the bottom here to the top here goes up from the bottom to the top of the head 8 inches, are you?
No. I'm just saying the way I made that was to take that 2.5 inch dimension and make that 2.5 inches on the photograph.
Okay, and I'm just trying to get a sense so that we're all clear about what that does to whether this is.
What it does is it makes the head bigger than normal.
A lot bigger.
15%.
Okay. Now, in terms of where the lacerations were, you did have access to the autopsy report, did you not?
Yes.
And you know there's diagrams on the autopsy report?
Yes.
Maybe put that up, please. Go down the. Now, you see where the lacerations are indicated on the autopsy report?
Yes, I do.
And the highest laceration on that autopsy report comes up to about, maybe a little bit below where I'm pointing on my head right here. Is that about right?
I can't see because of your hair.
I'm sorry.
I have a better head.
All right, we'll use yours. All right.
But it does
come around so the jury can see.
Okay. And this is very rough, just eyeballing it, but it's going to be about that distance, and that's about 2.5 inches back from that drawing.
Okay.
Of course, I have no idea what the scale is, how accurate that drawing is. I actually blew it up here and have it scaled out.
Right.
So that.
Of course, that wasn't done to scale.
I know, but I have a scale on it.
Okay.
With this blow up.
Right. And you would agree with me, would you not, that the lacerations that are shown on that diagram are to the back of the head, not the top of the head?
Yes. And I say I estimated that shows about 2.5 inches back. My report, I said from looking at the photographs and other considerations that it's about 1.5 inches back.
Okay.
So we're not too far different.
And are you able, on this photograph here, States Exhibit 224, to identify the occiput?
No.
You can't?
No.
Without
I
identifying.
tried. I mean, that's why I can say it.
Okay. Without identifying the occiput, it's a little bit tough then to figure out where on the scalp these are, right?
It is.
The two lowest lacerations here. See that?
Yes.
Would those be down pretty low?
I wouldn't expect them to get down into the muscle, so
Right.
to just be below the insertion. I'd say that they're right along the bony ridge back here. The bony ridge,
Right there.
in this. Well, that's of course, but along that ridge.
Mm-hmm.
Down here is where the muscle inserts, and I don't think you'd get a laceration because of the underlying tissue.
And of course, in this area, there's a curvature of the skull, right?
Yes.
And indeed, that's part of the reason why you could conceivably get, if there was an impact there on a flat surface, because this is curved, you could conceivably get forces pushing out two splits there. Could you not? Given the curvature?
I don't follow that.
All right, sir. If there's a, do you remember Dr. Bandak testifying that if there was a blow in that area, you could get forces radiating down that way that would cause two splits?
No, I don't remember him saying it would cause two splits.
Okay.
I thought he was explaining how you can get shearing in that area. But my understanding of mechanics, which I think is a lot, would say that you have to have contact to cause shearing.
Yeah.
So you have to have contact.
I understand. Now, I think you said something about after that first fall, she would have used up 2 or 3 feet of height, and so she wouldn't have another 2 or 3 feet of height left to generate enough force to cause another laceration. Is that a fair paraphrase?
In the second, along the wall. She doesn't, the way I looked at it, I didn't see enough velocity there, nor recognize now the velocity we're talking about is not the velocity along the wall, but into the wall.
Yes, sir.
It's the perpendicular velocity that we have to have, and she only falls the width of the molding to catch the wall.
Okay, hold on a second. Let me just.
Normal to the wall.
The first fall in the animation, and by the way, you're aware that Dr. Bandak wasn't saying that's the way this fall occurred, or these lacerations were created. You're aware of that, right?
Yes, it's my understanding he was offering that as a possibility.
As a possibility.
Yes.
And there's lots of other environmental possibilities that he talked about, right? In that stairway.
That was the only one that I thought he really detailed.
Yes, sir. But
he said there were others.
Yes, sir. Now, in that animation, he was talking about her falling from step 15, correct?
Yes.
Backwards. And her head striking at about 61 inches, correct?
Yes.
And there's certainly about 3 feet of space for someone falling back and hitting their head against there, right?
Vertical drop is what we're talking about.
Yes.
Yes, and that's what I believe I testified to.
All right, and then if somebody then fell from that 61 inches down to the floor, there would be enough vertical drop there to create another scalp laceration, would there not?
Yes, but he didn't have that. He had her hit the wall first.
Well, he had a glancing blow on the wall.
But he said, I understood him to say that could cause a laceration.
Oh, no, sir. No, what he said was, I believe, that it was a glancing blow, and then the laceration would have been caused at the very bottom. I think he said that there would have been 2 possible lacerations, one from the molding and one from an impact on the floor itself. Do you recall that?
No, I don't. But,
Okay.
If that's what he said, that there's potential for 2 lacerations in that fall, I would agree to that.
Okay. So if he didn't say that she had a laceration from that glancing blow on the wall, what he was saying is that she had a second laceration, or perhaps you can have 2 lacerations from a single fall, can you not?
Yes.
For example, if your head were to hit, if you have, for example, a wall, you know there's a north wall and then a floor.
Corner you're talking about. Yeah.
So, and there's a molding, a base molding that runs along. There's a base molding that runs along that wall, that north wall. And so if somebody hit their head and side of the head hit the base molding, the little piece that's sticking out.
Yes.
And then the rest of the head hit that and then landed there, you can have 2 lacerations from that. You'd agree with that, right?
Yes.
Okay. So there would be enough energy in Dr. Bandak's scenario to create a single laceration against the door jamb, and then enough energy to create 2 lacerations if the head hit in a particular way.
No,
at the bottom.
I only go 1 laceration there.
Well, if it hit at the same time.
We have to talk about the velocity perpendicular to the surface.
Yes, sir.
Now, you can't hit in a corner and have a lot of velocity against one corner and a lot of velocity against the other corner unless you're going in at 45 degrees.
Yes, sir.
Which she's not.
How do we know that she's not?
Well, certainly in that animation, she did not do it. And so, she didn't do it in that animation.
Well, your recollection of the animation is that she didn't go in at a 45-degree angle, but you could go into that corner at a 45-degree angle and cause 2 lacerations.
That's right. You could at a 45-degree angle. But now let's look at where the lacerations have to be.
Yes, sir.
So we have to hold this up at that 45-degree angle, and you're going to see that the lacerations are inconsistent with the.
What's going to happen is you're going to have. Do you remember Dr. Bandak trying to sort of illustrate this to the jury, where he was trying to say comes here and hits there? So you have a stellate wound on one surface and a more linear wound on another surface?
Yes.
I want to break your head there.
You won't break.
Now, and then are you aware that Kathleen Peterson apparently got up at some point after she fell the first time?
I am aware she had blood on her feet.
And that people indicated that experts in blood spatter and both the state's experts and defense experts indicated that seemed to indicate she had stood up at some point after there was some significant bleeding. Do you know that?
I think I know that. I'm not testifying about blood spatter here. I'm not an expert in that field.
I understand. But in any event, assuming she did get up, she could have gotten to a height of 2.5 or 3 feet and fallen back and caused another laceration, could she not?
Yes. And
that's what was depicted in the animation, was it not?
Yes, that's 3 lacerations that I see.
Yes, sir. And when we're talking about lacerations, you can have more than one laceration, just so we're clear, from a single impact, can you not?
Yes, you can.
And indeed, you testified earlier today that there were at least 7 lacerations, but that's not what you said in your report, is it?
No, I said that there are 7 lacerations in my report. I said there are at least 5 impact sites.
Well, actually, you said 5 separate lacerations, did you not?
That's why I say there are at least 5 separate lacerations.
Yes, sir. And then you talk about the 3. Now, Coach, you talk about the 3 major lacerations. You see
Yes.
that?
Yes.
Are approximately vertical or up and down, right?
Yes.
And by that, when you say 3, you're talking about this vertical, and that vertical, are you not?
No, I'm talking about.
You didn't say 4, you said 3.
That's right. But you indicated the multiple one at the top. And I'm
you weren't, so 1, 2, 3?
Yeah, that's right.
And then you talked about the 2 at the bottom. Let's see where those are referenced. You see where those are referenced there? You talk about the 2 at the very bottom.
Where?
Well, that's what I'm trying to find.
Okay.
Do you know where they are? Where you talk about those? We don't need to spend time now. I'll find in a minute. But in any event, at least in this report, what you identified specifically were 5 lacerations, correct?
I say at least 5.
Yes, sir.
Yes.
So you didn't point to any more than 5 in the body of your report.
That's right.
And with regard to the lacerations, you would agree, would you not, that at least one of those is a stellate type laceration?
It certainly has multiple fingers on it. Yeah, so you could call it a stellate.
And a stellate type laceration is consistent with an impact on a flat surface. Is it not a hard flat surface?
Yes, or an object having approximately that shape.
Yes, sir.
Right.
By the way,
or I should add a third. The third thing is it could be multiple impacts from a straight object.
if the impacts were exactly in the same precise location.
Well, if you look at that, it's not, it's smeared, but they do have to be quite close to one another.
Now, you would agree, would you not, that the lighter an object is, the faster it has to go in order to cause a particular injury?
Generally, that's correct, particularly for closed brain injury or skull fractures.
Well, it would also be
which
true.
are an impact energy phenomena more than velocity.
It would also be true of scalp lacerations to, I think you said, to a lesser extent, right?
To a much lesser extent. I think in scalp lacerations, when we get to something that weighs half a pound on up, the velocity is more critical than the mass.
By the way, have they informed you that we actually identified the blow poker yesterday?
Objection. Sustained.
Excuse me. Have they?
I saw that on Court TV.
I see.
But no, I was not informed of that by anybody from the district attorney's office.
You had an opportunity to look at this one, right?
I did.
And did you take it apart to see how thick the metal is on there?
Yes.
And what, about 1 millimeter?
I measured about a 32nd of an inch.
How does that compare with? Well, 32nd. It's pretty.
A millimeter, I guess, is a 25th of an inch. So
thin.
yes.
You measured even thinner than
a little thinner than a millimeter. Yes.
And it's made out of brass, right?
Yes.
Which is not the strongest metal around, is it? The stiffest.
No, it's not the strongest or the stiffest.
And in order to lacerate a scalp, I think you said you have to fall a head weighing, say, 9 pounds roughly 10 pounds, would have to fall about 3 feet or thereabouts.
Yes.
But you couldn't, and that would be about 14 feet per second.
Approximately, yes.
But you couldn't cause a laceration with this thing at 14 feet per second, could you?
Probably not.
You'd have to be up near 55 or 60 feet a second, wouldn't you?
Well, that would give you, see, it doesn't quite work that way. To cause a skull fracture, you would have to do that at 45 or 50 feet per second is what I've calculated.
And what is your calculation about how fast you'd have to hit somebody with this to cause a scalp laceration?
I did not calculate that, and because there's too many unknowns about defective shape on lacerations. But certainly somewhere between 45 or 50 feet per second and 15. I could give you an estimate of, say, 25 feet per second, 30 feet per second. Just for an idea of what we're talking about here, to throw these numbers around, a football player, a fast football player that can run 100 yards in 10 seconds is going 30 feet per second. So that's a fast run. Mm-hmm. So 15 feet per second that we're talking about for a skull fracture or potential head injury and a scalp laceration from the head falling is about a fast jog.
So is it your testimony then, just so I'm clear, that if a fast football player was running with this thing out as fast as he could and hit a head, that would cause the kind of lacerations that you see on Kathleen Peterson's staff?
No, it would be
faster than that.
It would be faster than that. But just consider now running with your head down, full tilt into somebody holding this thing so you could hit it with your head. That could cause a laceration, but not as severe as what we have here.
Right. Mm-hmm. So to cause the kind of lacerations we have there, you'd be up well above 30 feet per second, wouldn't you?
Above 30 feet, but below 50.
And did you do any testing? You can do testing on things like this to figure out if you hit this into a hard object, like a skull. A skull's a hard object, right?
No, I mean, not in the...
Well, if you hit this into a skull covered by a scalp, mm-hmm. at whatever the velocity is, 35, 40, 45 feet per second, you could figure out what it would do to a hollow brass tube like this that's a 32nd of an inch thick. Couldn't you?
Yes.
And did they ask you to do any such calculations?
No.
Would it be fair to say that it would be dented?
I wouldn't call it a dent. I think it would collapse the wall and leave an imprint and even put a permanent bend in it.
Right, and it'd be mangled. I think Investigator Holland said yesterday, if you took this and banged it against somebody's head, even one time, hard enough to cause one of those lacerations, it'd be mangled. It'd be like one of those cartoons where somebody hits somebody over the head and it forms the shape of the person's head, pretty much.
Well, it depends, of course, very much where the blow is impacted. If it's at the very end, where a lot of the mass is, you have less tendency to damage it. Mm-hmm. But I think it would be observable. If you hit it in the middle, it would leave a bend in it, a kink. I guess my idea of a dent is more localized.
Okay.
I'm seeing this.
You'd see it.
Some curvature to following the curvature of the head.
And you probably couldn't use it a second time to cause another laceration like the.
Oh, sure you could.
You could.
Oh, sure.
And then if you hit it the second time, then it would bend even more.
Or I'll bend a different way.
Right.
Different direction. You might even straighten it. I mean, but each time you do that at that speed, you're gonna put some permanent bend or collapse of the wall.
And after 7, you'd agree with Detective Holland, it'd be mangled, wouldn't you?
Well, I'm
not comfortable with that word.
Well, it's I don't know exactly what you mean by mangled, but in the vernacular, you could it would show.
Let me show you Defendant's Exhibit 280. You see any evidence in Defendant's Exhibit 280 of the kind of a dent or bend or whatever you want to call it that would come from even one impact?
Well, no, I don't. I mean, I see this bend up here where it's collapsed.
Yes, sir. Where it's crimped.
Well, crimping, of course, implies a purposeful machine type thing. This isn't crimped.
I see.
This is damaged. I mean, it actually has a slight crack in it. So this has been damaged.
Right.
I don't think that this happened. I wouldn't say that this is the kind of damage I would expect from hitting a head. So I don't see that this the piece is sort of threaded, very lightly threaded in at the end, as opposed to being screwed in.
Yes,
there.
sir. I understand
it's threaded in, and it would come down ways in there, and so this occurred with that piece out.
Yeah. And the bottom line is that your expert opinion would be that Defendant's Exhibit 280A was certainly not used to beat Kathleen Peterson to death 7 times over the head, right?
That's right.
So I have.
All right, Mr. Deputy, if you can take the jury to the deliberation room while we figure out the schedule right quick. Well, actually, Mr. Rudolph, while the jury is out, you seem somewhat shocked by the fact that both counsel for the state objected to your question to the witness about your defendant's 280 being the blow poke. I take it
was the stereo that took me by surprise.
I take it, first of all, that the state does not agree with you that is the blow poke, although we certainly read it in the newspapers and we've seen it on TV. I take it these two representatives for the state don't agree with you.
Well, they may not, but it's the only one that we were able to find in the house, Judge.
I was somewhat shocked by Mr. Harden and Ms. Black objecting, since throughout the course of this trial, they have not liked the double teaming by you and Mr. Maher at the defense table, objecting both at the same time.
Well, I interpreted that as completely unintentional, and we've tried to avoid the double teaming, so it was fine.
You're not allowed to do that.
I apologize to the court.
That's not how that works. You're not allowed to do that.
What are we going to do with our jurors? I don't know. You know, we had made some arrangements for a long day. I really didn't know what you all had in mind as far as a long day. I didn't know whether you anticipated the cross-examination or any redirect examination of this witness. What have you built that into your?
Your Honor, there would be just a little bit of redirect with Dr. Michael Haney, and then we would have Dr. Shabani all day. And again, just to remind the court, he can only be here tomorrow.
Well, I'm not the one that needs reminded.
Yes, sir.
I think counsel needs to be reminded. I'm going to be here tomorrow. I'm going to be here the day after that. I'm going to be here 2 days after that. I'm going to be here a month after that.
Yes, sir.
I swear I'm going to put an air tag on my crochet hook. I'm tired of losing the dang thing. You guys, I looked out the window and I saw what I thought might be fog, but with the drought and the wildfires and everything, I went outside and I smell smoke. So it's not fog, it's smoke, and it's all over the place. So I was on the phone with Travis. I don't know. And I don't think you can, but I gotta figure out some way because I lose that stupid thing all the time. It's awful small. I don't think you can put an air tag on it. I have got to figure out how to quit losing it though. Yeah. So if you guys are praying people, just please pray. Cause I called Travis because I'm like, I don't know what to do. I'm like, I guess I have to see fire before I call anybody, right? Do I have to actually see the flames in my yard before I can call the fire department? So just please pray that the fire, wherever it is. Oh yeah, I'm staying inside. No, Belle, no. Belle, no. Good gravy, Marie. Y'all, do you need to go outside? No. Okay. Fine. Just do it in the house. I don't care. Ugh. The dogs think the house is a bathroom. They don't need to be going out and breathing in all that smoke either, though. Yeah, there you go. Do it on the linoleum. It's easier to clean up. Oh, what is wrong with my dogs? So yeah, if I see fire, I'm gonna call the fire department, but I have no idea where it's coming from because I don't see it, but I smell it and I see the smoke everywhere. So if I get up and just the stream ends or whatever, it's because my house is on fire. Hopefully not, but
You get the point, right?
But not in this trial, right?
I didn't say. I didn't say that. I hope to be here a long time after that, but not in this trial. You can bring mine. All right, members of the jury will take our overnight recess. Remember the instructions the court has given you throughout the course of this trial. We'll see you tomorrow morning at 9:30. Remember now, we're going to go long tomorrow, but I don't think we're going to go past 4:30. Y'all remember that? Okay, we'll see you tomorrow. I've alluded to the
so can I call the non-emergency number? Just to let them know there's smoke and something smells like it's burning? There is a burn ban. Usually if I smell smoke, it's a controlled burn because I live out in the country and they do controlled burns all the time. But there's a burn ban right now, so I know it's not even a control. So usually if I smell smoke, I don't worry because it's like it's a controlled burn, but okay. All right, I'll call. We're almost done, Deb. We might get done today, actually. Oh, okay. Yeah, usually because we do control burns and usually I just, oh, it's another control burn, you know? But I know they're not doing that now with the drought and everything. Yeah, you smell smoke. Okay. Thanks, guys.
The other day, I have talked to the jury pool clerk, and I have talked to the lawyers involved in this case about a request that you have made. I wanted to just take a short period of time to explore that request with you. So if it can be worked out, we have some kind of idea of what you want. Since I haven't talked to you directly, I'm assuming that what I received from the jury pool clerk was correct, but not necessarily so. So what I need to do so I don't have to talk to 16 jurors is for you to just agree on somebody who can be your spokesman on this. The photo issue is what I'm talking about. Is there somebody that you all can just agree on will address the court about that issue? I just want to know what it is you want to do and how you want to do it. Who wants to speak? Come on, somebody speak.
With all due respect, sir, that's my idea.
That's okay. I don't care whose idea it is. I just want to know what it is you want to do and how you want to do it.
I did not want to turn into a can of worms, but we have invested a significant amount of time in this trial, and we've all gotten to know each other.
Well, you don't have to go through all that. I think I've already discussed it with the lawyers. They agree to do it. So just tell us what it is you want to do. I understand why you want to do it and all that.
Specifically, all we request is just to have a picture of the jury all seated in the as we are right now, and we also let's have a picture of yourself and also.
Well, I can understand why you want a picture of me.
Like a picture of the two prosecution attorneys and the two defense attorneys.
Okay, and the way you want to do that is how? Had you thought about that?
I had not thought.
Do you want the deputy or somebody to take your picture, or?
Obviously, you would have to be sitting there. However, with the defense and prosecution, however they want to set up there.
All right. Well, I mean, do you want to? Somebody's gonna bring their own camera, or?
Yeah. Yes, sir.
You gonna bring your camera? Okay. And you want to do this tomorrow, maybe?
Whatever would be convenient.
Okay. Why don't we plan on doing it tomorrow? At some point, we'll figure out what it is you're trying to get. We'll figure it out. Okay. Is there anything else right now?
Yes, sir.
Of course, you realize that if you take my picture, you're gonna have to pay for it.
Yeah, but let's see over judges. I'm not sure.
Okay, let's settle it. Now, where are we at this point, ladies and gentlemen? Counsel.
We direct with Dr. McElhaney.
All right.
Now, Dr. McElhaney, yesterday you were asked a number of questions about Dr. Ferris Van Dyke's animation or reenactment, whatever you want to call it, what he called the most likely scenario of the events in the stairwell that caused Ms. Peterson's interest. Correct. Now, I want to make sure I understand what your testimony is. In response to questions to Mr. Rudolph yesterday, you mentioned that you would agree that she could have gotten 3 lacerations by falling down the steps. Is that correct? Do you agree or disagree with that part of Dr. Van Dyke's testimony?
Falling twice.
Falling twice.
Yes.
Now, with respect to that, do you agree or disagree with the location of the lacerations, as you know, were on her head based on having potentially fallen in that fashion?
2 of those lacerations in that scenario would be different than the ones that she suffered.
And why do you say that?
Because the impacts positions would be different than where these lacerations were. One of them, however, could be accounted for by the initial fall, as demonstrated by the animation.
May I approach the witness?
Yes.
Just straight.
Yeah. Okay. Now, Dr. McElhaney, I'll show you states that it's 225, 226, and 227. Now, 225 and 226 would be representative of the first or second fall in your understanding of the animation.
The first fall.
Okay, now, states exhibit 227, Mr. Rudolph was just reminding me that this would be as a result of the second fall.
Yes.
Okay. Would these photographs help you illustrate your testimony to the jury about what you're saying to us as far as her position and the position of her, the location of her lacerations?
Yes.
I moved to introduce State's Exhibit 225, 226, and 227 into evidence. Step down before the jury if you would, please. May he?
Yes.
And use these photographs to illustrate your testimony about what you're talking about. Let's use 225 and 226 first.
Okay, these are stills from the animation that Dr. Van Dyck prepared. Actually, the animation is a series of still photographs that are showed in sequence, and these are just two of those positions. This is the.
Is there something about one of those positions that you just simply don't agree with, or you think it's just not feasible?
Well, this is the position after striking, falling off the third step and striking the rail in this area. Then he has her going down the wall, sliding down the wall. And I had offered the opinion that this impact against the wall would not cause one of these lacerations. Then she slides down the wall and could contact this molding, but she's sliding down the wall, and that's not going to cause a laceration. In my opinion, that is, there's not enough energy to cause that laceration. However, she could then strike her head, as he has shown here, on one of the steps.
Hey, Judy, welcome back. Oh my God.
Energy and velocity at that point to cause another laceration. However, in my opinion, the point of contact.
That's where my stepgirls live.
With the initiation point.
That's one county over.
Of the 3 or 4 major lacerations up close to the top of her head. And I think that shows.
So you just feel like that's simply just not possible?
Well, objection.
Is that your opinion?
Well, I don't use the word possible.
What word do you use?
Very unlikely. It wouldn't happen that way, in my opinion. It wouldn't happen that way.
All right, now let's use 227. Tell us about that.
227 is my understanding is that this is the second fall, that she then got up and fell again backwards against this step.
Now, in conjunction with that, with the second fall of that sort, as Dr. Van Dyck told us, could she get the lacerations, in your opinion, that you saw ultimately on the autopsy photo? Would there be enough energy?
There would be enough energy for her to get a laceration, and this could produce one of those lacerations at the base, but not both of them. She has 2 lacerations down the back of her head. And this could account for one of those, but not both, in my opinion.
All right, now, you also mentioned yesterday during your testimony that you had reviewed the autopsy report and the photos, and in your opinion, there was a minimum of 15 impacts. Was that your testimony?
At least, yes, at least 15 impacts. There's 33 different bruises, contusions, and lacerations.
According to what now?
According to the autopsy report, noted in the autopsy report. And then these are photographs showing some of those. And again, I have to show you these, but they are kind of difficult to look at. So
well, let me
have to
count in these terms. Would you be able to use the autopsy photographs to show us at least most of these, the minimum of these 15 impacts that you described?
Yes.
Maybe he'd be allowed to do that.
So,
all right, let's look at AKP2. Show the jury that photograph, please, and then show them how many impacts that you perceive on that photograph.
Okay, this is page And we can see the number of bruises on the face.
Point out the impacts, in your opinion, if you would, please.
The nose, across the bridge of the nose, is clearly something has caused that bruise. That's what we would call an impact situation there, across the nose.
Would you reverse that now, please?
Across the eye, another bruise. We have these marks on the forehead, another bruise, and then it doesn't show, but on her left ear, there's a significant abrasion on her left ear. So that's these are all impact points, and they're separate points because they're enough removed in her anatomy that contour of some step or wall wouldn't cause all of these at the same time. So they're caused, in my opinion, while there's I have to look at my notes. Yeah, there's 11 noted on the face. I identified, counting the ear, 4 clearly identifiable impact situations. But there are 11 noted, and there could be, we could say there's 11 different impacts that cause these.
Now, with this photograph here that I'm showing you, AKP3, show anything additionally that the last one?
No, I don't think. Well, it does. It shows another impact area underneath her chin on the right side. That's this mark here. So something caused that mark in this situation.
Let's look at AKP 11. Does that reflect one or more impacts?
Yes, this is impacts.
How many impacts do you see there?
Well, we can see on the wrist, we see bruises. So we see a bruise there. We see bruises, several bruises around the elbow. On that.
So how many impacts are you pointing out there on that photograph?
At least 2 there. Okay. At least 2. And
now look at AKP now. See any on there?
This is the other arm. And we see a bruise here, a bruise there, a bruise there, and also over the upper back scapula.
So how many impacts are you pointing out on that one?
Well, we can see here 1, 2, 3, 4, 5 if we want to think about those.
All right then. AKP 10. See anything on there?
And this is her hand. And we see bruises on the wrist and the knuckle.
So how many are you pointing out on that photograph?
At least 2 on this photograph.
All right then, AKP 7.
Okay, well, you don't need to see this again.
How many are you?
But there's 7 lacerations noted on that by Dr. Radish, and I would say at least 5 places consistent with an impact. You might get 2 with a single impact, but you might not. But there's another 5 there. So that adds up to at least 15 separate impact sites with 33 places noted in the autopsy of bruises, abrasions, and lacerations.
All right, you may take your seat, sir. Now, Mr. Rudolph, I talked to you yesterday about compensation and how much people charge to come to court and testify, and to look into cases and evaluate cases as experts. And you said that you do have a normal hourly rate. Is that right?
I do, yes.
Now, this is your first criminal trial that you testified in. Is that correct?
That's correct. I was called in the Rodney King case, by the prosecutor who was prosecuting 3 policemen for, I guess, abusive behavior.
That was how many years ago, sir?
Well, whatever that was.
Okay.
But they decided that the issues regarding lacerations to his face were agreed upon, and so that they didn't need me, and so I didn't testify in that case.
Now, you told us yesterday, you told Mr. Rudolph in response to his questions about compensation that you're doing this for free. Is that right?
Yes, I decided not to seek compensation.
Well, now, how many hours do you believe you've put into this case thus far?
About 40. I should say when Mr. Harden called me, and I think he called the university and they gave me my name, and I came down and looked it over, and we negotiated a little bit, and I told him what my hourly rate was, and he didn't have the budget for that. So I said, well, I'm going to be out of the country for the month of June, so I didn't want to be in the case in chief listed. But he said, how about rebuttal? And I said, well, that doesn't sound like too much work. So I said I could do that without compensation.
And why are you willing to do it without compensation?
Well, I've asked myself that. At the time, it seemed like the right thing to do under the circumstances, so I agreed to do it that way.
All right. Thank you, sir.
I got a few more.
Yes, sir.
In case you hadn't spent enough time, we'll spend a little bit more. But not too long.
Thank you.
Let me start off by. Do you have those photos up there?
I don't. They're there.
Oh, thank you. I'm going to go just so we're all on the same page. With regard to Exhibit 225, that's the one where the animation showed the head grazing the wall?
Yes.
Do you understand Dr. Bandak didn't testify that she slid down that wall? Are you aware of that?
Or that she didn't contact the wall?
No, what he said was she might have grazed the wall on her way down. Did someone tell you that he had said she slid down the wall?
No, I just looked at the animation and and it looks like she's grazing the wall. It's the same as sliding to me. I wouldn't argue.
Well, in other words, what he's saying is she may have grazed the wall on her way down as opposed to sort of sliding against the wall. There is a difference in terms of velocity and speed, depending on which one you do, isn't there?
Okay, I just talked to my stepdaughter. They're evacuating Bronson, which is in Levy County, and they're evacuating them to Chiefland, which is in Levy County, where my stepdaughters live. And then I live, like, Chiefland is here, Trenton is here. So I live here. So we're, like, parallel, and then Bronson is over here. So if the fire is over here and they're evacuating people this way, I think I'm good. I hope I'm good.
In other words, if you just graze the wall on your way down, you may slow yourself down a little bit, but that's a lot different than sliding down the wall, right?
That's right. But even sliding down the wall is not going to slow you down much.
Okay. In any event, you would agree. Can we go to the? Let's go to the. You would agree that there's certainly enough energy from the fall from there against the door jamb to cause a laceration, correct?
Yes.
Okay, let's do that one. All right. Keep going. Keep going. And that's where you were sort of assuming she was sliding down the wall.
Well, she has to get from that position to this.
Right.
And
Okay.
looks,
And of course, you understand, he's not saying this is exactly how it happened. He's simply saying she could have grazed the wall there, she might not.
that's right. And I guess what you're saying is that we in fact do agree that she wouldn't suffer a laceration
On that.
So that's all I said, that she wouldn't suffer a laceration that way.
All right, we're going to do. All right, and then keep going. Well, you see where there's a point of impact there?
Yes.
You're not saying that there would have to be 15 separate blows to get these injuries, right?
Plus 15 separate contacts.
Contacts.
Yes.
And you could have 4, 5, 6 contacts in a single fall.
Oh, yes.
7 or 8 or 9 contacts in a single fall, just depending on how you fell,
Well,
where your hand struck.
Because if I don't show up tomorrow, you know why.
8 or 9.
Okay.
5 is a stretch for me. 5, but 5, yes.
Other people might see more, or at least think that more was possible.
I certainly can't speak for other people.
In any event, you saw that one. That would be consistent. For example, we'll go back one. I'm sorry. There was some bruises on her elbow there, right?
Yes.
And that would be at least consistent with the bruising on her elbow.
Yes.
All right. Now, that's where Dr. Bandak postulated the possibility, at least, that she could have come down from the 61.5 inches and hit her head on that step, right? Sort of the rounded edge of the step.
The step, yes.
Yes. And you certainly agree that there'd be enough force, enough energy, enough velocity in that scenario to cause a laceration of the scalp.
Yes.
And I guess what you disagree with is exactly what there was 1 or 2 there at the base from that.
That's right.
And of course, if her head also, you see this little molding that comes out there, right?
I do.
In the model, they didn't actually have that molding coming out down there, did they?
I'd have to look at the pictures.
Okay. Well, in any event, there is a molding there, and you remember that Dr. Bandak was postulating that she might have sort of hit in the corner there. If you want to look, that's fine. That's all right. Dr. Bandak was postulating that she might have hit in the corner. I think you were talking about a 45-degree angle. It could have been a 50-degree angle or a 40-degree angle, but in any event that she...
Well, it's because she contacts the wall or grazes it, so she has to be turned shoulder down. And that does not give her then a velocity at 45 degrees into that corner, or 50 degrees or 60 degrees. It's more like 90 degrees.
Well, of course, she might not have grazed the wall at all. No way to tell at this point, right?
That's right.
In any event, we can certainly agree that there's enough velocity to cause a laceration. The disagreement between you and Dr. Bandak is over how many in the possible locations of the lacerations. Fair?
That's right.
And then, can we keep going? By the way, you see that bruise right there, that contact point right there? See that?
Yes.
There's actually one on the left elbow and one on the area where there's a bruise in the torso there. Do you see that?
Yes.
So that kind of contact would be consistent with this bruising.
Yes.
All right. Keep going. And that's just a view from the other side of the wall. Oh, and you see that hand there? That would be consistent with the bruise on the wrist over here, would it not?
It could be, yes.
All right. Keep going. Now, this is where Dr. Bandak was postulating that because of the blood on her feet, she might have tried to stand up at some point. You call that?
Yes.
And of course, there's no way to know exactly where she would have been when she tried to stand up, going back and trying to recreate it, correct?
No way for me to know.
No way for anyone to really know at this point, right?
Well, if the footprints were in the blood, I mean, there might be a way to know, but I don't have a way.
All right. In any event, you go now. Did you see? She starts to get up, and that's about what maybe a 2 foot fall there, something like that, 2.5 foot fall. Ballpark.
Yes.
And of course, again, you can't tell for sure whether it's a 3 foot fall or a 2 foot fall or somewhere in between, but generally speaking, there would be enough energy generated, enough velocity generated from a fall from that height, so halfway up, to cause a laceration, correct?
Yes, you could get a laceration at that level against the edge of the steps.
Yes, or for example, if you hit the molding where there's some age.
Well, I don't think in that position, but there could be another position that you could hit the molding.
Fair enough. And of course, at this point, you can keep going. And you see where her arm, there is hitting the 17th step, that one right there. That could be consistent with the bruising on her arm there.
That's a significant bruise there.
Yes, sir.
Recognizing that bruises take time to bleed out.
Yes, sir.
And she died before the full time would have elapsed for that bruise to show. So it's a pretty decent bruise.
Yes, sir, I agree. But it could have, I mean, if you fall from 2 or 3 feet on your bone there, you can create a pretty significant bruise, can't you?
Well, you could if you fall on that arm, but then, you know, we have her falling and striking other things too here, and
that would take up some of the energy.
That takes a lot of the energy out. I mean, I can swing my arm against something from 2 feet, just let it drop,
and when you say this
is not a major bruise.
When you say this is a significant bruise, what do you mean by significant? I mean, it didn't cover the entire arm or the entire forearm, did it?
No, what I mean is for a bruise to show within an hour or so of death, had she lived, that bruise would have been much bigger.
Well, do you know, for example, whether she could have gotten that bruise earlier that evening?
Well, no, I don't.
You know that she had been drinking.
I understand that she had something to drink.
And she had Valium on board. You know that?
Understanding, yes.
And you know just from your own research that that's not a good combination, don't you, in terms of falling?
I'd have to say that's really a little outside my area. But I do know that, yes.
And Flexeril, did you know that she was also taking Flexeril with the Valium and the alcohol that same night?
Now you're outside my area.
And an allergy medicine on top.
Is that the first time we've heard about the Flexeril and allergy medicine? Allergy medicine, Flexeril, Valium, and alcohol. How is she standing? Unless her body had gotten used to all that. Because that's a whopper. Flexeril on its own will knock you on your butt. That, like I said, unless she was had built up a tolerance, that's quite a punch right there.
I don't know.
I object that not being any testimony that we've heard.
Well, it's actually in the autopsy report.
Objection.
Okay, well, wait. He said he didn't know.
We've not heard it. Exactly. It's what I just said.
Now, you can keep going. Again, that could account for a bruise on the body or the arm, correct?
It could but it has to hit forcibly.
It has to hit hard enough to cause a bruise.
Yes.
All right. And do you know what effect liver would have on darkening a bruise after death?
I don't myself see why it would have any effect.
Okay. Do you know what happens to blood after someone dies in terms of it going to various points of the body?
Well, it's influenced by gravity, and then of course it clots eventually.
Now,
the rigor is a muscle phenomenon.
I was talking about liver, not rigor.
Oh, okay. Pardon me, I thought you said rigor.
No, liver.
Okay, that's gravity. I don't think that could look like a bruise in the lower parts of the body, and she did show some of that, but not. It wouldn't be on the elbows.
Now, in your summary of opinions, your very first sentence said, "It has been implied." Do you have a copy of it there?
I do.
It has been implied that multiple deep scalp lesions, like those that occurred in this case, can occur in a single head impact due to the head bouncing on a flat surface. You see that?
Yes.
Was that what Mr. Harden told you was our theory when he first talked with you?
Objection, Ralph.
Overall.
I think that's where I got it. I'm not sure where I got that. I might have gotten it from your opening statement.
Well, if you got it from my opening statement, did you hear me say that her head bounced multiple times?
I really don't recall where and I just say it's been implied.
Okay. And I mean, in number 4, page 2, may I put?
Yes.
Page 2, you talk about the 5 separate lacerations. You say, for this bounce to cause the severe lacerations that occurred, the head would have had to bounce at least 3 feet high.
Yes.
One reason that doesn't happen is the head is attached to the body. See that?
Yes.
We could all agree on that, I guess, right?
I think so.
All right. So, at least when did you write this summary? It's not dated.
Oh, I wrote this about a month ago.
All right, so at least as of a month ago, you were operating under the assumption that what we were claiming was that there was a bounce. Is that fair?
That was an assumption of one of the things you were claiming.
Okay. By the way, do you know Dr. Sammy Shabani?
I would say I'd met him this morning.
All right. You hadn't met him before.
He thought I had met him before, but I have no memory of having met him before.
All right. He did some experiments or something in this case, didn't he, for the prosecution?
I have no idea what he did.
You weren't involved in that?
No.
No one asked you to sort of sit in, oversee, look at what he was doing?
No.
Comment on it?
No.
Now, you were asked about Dr. Bandak, and we have a copy of his CV in evidence, right? Bandak. And I think you said you were familiar with him.
Yes.
Yeah. I'm sorry. Can you put up 276? You're aware that he was the program director to the National Transportation Biomechanics Research Center?
Yes.
Of the National Highway Traffic Safety Administration?
Yes.
And that's a serious position, isn't it?
Yes.
In your field, I mean.
Yes.
And for 9 years, he was the director of head injury research for that division. See that?
Yes.
And you have to be a serious scientist to do that, don't you?
Yes.
And do you see where he's now a senior science advisor to the Volpe National Transportation Systems Center.
I see that, yes.
And indeed is listed as a national expert by the Volpe National Transportation Systems Center.
I see that.
And that's a serious organization, is it not?
Yes.
And you're aware that he's, for example, also a professor of engineering and applied science as an adjunct at the School of Engineering and Applied Science at GWU, George Washington.
Yes.
That's a serious program and a serious position.
Yes, it is.
He got his PhD from Johns Hopkins, right?
That's what it says.
And assuming that's accurate, that's certainly a reasonably prestigious institution, maybe not quite at Duke's level, but in the same ballpark.
It's at Duke's level.
All right.
No, that is a prestigious institution.
All right. And you see where, for example, he's an editor or associate editor of International Journal of Crashworthiness.
Yes, I see that.
Are you familiar with that journal?
Yes.
And he's been a guest editor at the Journal of Neurotrauma.
Who cares?
Right?
That's what it says, yes.
And you're familiar with that journal, are you not?
Yes, I am.
That's something you've got to be published in.
That's correct.
And that's something that's peer reviewed, right? That journal?
Yes, it is.
And just so the jury understands what serious peer review is. Serious peer review is where you as a professor write an article and it's submitted to a serious scholarly journal like the Journal of Neurotrauma or the Journal of Forensic Sciences, for example, or I guess there's a couple others we'll go over in a few minutes. And they send it out to people like you or Dr. Bandak or other serious scientists to review for its accuracy and the methodology and what's said there and that sort of thing, right?
Yes.
And folks like you, and I assume you've peer reviewed other people's articles from time to time.
I have. I've been on maybe 6 different editorial boards of journals.
Okay. And folks like you and Dr. Bandak review those articles, and sometimes they're good enough to be published, and sometimes they have to be reworked, and sometimes they're junk. Fair?
Yes.
And what that does is it assures a certain level of quality and reliability to the research and the writing. Fair?
That's the aim of it. That's what we hope it does.
All right. And I noticed that, for example, Dr. Bandak, he's written book chapters. I think the prosecutor had a copy, but I don't know if you're familiar with it. But he's also edited a book called Traumatic Brain Injury, Bioscience, and Mechanics.
Yes.
Were you familiar with this book?
I think I have a paper or a chapter in that book.
All right. Well, then I guess you're probably familiar with it.
Yes.
All right. And I guess it's fair to say then that the people who contribute to this are all fairly distinguished in their field. Fair?
Yes, that came from a conference. That's where people were invited to present by, I believe, the National Highway Traffic Safety Administration.
And for example, and I'm not sure I could pronounce his name.
Ayub
Omaya.
Yes.
He's written some pretty heavy-duty articles on scalp injuries and brain trauma and that sort of thing. Has he not?
I've co-authored some with him.
He's a professor of neurosurgery, right?
I don't think he's, well, okay. He was then.
All right. In any event, this is a serious scholarly work, correct?
Yes.
And you're aware that Dr. Bandak has also contributed book chapters to various books published by Kluwer Academic Publishers, which is a serious publishing company for academics, correct?
Yes.
And Elsevier, am I pronouncing that right?
Yes.
That's another academic publishing company?
Yes.
And that he's published papers in things like the, let's just see, Journal of Neurotrauma, correct?
Yes.
Actually, a couple in Journal of Neurotrauma, right?
Yes, I think that's the two in this book.
Okay. And he's published in various other, let's see if I could find one here. International Journal of Impact Engineering. Is that one you're familiar with or not?
Doesn't ring a bell.
That one he published with Amaya, though, and Tebow.
Yeah, Larry Tebow, yes.
And they are serious scientists, are they not?
Yes, they are.
And you yourself have published in a number of those journals, have you not, those peer-reviewed journals?
Yes, I have.
Now, I think you said that you peer-reviewed for a number of journals in your field. Have you ever peer-reviewed an article by Sami Shabani?
Not that I recall.
Let me show you some of the, may I approach you? Can I have this mark, please? Exhibit 291 is his CV.
May I see that?
You get it?
You know, I'm going to object to this. This individual has not yet testified.
He's about to.
I'll object.
I'm sorry.
He's about to?
Oh, he's over with.
He's been arrested.
Now, first of all, he lists himself here as an international expert designated by the U.S. Departments of Labor and Justice. Have you ever heard of anyone who's an international expert in injury causation?
Well, I would say I am.
Well, I understand.
I could name some others.
But you haven't been designated that by.
But that's not what you said.
No, that's what I was asking. Whether you're aware of anyone being designated that.
I am not aware what that means. Department of Labor and Justice. You can ask him.
We will. And let me show you some of these publications here. Could you tell me if you see any that are in what you would consider to be a peer-reviewed journal in your field? I guess it's what, biomechanical engineering, or is that injury biomechanics?
Yes.
All right.
Say it a number of different ways.
All right. Why don't you take a quick look? And I tried to highlight the to be a peer-reviewed journal.
Well, the first 3, 4, 5, 6, 7. On this page, 7 of these are Oxford University Engineering Laboratory reports.
Right. Now that's
Oxford. I'm assuming it's the Oxford University.
Well, we'll find that out too.
But which of course is a very famous university. Yes. But I have no idea how they review such reports.
Okay.
So I couldn't answer that. Wait.
I'm sorry.
IRCOBE is an international conference. I wouldn't say that's peer reviewed.
Right.
It's a good conference.
Sure. Somebody goes, they present a paper.
Right. I've gone there and presented papers. They don't let anybody present papers.
Sure.
But and they do a review. Mm-hmm. But it's not at the journal peer review level.
Okay.
For our
fair enough.
So that's
okay.
The rest are all.
Yes, sir.
Naval Biodynamics Laboratory Report, New Orleans. But that's not peer reviewed in the sense that we're talking about.
Okay.
But I'm sure somebody for the Navy reviewed it.
Sure. Understand.
It looks like it was Al Hirsch. Okay, I know. Or Art Hirsch, I know him.
Mm-hmm.
And Nigel. But that's a report covering probably a contract with the Navy.
Right. Okay.
Another Ira Kobe.
See a lot of sort of papers that have been presented to meetings.
Yes.
And that's not peer reviewed, right? In the sense that you're talking about.
That's right. Some meetings are not reviewed at all, and some are reviewed by a group who's trying to maintain a certain standard.
Sure.
For example, Ira Kobe, I've been on the review committee for that, but it's not peer reviewed in the journal sense, which is attempts to be
scientific.
To keep the science Now, here's a medical journal.
Which one is that?
Well, I'm the baby. Why do I have anxiety?
228.
What's the name of the medical journal?
Well, maybe you could pronounce it.
Oh, Conmaw Medical Journal?
Conmaw.
Have you ever heard of that?
No, I haven't. Conmaw, okay. Memorial Hospital.
In other words, that's a journal from some hospital in Pennsylvania.
Temple University / Conmaw Memorial Hospital. That might be peer reviewed.
Don't know.
I couldn't say.
Certainly not a journal you've ever heard of.
That's right.
By the way, would you expect, if that was a real scientific journal, that if you did a search on Medline, you'd come up with that reference?
Well, Medline is going to have what's in the National Library of Medicine.
Okay.
So I don't know if
okay.
Here's American Physical Society bulletins. That is peer reviewed.
That's not a journal though. That's just a meeting. You see that? Oh, the bulletin.
American Physical Society.
And is it your understanding that the bulletin is a peer reviewed?
The bulletin is, yes, and it was published at pages 1189 to 1994.
Okay.
Well, that can't be right. No, okay, it's.
Excuse me, Dr.
I'm sorry. I am mumbling because I'm confused.
I'm sorry, well, I'm too close to you, so.
But certainly the American Physical Society is peer reviewed.
Okay.
Exactly what that is, I don't know.
All right.
Presented. That's presented.
Do you see anything in any, so far, have you seen anything other than the American Bulletin? I'm sorry, is it the Bulletin of the American Physical Society?
Yes.
That's a journal you've heard of, or at least a bulletin you've heard of.
Yes, it's a journal. It's called the Bulletin, but it's a journal.
Okay.
That's a prestigious journal.
Okay.
And here's another paper at the American Physical Society.
Is that a paper that was presented at the Physical Society?
Yes, but also published
in that bulletin.
Yes. This is the Proceedings of the American Academy of Forensic Sciences.
That's a paper presented to that meeting, is it not? That's not the Journal of Forensic Sciences, is it?
This is a paper presented at a meeting and also published in the Proceedings of the American Academy of Forensic Sciences, 6/20/2000.
Mm-hmm.
So that's
is that the same thing as the Journal of Forensic Science?
I don't know.
Okay. We'll find out.
This is a paper at the proceedings of the International Association of Forensic Sciences. I'm not familiar with that, so I couldn't say whether that's peer reviewed or not.
All right.
And here's another one at the American Physical Society.
Yes, sir.
Also presented at the American Physical Society meeting.
Yes, sir.
So that's peer reviewed or close to it.
All right. I'm sorry.
I'm only on 7 of 9 here.
Well, there's you're close to the end of the journal entries.
And another bulletin, American Physical Society, 2, 3. So he has about 5 there.
Okay.
And this is a paper in the announcer. I'm not sure what that is.
Well, I'm not sure what it is either. We'll find out.
But that is a paper.
No, I object to continued commentary by Mr. Rudolph about finding things out.
And another paper in the American Physical Society. So he has 6 there.
There's an objection.
So we're up to films now, so you don't need to worry about that.
Okay.
So the one journal, at least that you're familiar with, that you believe would have peer reviewed any of these, let's see, we've got 75 articles claimed in his resume. Is that right?
Yeah, I think he has 6 in that journal that
you would consider to be a peer.
Yes.
Okay. And the others are stuff you're just not familiar enough with to comment on.
That's right.
He talked in one of his cases about a major contribution. I just want to find out if you've heard about it.
I like Judge Hudson. I mean, he's personable and, he talks to the lawyers and the jury like, he's pleasant, I guess. But he doesn't control his courtroom well. They'll object to something and he'll sustain it and say, don't do it anymore. And then they'll still do it. And then he just lets it go like that. She just objected to him making comments. And he's not supposed to do that. And he knows he's not supposed to do that. Yet he's doing it anyway. And then the witness keeps talking and the judge just ignores. Like, did he even rule on that objection? I didn't hear him rule. I don't know what happened. And this has been the entire trial. Stuff like this has been happening. He just does not control his courtroom well at all.
May I approach, Your Honor?
Yes.
Yes. This is testimony from Stephen's case. Dr. Shabani's testimony in Stephen's case. May I approach?
Yeah, let me talk to the other person.
Oh, good.
Let me show you, if I could, a copy of a transcript from that Dr. Shabani testified from another case a while back. And he testified, I think one of the most important papers that I did a handful of years ago was entitled Benefits of Using Physics in Evaluation and Treatment of Trauma. And then he said that was a pretty important contribution that we made a number of years ago. Have you ever heard of that article?
I can't identify it from what it says here. It doesn't say.
Maybe listed in his CV here. Let me just take a quick look. Here it is. Benefits of using physics in the evaluation and treatment of trauma. Conmore Medical Journal, 1993. You see that?
Yes.
Is that, in your opinion, or have you ever heard of this article or that journal before?
Objection, ask and answer.
Overruled. No, I haven't.
Are you aware of any do you know if there are any basic principles of physics and science that Dr. Shabani just doesn't agree with? You ever heard about that at all?
Sustained.
That's all I have. Thank you, Doctor.
All right, you can come down.
Thank you, Your Honor.
Dr. Butts.
By fax this weekend, and then I told him earlier this morning that with respect to some information that was provided to the court intended to the jury last week, the defendant brought into court what they've described as a found blowpoke. With that, Candace Zamperini undertook to see whether she could locate the other blowpokes that she had given to friend and family members. She's been able to locate 2 of those, and they were sent to my office. I've indicated to the defendant that they're available for his inspection, and I wanted to inform the court of that to make sure that you were aware of it. So we do not intend to offer that into evidence at this point. So I'm letting them know that they're available, and if they can look at those and inspect them.
Sorry.
And I appreciate that. I didn't get the facts yesterday because I just didn't see it on the machine, but we'll take a look at it over the break today. Thank you.
All right. Or otherwise, counsel ready to proceed?
Yes.
All right, Mr. Smith.
For the record, sir, please state your name.
John D. Butts, B-U-T-T-S.
How are you employed?
I'm employed as a physician, a medical doctor, specializing in the field of forensic pathology. I am the chief medical examiner for the state of North Carolina.
If you would, please, Dr. Butts, take just a moment and describe to the jury what your educational background is as it relates to your field as a physician and as forensic pathologist here in North Carolina.
Yes, sir. I have an undergraduate degree in chemistry, which I obtained from Duke in 1968. I attended Duke Medical School, graduating in 1972 with my MD degree. I then had 3 years of training in the field of anatomic and clinical pathology, also at Duke, right here in Durham. Then I went to Chapel Hill and did a 1 year's fellowship in forensic pathology with the Office of the Chief Medical Examiner. And finished my postgraduate training with a year of clinical pathology, also at Chapel Hill at North Carolina Memorial Hospital, the UNC School of Medicine, Department of Pathology. So that was in 1977. And at that time, then I went on the staff of the Office of the Chief Medical Examiner as the deputy chief. And I served in that capacity until the end of November of 1986. Then spent 11 months as the acting chief. And then in beginning of November 87, I became the chief medical examiner, the capacity in which I currently serve.
And you hold board certifications?
Yes, I'm certified by the American Board of Pathology in anatomic, clinical, and forensic pathology, and I obtained that certification in 1977.
All right. Now, if you would please, Dr. Butts, would you describe to the jury whether you have published articles or papers related to the field that you've just described regarding forensic pathology?
Yes, I have published, been an author on a number of papers dealing with forensic pathology, with death investigation, and a lot of them in the field of epidemiology, looking at various types of deaths and defining their characteristics.
Now, have you held any teaching appointments as it relates to the field that you currently involved with?
I know, right?
With respect to your responsibilities as the chief medical examiner for the state of North Carolina, please describe those to the jury and exactly what your office is responsible for on a statewide basis.
Could you imagine if he was a proctologist?
Well, the Office of the Chief Medical Examiner is responsible for the oversight of our state's medical legal death investigation system. That is to say that there are certain deaths that occur in our state that require such an investigation. These are deaths that are believed to be due to trauma or violence, injury deaths, or deaths or instances where people die suddenly and unexpectedly, and there isn't a good reason known for why they should be dead, even though it may turn out that death is due to natural causes. We're charged by law with literally taking charge of bodies, conducting investigations, including autopsies when required, and ultimately making a ruling or determination as to both the cause of the death, that is what injury or illness might have led to the death, but also in terms of offering an opinion as to the manner of death, whether the death is natural, accident, suicide, or homicide.
All right. Now, with respect to your own personal experience, would you please describe to the jury how many autopsies you have personally conducted?
I've personally conducted over 5,000.
Do you have an estimate of how many autopsies you've been involved with in some manner beyond personally autopsying an individual to determine cause of death and manner of death?
It would be difficult to give a precise estimate. There are many, many thousands more. I review well over 1,000 additional cases a year that come through our office, and of course I'm consulted on, and then also at times supervise cases. So it's a large number more, but I couldn't give you an exact number.
Okay. Now, with respect to the responsibility to consult, well, let me back up. With respect to the organization that you're associated with, would you please describe to the jury exactly what relationship you have or that organization has to any law enforcement entity within the state of North Carolina?
Well, the Office of the Chief Medical Examiner is actually a section within the Division of Public Health, which is a part of the Department of Health and Human Services, and that's the organization that organizationally and functionally we are a part of. It has no connection with law enforcement or the courts, for that matter, at least as an organizational or formal basis.
All right. Now, with respect to the occasions that you have appeared in court in the state of North Carolina, how many times have you testified in the field of forensic pathology?
It'd be around 600.
Okay. At this point, we will tender Dr. Butts as an expert in the field of forensic pathology.
It's allowed.
Now, you had indicated, Dr. Butts, that you have not only conducted approximately 5,000 autopsies, but you've also conferred or consulted or reviewed many, many more. And with respect to those responsibilities, did you have the occasion to review the autopsy and findings as it related to Kathleen Peterson?
Yes, sir.
If you would, please describe to the jury how that process occurred and what happened during your conference in this matter.
Well, I've had occasion to review the findings many, many times since the actual moment of the examination. While I was not present at the time that Ms. Peterson's body was examined at our facility, my first involvement came on the Monday after that weekend in which she died, when at our morning conference, where all of the pathologists in my office meet the first thing, 8:30 on Monday morning, we discussed the cases that we've had over the weekend and kind of set our week, because who's going to be going to court, who's going to be there, what other cases we might be have coming in for the weekend. Again, we also discussed the cases over the weekend. So at that particular time, we did discuss the findings at the autopsy, and that was basically my first involvement in it.
Okay. If you would, please go ahead and describe to the jury what other involvement you've had as it relates to the autopsy of Kathleen Peterson.
I consulted with Dr. Radish as she was working on the case, preparing the report, and then I've looked at it several times since.
In particular, what have you looked at as it relates to this autopsy and these findings?
I've reviewed the photographs that were taken, the report that was prepared. I've looked at the microscopic slides. I've seen a few scene photographs.
All right. Now, with respect to the basic finding that Dr. Radish had in this case, she had indicated that the cause of death, in her opinion, was blunt force trauma of the head. With respect to that, do you hold that opinion as well, separate and apart from what she has testified to before this jury?
Yes, it's my opinion that that's what Ms. Peterson died from.
All right. And with respect to Dr. Radish's summary regarding the severe concussive injury of the brain, would you hold that opinion as well?
Yes, it would be my opinion that there was concussive injury to the brain in this instance. Yes, sir.
And would it be your opinion that blood loss from these deep scalp lacerations may have played a role in Kathleen Peterson's death as well?
Yes, sir. I think that's a reasonable interpretation.
Now, separate and apart from the opinions that Deborah Radish has indicated in this autopsy report, do you have an opinion as to the cause of death, that being blunt force trauma, as it relates to the number, severity, and location of the lacerations of Kathleen Peterson's injuries on her scalp?
Well, I have a separate opinion, but it agrees with Dr. Radish's opinion.
Would you please describe to the jury, if you would, what your thought process is about why you are in agreement with her opinions?
Well, I reviewed the findings. I've looked at the photographs. I've noted the location, the appearance of the injuries, the wounds that are present. And when I look at them in terms of my past experience in this area, the many cases I've been involved in, and my understanding of bodily mechanisms and how injuries are caused, I concur essentially with her findings that there is evidence of multiple blunt force impacts, blunt meaning that the head either struck a hard, firm, rather than a sharp, pointy surface, or was struck by a hard object, rather than, again, a sharp, pointy type of object. And that these are, that there are at least 7, in my opinion, impacts to the head that produce the lacerations or tears of the skin that are present. And that, again, they're of sufficient severity that they would have caused internal hemorrhage or damage. And in fact, it did cause some slight bleeding over the brain. And that ultimately that's the cause of her death.
Your Honor, may I approach the witness, please?
Yes.
Dr. Butts, let me show you what
I
we
would.
The Defendant's Exhibit 242, and ask you to look at that very quickly if you would, please.
Yes, sir.
Do you recognize that as the back of Miss Peterson's head?
Well, I recognize it as a depiction or an attempt to depict the back of her head.
All right. Now, it's been suggested to the jury, let me just hold this up, that these lacerations actually number 3. One being this, what that has been described as a complex of lacerations. This, what is described as a single laceration in the occipital area, and then this complex over on the right side of the back of the head as a single laceration.
I don't object to that characterization. I think it was impacts, not lacerations. I think there was a debate about how we define lacerations.
With respect to what is marked as...
He just objected, Harden.
Members of the jury, it's up to you to recall the evidence that has been presented. The state is putting forth contentions of what it believes the defendant's evidence has been. It's up to you to determine whether or not that is correct. Overruled.
Let me show you what's marked as State's Exhibit AKP5 and ask whether you can identify that, please.
Yes, sir, I can.
What is that?
It's one of the photographs that was taken at the time of the autopsy examination of Miss Peterson that depicts or illustrates the lacerations that were present on her head.
Your Honor, with your permission, could Dr. Butt step down and describe to the jury what he sees as separate lacerations and what's marked as State's Exhibit AKP5?
Yes, sir.
Dr. Butt, would you please do that, and he'll talk with the first set of drawers here and then with the second set down.
State's Exhibit AKP5, again, a photograph showing the back of Miss Peterson's head with the hair removed so that the scalp and the lacerations are visualized. In my opinion, shows evidence of 7 separate impact points. That is, where there were 7 forceful contacts between her head and a surface or an object. She was either struck or the head was struck against a hard surface. One on the right, 1 complex laceration more towards the top 2, another in more towards the middle 3, a long one over on the side, the left side, 4, a separate small one up near the top of that one, 5, and then 2 down near the base of the skull that are separate from each other, which would be 6 and 7. One, 2, 3, 4, 5, 6, 7.
Now, with respect to the various lacerations that are seen in this photograph, do you have an opinion with respect to them individually as to whether these were caused by striking a flat surface or some object striking the head?
I can't say for certain whether they were the result of the head striking a surface, not necessarily a flat surface, but a hard surface, or something hard striking the head. They could, in my opinion, be explained either way, depending on the nature of the surface that was struck or the nature of the object that she was struck with. But in my opinion, there are 7 impact sites delineated by those lacerations. There are also some additional bruises on the scalp that don't appear to entirely match those lacerations and could represent separate impact sites.
All right. Now, with respect to the other analysis that you conducted, I think you indicated that you looked at the slides that were produced.
Microscopic slides, yes, sir.
Yes, sir. And which slides were these actually of? I mean, which areas of the body were the slides actually taken from?
Well, I reviewed all the slides that were taken in the at the autopsy, which would be the organs, brain.
Okay. With respect to the lung area, did you look at slides of the lung area in particular?
Yes, there were a number of slides of the lung taken.
All right. Let me show you what is marked.
Still on the blood in the lung.
Yes. Let me show you what's marked in Defendant's Exhibit 246. And ask if you've seen this before.
Yes, sir.
Based on your experience and your knowledge and your training, what is depicted in this slide, this photograph of the slide?
There's a small air passage that is one out in the distribution of the air passages coming down from the nose and mouth, and within it there are some red blood cells as well as what appears to be mucus to me.
All right. Now, with respect to the testimony of Dr. Leetsma, he had indicated that in his opinion, this was evidence that Kathleen Peterson had aspirated blood into her airway, down into her lungs. Do you hold that opinion?
I would hold the opinion that it is possible that that's how it got there, but that there are other ways that it could have got there.
Okay. Now, with respect to the the blood that is shown in this actual slide, would that have been visible, or would you have had to see it from a microscopic perspective?
The quantity of blood that's visible in this microphotograph would be essentially invisible to the eye. That is to say, if it were present on a sheet of paper, you probably couldn't even see it.
Did you bring with you the slide that's represented in this microphotograph?
I couldn't hear that question, I'm sorry.
Did you bring with you the slide that is represented here in this microphotograph?
Yes, sir. I brought a glass slide from the autopsy. It is not the slide that this was taken from, but Dr. Leetsma was furnished a set of slides cut from the same blocks, and it is my opinion that the slide I brought is the one that was cut prior to this. It is a slide cut from that same block, so that it is very similar, if not completely identical, and I did bring the slide with me.
All right, let me see it, please. Dr. Bunch would mark this as State's Exhibit 229. Colonel, with your permission, can he step down and show the jury exactly how much blood is shown on this slide? Yes. Now, as you do that, Dr. Butts, how much tissue is represented? This is an actual piece of tissue, or a slide of an actual
This is a slide taken from a piece of the lung that was put into a block of wax.
All right. If you would please show the jury exactly how much blood we're talking about, period, in this section of the lung.
See, this is a piece of tissue that's about the size of your finger, and there are two little black dots on the slide, which actually represent little bits of ink that were put there to mark the tiny little blood, air passage that blood is in. And so we literally can barely see the actual opening, so the amount of blood there again is maybe about the head of a pin at the most. I actually brought along a magnifying glass, sort of see a little better out of it. But even with a magnifying glass, it's very difficult to just barely make out the opening of that air passage. So that's
very, very small amount of blood.
Thank you. Now, may we pass that along to the jury, please?
Yes.
Your Honor, we would move to introduce what's marked as State Exhibit 229.
It's allowed.
Now, Dr. Butts, you're aware that there was no blood found in the mouth or in the airway of Kathleen Peterson at all?
Yes, the pathologist performing the examination did not note or describe any blood down in the air passages or down visibly within the lung themselves or the major air passages in the lungs.
Based on that, then, this alone, is there any evidence whatsoever that Kathleen Peterson aspirated blood?
Objection, but we're also going to include the spatter on the wall and the testimony about the shape of that.
So,
In my opinion, no, there's no evidence of any significant aspiration of blood. When an individual aspirates blood, that is, actually takes it down in their lungs, it's visible grossly. With the eye, you can see it down in the air passages, typically, because an individual is bleeding either in the lungs themselves, to spew it out, or they're bleeding from somewhere up in the nasal cavity where the blood drips down, or in the mouth. Again, blood comes down, has to aspirate, get down into the lungs. A certain amount of it is going to go down deep into the lungs itself, and it will be visible. If you don't see anything there, it's not visible, then you really can't be aspirating, because, I mean, aspirate means to take down in.
Well, then let me ask the reverse side of the question. Is there any evidence whatsoever that Kathleen Peterson coughed up blood if there's no aspirated blood in her airway and lungs, in your opinion?
No, there's, though, again, the absence of blood down in the lungs and the air passages would indicate it unlikely that she could have coughed any blood. I mean, it's just very difficult to, if you are getting significant amounts of blood down into your air passages, for you to get all of it out. You're going to swallow a certain amount, and you almost always take a certain amount of it down into your lungs, and it's visible. It's very distinctive to the eye. And under the microscope, one can see the alveoli, little air sacs distended or filled with blood. You just wouldn't get one particular small air passages have a few blood cells in it, with the rest of the sections of the lungs being completely normal. No blood at all in those areas.
And that was the finding here?
Yes, this is the only section that showed any of this, and it was just, again, that one air passage.
And with respect to this section, do you have an opinion as to generally where in the lung this section was taken?
I don't know exactly where it was. It would be somewhere out towards the periphery.
All right.
It is towards the edge.
Are there other possible explanations for how these microscopic blood findings would have been located out in the periphery of the lung?
Yeah, there are other ways that blood can get into the airways.
Okay. But they wouldn't necessarily have anything to do with aspirated blood or coughing blood, would they?
They could come from aspirating gastric contents. Often in a terminal state, as the person is dying, they'll swallow or choke a little on their vomitus, and that can cause some bleeding. Also, during the process of performing the autopsy itself, as you cut through the organs, you break blood vessels. You can sort of, I use the term, butter a little of the blood into other parts. So there are a variety of possible ways it could have gotten in there.
So this could be artifact?
It's possible it could be artifact.
All right. Did you also look at other slides of the heart as well?
Yes, sir.
Excuse me, the lung as well?
Yes, I looked at the other slides.
With respect to those, did you formulate any opinions that Dr. Radish didn't express as it relates to things that you saw on those other slides?
I did see some things on the slides that are not contained in the autopsy report.
If you would, please describe to the jury what those were.
Well, when I looked through the lung slides, in addition to the absence of blood in the air passages or the air spaces, I did happen to see in several of the blood vessels within the lungs pieces of fatty tissue.
And what does that mean in your opinion?
That can be seen in instances of blunt force trauma where fatty tissues of the body are damaged or struck or broken, that sometimes this fat can get into the bloodstream and actually be carried to the lungs, and then it kind of plugs up or get filtered out in the blood vessels of the lungs.
With respect to the lacerations on the head, could that have occurred?
Yes, the scalp has fat underneath the skin here. There's a fatty cushion, and certainly forceful interaction here that tore up or disrupted that fat could lead to some of it getting into the bloodstream, and then it would make its way to the lungs.
All right. Did you make microphotographs of some of those slides that you looked at with respect to those fatty deposits in the lung system?
Yes, sir.
May I see those, please?
They will be happy to stipulate that those fatty deposits are there.
All right. May I see them, please? Folks, I'm just going to show you two of these. Let me show you what's marked. States Exhibit 230 and 231. Those are the micro slides of the section. Is that correct?
Yes, sir.
At this point, we move into evidence. What's marked as States Exhibit 230 and 231. So, just from your seat, if you would please take your pen and point out to the jury what you've been describing as the fat emboli in the blood system of the lung that you've sectioned.
In this photomicrograph, where I'm pointing to now is a small blood vessel that's plugged with a piece of fat. And the fat just shows it looks almost like a net or a sponge-like area. The actual fat itself comes out during the processing of the tissue, so it just shows as a clear space. And that was States Exhibit 230, and States Exhibit 231 is a different part of the lung. And similarly, there's a blood vessel that's plugged with a piece of fat.
Strike that. With respect to the other areas of the body that you looked at regarding Kathleen Peterson's death, did you look at the heart as well?
Yes, sir.
If you would, please describe to the jury what your findings were with respect to the pathology of her heart.
I didn't find any pathology in the heart. The heart was of normal size. It showed no significant narrowing of the coronary arteries, hardening of the arteries, or atherosclerosis. And I thought that the appearance under the microscope was within normal limits.
All right. Now, my approach witness, please.
Yes.
Let me show you what's marked as Defendant's Exhibit 247A, 247B, and 247C. Have you seen those before?
Yes, sir.
Based on what you see, what are they?
They're microphotographs of the heart.
And I think they indicate that there's a left ventricle of the heart that has what's described as a lesion. Another one that has left ventricle of the heart that indicates there's a lesion, and the left ventricle of the heart that indicates hypertrophy and fiber changes.
Yes.
Now, if you would please take each, and first of all, what's a lesion?
What is a lesion? A lesion is just generally something that's wrong, like a pimple would be a lesion, or a cut would be a lesion. It could be anything.
All right. And with respect to what's marked as States Exhibit D247C, if you would describe to the jury what you see there.
I see heart muscle. I see a blood vessel with red blood cells and white blood or inflammatory cells in them.
Do you see a lesion at all?
No, sir, that's normal. That's where the white blood cells and the red blood cells are supposed to be in the blood vessels.
And with respect to what's marked as State's Exhibit 247B, that's also marked on that defendant's exhibit as a lesion. What do you see?
I don't see a lesion. I see normal, what to me is normal anatomy.
And then with respect to what's marked as State's Exhibit, defendant's Exhibit 247A, that's indicated as, is it
Hypertrophy?
Yes, and fiber changes. Do you see those at all?
I don't see hypertrophy, no, sir.
Now, it was suggested that, I think by Dr. Leachma, that at least with what he saw here in these slides as it relates to the lesion and the fiber changes, that would, in his opinion, or could have caused fluctuation in Kathleen Peterson's blood pressure, such that it would have caused the ischemic event that caused the red neurons to develop in her brain. Do you see that at all based on your observations of these micrographic slides?
Object to that characterization of Dr. Leachman's testimony.
Members of the jury, this is a contention of the state. You are to regard it as that and recall yourselves what the evidence has been in this trial. So
I don't see anything in this slide that would suggest to me that there was anything the matter with Miss Peterson's heart prior to her trauma.
Right. And with respect to the development of red neurons in the brain, you're familiar with that concept, aren't you?
Yes, sir.
Based on your training and your experience, what does that mean to you?
Red neurons?
The development of red neurons in the brain, yes, sir.
Red neurons are described as being the result of ischemia, that is a failure of adequate oxygen to reach the brain so that the neurons undergo a degenerative break. They begin to break down to die.
All right. Now, with respect to someone's condition, what would their state have to be in order for the development of those red neurons to occur? What is the phenomenon going on in the body that causes that, in your opinion?
Well, again, it's what we call ischemia, or a failure of the brain of those particular cells to get adequate oxygen. That's usually the result of an inadequate blood supply. They're not pumping enough blood up there, or sometimes you're pumping enough blood, but there's not enough oxygen in the blood for whatever other reason.
Right. In your opinion, when the red neurons develop due to the lack of oxygen in the blood and to the brain, would the person have to be conscious or would they be unconscious?
For the oxygen supply to the brain to be reduced to the point that the neurons begin to die, an individual would have lost consciousness before that occurs, because if the neurons are dying, there's not enough oxygen getting to the brain for you to be conscious.
All right. Based on the observations you've made of the slides, the autopsy, the photographs, the multiple conferences you've had with doctors within your office and Dr. Radish, do you have an opinion as to whether the wounds sustained by Kathleen Peterson are consistent with a fall down the steps?
Yes, I have such an opinion.
Would you please describe to the jury what that opinion is?
No, in my opinion, the multitude of injuries are not consistent with a fall down steps.
Do you have an opinion as to whether the number, location, severity of the lacerations and other injuries to Ms. Peterson's body are consistent with a beating?
Yes.
What is that opinion?
In my opinion, the number and location and appearance of the wounds are consistent with inflicted trauma, that is, not accidental trauma, and beating would be one term that one could use.
Just a moment, please. No other questions of the witness at this time?
Cross-exam.
Judge, if I could have about a 5-minute
Oh my
recess, I may be able
God.
to shorten up what I was planning on doing and maybe get done by the end of the morning with Dr. Fudge.
10 minutes.
Ladies and gentlemen, we're going to take a 2-minute break. Please allow the jury to courtroom clerk.
All right, so
Yes, sir. Good morning, Dr. Butts.
sir.
You and I have known each other for a number of years now, correct?
In quite a while.
Yes. Let me start off asking a little bit about your office. Deborah Radish is someone, of course, who trained in your office, correct?
That's correct.
And she's worked in your office for a number of years, on and off, at least.
Yes, she initially trained in the office. She left, was in private practice briefly, and then came back full-time, then left to pursue some additional training, and then came back again.
And fair to say that her work is, since she's done all of her training and her experiences there, her work is in essence a reflection of your office and what she's learned there, as well as her own abilities.
Yes.
Now, you're aware that Dr. Radish's opinion is that the cause of death here was concussive injury to the brain.
My understanding that her opinion was that the cause of death was blunt force injuries to the brain. The mechanisms by which that occurred or how that caused death included concussive injuries and, of course, possibly also blood loss from the scalp lacerations.
All right. I take it what you're referring to when you say that is the very first page of the report of autopsy examination where it says cause of death, blunt force trauma of the head.
Yes, and certainly in part.
All right. In the last paragraph, she indicates, in my opinion, the cause of death in this case was due to severe concussive injury of the brain caused by multiple blunt force impacts. You see that?
Yes, sir.
And then the blood loss may have also played a role.
Yes, sir.
Now, with regard to concussive injury to the brain, generally what we're talking about there is some sort of DAI, diffuse axonal injury.
That's what's generally considered to be the result of concussions or forces transmitted through the brain.
And in this particular case, there was no gross or microscopic evidence of any DAI, correct?
No, sir.
And you're aware that Dr. Lietzner's opinion was that the cause of death here was loss of blood.
Entirely?
Yes, sir.
Well, that's a simplification, of course.
Well, sure. In other words, the loss of blood then has various ramifications throughout the body. But in other words, he did not believe that there was concussive injury to the brain as a cause of death. You aware of that?
He may have said that. I wouldn't agree with it.
I understand. And of course, loss of blood can cause ischemic changes in the brain.
Yes.
And there was physical evidence of ischemia.
Microscopic evidence of ischemia, yes.
And red neurons, as we've already talked about.
Yes.
Now, as I understand Dr. Radish's opinion, I guess your opinion as well, she concluded that the cause of the injuries, and I want to distinguish right now between cause of death or manner of death on the one hand and cause of injuries on the other. You with me on that?
I'll go along and see if I understood it right.
All right. I think what she said was that the cause of the injuries, the laceration, could not have been an accident involving the stairs at the Peterson house, that it was inconsistent with an accident in that stairway. Is that your understanding?
That was my understanding, yes, sir.
And what Dr. Radish relied upon, I believe, in forming the opinion as to the cause of the injuries, in other words, the cause of the lacerations, was the number, location, and severity of the lacerations. Is that your understanding?
Yes, sir, if I'm understanding you correctly.
All right. Now, and I think you said that, you're familiar with the book by Bernard Knight, correct?
Yes, sir. It's a forensic textbook.
And it's one that you've had in your office from time to time?
I had one once, but someone lifted it.
Not me.
No, mine was a older edition. I checked.
And are you familiar? Well, let me ask you this: would you agree with the following statement in Dr. Knight's book? A flat impact may cause a laceration, especially on the scalp. If the head falls to the ground or is hit by a wide, flat weapon, the skin and subcutaneous tissues are compressed on the anvil of the skull and may split sideways, often with a zone of surrounding bruising. Would you agree with that?
I wouldn't disagree with it, no, sir.
I'm sorry, did you say you would disagree with that?
No, I would not disagree with that, no, sir.
And would you agree with the following statement? Lacerations of the scalp bleed profusely, and dangerous and even fatal blood loss can occur from an extensive scalp injury if it is not checked by treatment.
That it's certainly possible to bleed to death from scalp lacerations, yes, sir.
Would you agree with this statement? It is vital for the pathologist to appreciate that falls to a flat surface or a blow from a wide flat object such as a plank or paving stone may sometimes leave no external mark whatsoever on the exterior of the head, but commonly such an injury will cause a ragged split which may be linear, stellate, or quite irregular. Agree with that?
Tell me what type of object again, how he described it?
He said either a fall on a flat surface or a blow from a wide flat object such as a plank or paving stone. And the relevant portion of that is commonly such an injury will cause a ragged split, which may be linear, stellate, or quite irregular.
There is some variability in how it will look, yes, sir.
And would you agree with the following statement? Such injuries on the back point of the head are commonly caused by falling, especially in inebriated victims. Falls backward against a ridge, such as a wall or pavement curve, may cause a transverse laceration, which may be undercut and partly detached from the underlying bone, so that a flap of scalp is loosened from the skull.
Yes, I've seen many instances of falls to the back of the head with a little transverse laceration, and you often get a little bit of scraping or bruising around it.
Now, I think you said that it was your opinion there were 7 impacts on the scalp.
I said that there were at least 7 points of impact, as delineated or marked by the separate splits in the skin.
All right, and would you agree that you could have 2 points of impact from a single fall?
If you were to fall on an object that had two projecting surfaces, yes, you conceivably could get 2 splits.
Or if you were to fall, for example, in a corner and hit your head on 2 different surfaces, you could get 2 splits from a single fall.
I've never heard of such a thing. I suppose it's theoretically possible.
All right. And are you aware that Dr. McElhaney, biomechanical engineer, I guess, called by the state, testified that in his opinion there could have been as few as 5 separate impacts?
I don't know what he testified to.
All right. You just disagree with Dr. McElhaney about that?
I would have to know the basis by which he decided that some of these could have represented simultaneous impacts.
All right. And let me show you. You know who Werner Spitz is?
Yes, sir.
You've met him?
Yes, sir.
He's written a book which is fairly widely, or at least edited a book, I should say, and written chapters in it, which is fairly widely used in your profession.
Yes, I still have my copy of that one.
Good. And this one's not it?
No, that's not it.
You're aware Dr. Spitz has consulted for the defendant in this case?
Yes, I met him in our autopsy suite.
Let me show you what's been introduced into evidence in defense of 1972. And just so we're all clear, it's not unusual for forensic pathologists, just like other professionals and experts, to sometimes disagree with one another about their professional opinions. True?
Yes, there are often differences of opinion.
All right. And have you seen Defendant's Exhibit 172 prior to just now?
I don't believe so, no, sir.
I want you to take a minute then to read it. Can we put that up on the board? It's already in evidence. And could you focus in on the fourth paragraph there? Have you had a chance to look at that?
Yes, sir.
And you see that Dr. Spitz looking at the same information. And by the way, you were not actually present at the autopsy, correct?
Of Ms. Peterson?
Yes.
No, sir.
So what you're relying upon are the photographs and the autopsy report and that sort of thing.
Yes, sir.
You've not been to the scene, have you?
No, physically, no, sir.
All right. And you see that Dr. Spitz went to the scene on October 22nd, 2002?
Yes, it says so.
All right. And with regard to the fourth paragraph, you see that it's his opinion that a total of 3 and possibly 4 such points of impact were identified.
I see. He says that. Yes, sir.
All right. And would it be fair to say that Dr. Spitz, as a former chief medical examiner in Detroit, probably has done at least 5,000 autopsies on his own?
I certainly wouldn't be surprised if he's done many thousands. I would expect he did many thousands.
Now, when you can take that down, thank you. When Dr. Radish formed her opinion, I think she said that she had not yet been to the scene in person, right?
No, I'm sorry?
Dr. Radish had not been to the scene in person when she formed her opinion in the autopsy report.
That's my understanding.
And is it further your understanding that she's still not been to the scene?
I don't believe anyone from my office has been to the scene except for Dr. Snell.
And of course, Dr. Snell initially had the opinion that it was a fall down the stairs.
That's what he initially put down, yes, sir.
And to your knowledge, are you aware, for example, that the police went back to the house in June of 2002 to take measurements?
I don't know all of the visits that have been made. I'm not aware of them.
To your knowledge, did anyone from the police department or the DA's office contact anyone from your office to say, hey, listen, we're going back to the house. If you'd like, if you'd like to actually see the scene, you can come with us on June 26, 2002.
They didn't talk to me, but that doesn't mean they didn't offer to somebody else. I'm not aware of it.
All right. And I think you said you looked at some scene photographs.
Yes, sir.
Do you remember what you saw in the scene photographs as you sit there now?
Yes, sir.
What do you recall seeing in the scene photographs?
I recall seeing Miss Peterson lying on the bottom rung or step or so of the stairs, her feet out into the hallway. There's splattered blood on various portions of the stairwell behind her. There's some sort of towel or fabric under her head. There's a roll of paper towels nearby. Okay. There's some blood on the front of her clothing. Just head's off to the side. Mouth is open.
Did you notice in that photograph that the bottom landing of that particular stairway ends in a wall?
Yes.
And do you know what that wall was made of?
No, I don't know for certain what it's made of.
If it was made of plaster, for example, as opposed to
drywall,
thank you very much. That would present a harder surface, would it
yes,
not?
Plaster is harder than drywall.
And did you happen to notice anything about the molding on the base of that landing?
I don't remember precisely what the molding looked like.
Did you happen to notice anything about the molding on the entranceway as you walk in to the stairway?
I remember there's some white painted molding as you go in on either side.
Anything about the shape of that that stuck in your mind?
I recall it looked like pretty much standard molding.
All right. Remember anything about some edges that come out from it?
Edges that come out from it. Well, I mean, it would have edges. It's molding.
I mean, edges from the middle of it. In other words, some things that were coming out from the middle of the molding. Ornate sort of molding.
I'm not sure what you're referring to.
All right. Did you notice the metal chair at the bottom?
Oh, you mean the lift chair?
Yes, sir.
Yes, sir.
And could you see anything about the angles or the edges of that chair from the photograph you saw?
You can see that it had some relatively sharp edges, yes, sir.
Anything, can you tell anything about how many or what they look like or how far out into the space the chair came?
No, you couldn't tell for sure.
And you're aware, you're not, that Dr. Radish testified before the grand jury in this case on December 20th of 2001.
I know that you testified before a grand jury, yes, sir.
That was before Christmas of 2001, you recall that?
I don't recall the dates.
Well, assuming that the indictment, which is in evidence, reflects that the grand jury returned its indictment on December 20th of 2001, which would have been, I guess, 11 days after Kathleen Peterson's death. It's true, is it not, that at that point...
Actually, that would have been a year before she died. January 2001.
No, December 20th, 2001.
December?
Yes, did I say January? I'm sorry.
Yes, you said January.
I'm sorry.
I'm sorry. Could you rephrase it? You confused me.
I'm sorry. She testified before the grand jury December 20th of 2001. If that's what the indictment reflects, that would have been just 11 days after Kathleen Peterson died, correct?
If that's the case, yes.
And assuming that to be the case, that would have been a couple of months before the final autopsy report was written, reviewed, and signed, correct?
Yes, sir.
And indeed, at that point, when she testified before the grand jury that returned the indictment in December of 2001, the final neuropathology report had not yet been typed and signed by Dr. Bolton, correct?
Yes, sir.
Now, you would agree, would you not, that it is important for scientists of all types not to go beyond their particular training or experience in rendering opinions in court?
That'd be true of anybody.
And to your knowledge, Deborah Radish has no training in biomechanical engineering?
I don't think she's ever taken any formal courses.
Or in injury biomechanics?
No formal courses.
And are you aware that, for example, she had no idea how much force would be needed to cause a scalp laceration without a skull fracture or serious brain injury?
You mean in terms of being able to say how many dynes or ergs or some unit of measurement?
Feet per second that the head would have to be moving or that an object would have to be moving, that sort of thing.
It wouldn't surprise me. I probably couldn't tell you either.
All right.
Well, and Emmy doesn't even
Indeed,
know
it
that.
would be fair to say, would it not, that most forensic pathologists, and I don't mean this in any way to
yes, you do.
minimize the importance of what you do, but for the most part, forensic pathologists would be generalists. Fair to say?
It's fair to say that we're generalists in terms of the diseases or conditions of the body because we have to figure out why people die from, and people die from all sorts of things.
Right.
We're specialists in terms of the effects of violence or trauma on the body.
Sure.
That is our particular area of expertise, in which we're expected to be familiar with what happens when people fall, when they're hit, when they're shot, when they're stabbed, and to recognize those injuries and extrapolate them back to the circumstances that led to them.
Right.
That's a normal part of our job. It's what we do, why we do it.
Indeed, you do autopsies in a very wide range of cases, fair?
That is correct.
Shootings,
Shootings,
stabbings,
Stabbings.
Beatings. Drownings. Poisonings. Arsons. And
falls. Is there an echo in here?
Yes, sir.
And Deborah Radish is not a specialist, to your knowledge, in any particular one of those areas, is she?
Well, it'd be a rare forensic pathologist who would specialize in falls or beatings or stabbings.
Right.
In fact, I don't know of any.
Exactly. And of course, your office doesn't do, and by your office, I'm talking about the medical examiner's office in Chapel Hill. Under your system, the medical examiner's office in Chapel Hill doesn't do an autopsy there in Chapel Hill in every case of a blunt trauma injury to the head, correct?
There would be certain instances where probably we would not do an autopsy. That's correct.
Indeed. You're aware that Deborah Radish looked at 29 fall cases and took some notes on those. You familiar with that?
Yes, she extracted from our records cases deaths that were related to fall to look at the types of injuries that were typical in falls.
Right. And in those cases, there were a number, I think she said half or more perhaps, that there hadn't been any autopsy done in Chapel Hill, right?
Yes, sir, I'm sure that was the case.
She was basing it on that initial report of the medical examiner done like Dr. Snell did initially, correct?
Yeah, some of the autopsies may have been done somewhere else. I don't know exactly how many of the cases were actually autopsied.
Now, another way to ask the question here is whether the injuries suffered by Kathleen Peterson are consistent with a beating. That's another way to ask the question. True?
It's certainly the question that we would ask when we look at injuries and what we asked when we looked at the injuries on Miss Peterson.
And it is true, is it not, that in cases involving beatings, blunt trauma injury to the head resulting in death, there are some injuries that you generally tend to see.
Yes, sir.
Fractured skull.
You can see fractured skulls.
Facial bones.
If blows are struck to the face, then you can see fractures or lacerations, bruises there.
Oftentimes there's broken ribs because the person is trying to hit somebody in the head and they miss.
Well, that would be presumptuous to say that if you have broken ribs, that it's because someone was swinging at their head and missed.
Well,
but yes, you often see other assorted injuries in a beating in addition to just head injuries.
All right. Fair to say that in a lot of the cases where there's head injuries, there are broken ribs.
In some of them. I don't know that. I would doubt that it was most of them.
Oh no.
How about epidural hemorrhage?
You can get epidural in some circumstances.
Subdural?
Relatively. Epis are not all that common, but we do see them.
Subdural?
Subdurals are relatively common.
Brain contusions?
Contusions.
Swelling of the brain after some period of time.
If a person survives for a while, then you can get swelling of the brain.
And of course, we know that Kathleen Peterson survived for some period of time here because of the formation of the red neurons, correct?
Yes, usually we see brain swelling in much longer survivals, many, many hours.
Now,
you get subarachnoid hemorrhage too.
Yes, sir. And the subarachnoid here was fairly mild, was it not?
There was subarachnoid hemorrhage, though.
Yes, sir. Fair to say, though, it was mild.
It wasn't as extreme as we sometimes see, but it was there.
Now, from the medical examiner's database, it's possible to request a list of all the beating cases involving blunt trauma to the head, is it not?
Yes, sir. You could get those cases listed.
And of course, I communicated with you about that a while back, did I not?
Yes, sir.
And initially, you weren't terribly thrilled at the prospect of having to dig those up, but we eventually found a way to do that, right?
Mr. Rudolph requested all of them. He wanted me to send him copies, and we ran the records, and there were 500 in some. Unfortunately, being a state-funded facility, don't really have the people to make 500 copies.
And eventually what we did was we figured out how many of those had actually been autopsied at Chapel Hill, and we sent somebody over to copy all those, right?
Yes, sir. Your staff came and made the copies.
And you actually performed and signed a number of those autopsies, did you not?
I would be surprised if I hadn't.
And are you aware, well, let me ask you this, would it seem about right to you that between 1991 and 2003, you personally would have signed off, and I know you observed others, but in terms of the ones you signed off, 47 cases involving blunt trauma to the head?
I wouldn't argue with it. Certainly, if you say so, that certainly sounds reasonable.
Mr. Rudolph, we probably ought to stop right here.
Oh, I'm sorry. Yes, sir.
Yeah, okay. All right, members of the jury, we'll take our lunch break at this time. Remember the instructions I've given you throughout the course of this trial, and we'll see you at 12:45. All right, Mr. Rudolph.
Thank you. Dr. Butts, before lunch, I think we were talking about the other way to ask the question, which was whether Kathleen Peterson's injuries were consistent with a beating. And we were talking a little bit about some of the cases that you've worked on personally among the cases that we had gathered from your office. Do you recall that?
You mentioned that, yes, sir.
Let me show you Defendant's Exhibit 249. It's already in evidence. And could you go to the next page? This is just so we're clear. What we ended up getting from your office was a list of 257 cases, in other words, the case numbers that we then got the autopsies. Is that correct?
Yes, sir.
Okay. And are you aware that out of those 257 cases, there were skull, facial, and other fractures in 215 of them? Keep going. Out of the other 42, there was traumatic brain injury, not including subarachnoid hemorrhage, in 34. And out of the other 8, none of them had multiple impacts. Are you aware of that?
You'll have to explain to me what some of these things mean because they're not immediately clear.
All right.
So these are blunt force. These were cases that were classified as homicide. Is that correct?
Yes, sir.
Okay.
These are all
Where
homicides.
the cause of death was listed as blunt force injury to the head.
Yes, sir.
Okay. So there were 42 instances where there were no
Skull, facial, rib,
any fractures whatsoever.
Any fractures.
Okay. And in of those 42 cases where there weren't fractures,
there was some sort of traumatic brain injury, meaning a subdural, an epidural, a brain contusion, something beyond a subarachnoid hemorrhage.
So there was some type of intracranial bleeding and or actual brain injury.
Yes, sir.
Because the two are not exactly the same.
Yes, sir.
Exclusive, however, of subarachnoid hemorrhage.
Yes, sir.
Okay.
And of course, you can get a subarachnoid from falling against a wall, right? I mean, subarachnoids can happen from a fairly mild amount of trauma.
You get a subdural from falling against the wall.
I understand.
As well as contusions.
I understand.
Now, of those 34 cases, 34 cases had definite.
Out of the 42,
injuries.
34.
There were 8 cases that didn't.
Correct.
And then now you say none of those involve multiple impacts. Is
Correct.
That what you're saying?
Yes.
Okay.
Are you aware of that?
I am now, I guess.
All right. Let's look at it a different way.
Oh, that's different.
If we go from the other direction, out of the 257 cases, 143 had multiple impacts. Right. Out of those 143, 133 had skull, facial, or other fractures. And out of the 10 that didn't, all had some sort of traumatic brain injury other than subarachnoid hemorrhage. That was the testimony of Dr. Lietzma based on the autopsy analysis. Were you aware of that?
Okay, now could you start at the beginning? Let me digest it, please.
Yes, sir. Same 257 cases.
Okay, of those with multiple impacts.
Yes, sir. Skull, facial, or rib, other kinds of fractures, 133 out of the 143.
Okay.
Out of the other 10 cases, all had some sort of traumatic brain injury other than subarachnoid hemorrhage.
What
okay.
food?
Were you aware of that before today?
No.
Now, you talked a little bit about Dr. Lietzman's testimony about the heart section. You can take that down now, thank you. And I think may I approach your honor?
Yes.
You did take a look at 247A, 247B, and 247C, correct?
Yes, sir.
And I think it was your opinion, in contrast to his, that these were within normal limits.
That's correct.
Did you notice Dr. Lietzman did explain to the jury some of the things he saw? For example, some what looked like interruptions to the vans there. You see that?
Yes, sir.
All right, and I don't remember exactly how he described it, but he saw some things that he felt were indicative of myocarditis in the other two photographs.
Yes, sir.
Okay.
That's what he said.
The bottom line is that you and he just disagree about that, correct?
I certainly don't see myocarditis in that slide. I see only normal as far as what he's describing in the other one. It's not an unusual finding in what I see there. I would see in a large number of sections of heart that I took from people dying of a variety of different causes. I don't see it as evidence of a pre-existing pathological condition.
You certainly recognize that Dr. Lietzman is someone who has, for example, written a book on forensic neuropathology.
About the brain, yes, sir.
Yes, sir. And obviously, brain neuropathology often involves problems with the heart, does it not?
Well, most often it involves problems with the brain, but yes, there are diseases of the heart that can cause conditions in the brain.
Yes. Now, do you have any particular training in neurology?
No, I'm not a neurologist.
Do you know anything about concussive convulsions?
Concussive convulsion?
Yes, sir.
You mean the idea that if you have a bloated head, you might have a convulsion?
Well, are you familiar with a phenomenon that is known in the medical literature as concussive convulsions?
I'm familiar with convulsions in general, and I'm certainly familiar with concussions. I'm not sure that I know exactly what you're referring to when you say concussive convulsion.
Well, you're familiar, for example, with, let me ask you the question. Are you familiar with the Journal of Academic Emergency Medicine?
Frankly, I haven't heard of it, but I won't dispute its existence.
All right. How about Sports Medicine Journal? Are you familiar with that?
I've heard of it.
Please mark this one.
You're supposed to stand.
Let me show you what's been marked now, Coach.
Yes.
294 and 295, and ask you to take a look at those two articles.
It appears I'm now more familiar with them.
All right. Apparently, there is a phenomenon, at least in the medical literature, that's called concussive convulsions.
Yes, these two articles describe the phenomenon.
All right.
Yeah, you get a concussion, you have a seizure.
What they
That's what that
basically
means.
say, and I realize
Why
I
are
haven't
you
had a chance to
making
fully
it sound
digest, and I'm
like-
not trying to cross-examine you on the details, but they basically say that someone who suffers a concussive injury to the brain, such as what Dr. Radish diagnosed in this case, or determined in this case, can, not will, but can on some occasions, I think it says something like 1 out of 70 is the statistic. And 1 out of 70 cases, they can go into seizure or convulsion for several minutes immediately after impact, correct?
Yes, studied primarily in athletic populations.
I'll make
it
you a
has an
Christopher
estimated
Robin,
incidence
Joe.
of 1 in 70 concussions.
All right. And I think in that same article, it talks about it as being similar to concussive syncope.
That's Prince Charming. I'm gonna have to put a.
That one.
Well, they sort of differentiating the two, if I understand this right. The syncopal reflex, which may be the basis of the syncope, which is the feigning or loss of consciousness that you see in a concussion, versus, of course, the subsequent seizure activity, which is what they're describing. So there's.
And a concussive syncope can be associated with cerebral global ischemia, can it not?
Well, they're implying that that's one of the theories as to why you have a seizure, because seizures, when people have this ischemic events, are very common. So a terminal event, and sometimes someone who had a heart attack or a variety of other insults, whereas a person dying with blood supply to the brain is cut off or diminished, and a seizure often results. And in fact, if you actually cut off the blood supply to the brain to the point that a person loses consciousness, there will often be a little seizure activity at that time.
And indeed, there was, in fact, ischemia, global ischemia in this case, was there not?
Well, there certainly was eventually.
And let me show you. Can you mark this, please? Are you familiar with a book called The Treatment of Epilepsy, Principles and Practice?
I'm not intimately familiar with it, no, sir.
All right. Well, let me ask you this. Are you familiar with a phenomenon described in the epilepsy literature as immediate or impact seizure? Seizure, a single generalized seizure occurring within seconds of a mild injury in an adult. Are you familiar with that literature at all?
I'm not particularly familiar with that, no, sir.
Let me ask you if you would agree with this. The immediate or primary insult after a head injury consists of diffuse axonal injury. That's what you were talking about before, right?
That's the theory is that when an individual suffers an impact, that there's a wave of force that travels through the brain, and if it's severe enough, it actually disrupts or tears the nerve cells.
And would you know anything about whether diffuse axonal injury as a process can contribute to the development of seizure activity, such as might occur from hypoxia or ischemia, as well as some other causes?
That sounds like would require a kind of a complicated answer. I mean, certainly if an individual suffers injury to the point that they become hypoxic, then of course they could have a seizure on that basis. Certainly over time, if there's diffuse axonal injury to the extent that there's then underlying brain injury, that's possible that could predispose to a seizure problem later on, should the individual survive the initial.
And of course, this thing is, well, let me just may I approach on? Yes. Showing you Defense Exhibit 296. Does it appear to be a chapter on post-traumatic epilepsy from the book Treatment of Epilepsy?
Yes, sir.
And do you see you're talking about immediate seizures as opposed to seizures that come on at some future time?
Yes, sir. I assume it's referring to the same phenomena as the concussive convulsion.
Yes. And that's not a phenomenon that you were at least intimately familiar with?
No, sir.
And to your knowledge, is there any way to determine post-mortem if Kathleen Peterson had a post-concussive seizure or a convulsion or an involuntary movement even when she was unconscious?
No, there'd be no way to know that in someone who was deceased, unless there was, witnesses to view them.
Now, the medical examiner's office did a toxicology report on Kathleen Peterson, did they not?
Yes, sir.
And you found a blood alcohol content of 0.07?
That's correct.
Which would be just a tenth below what is the legal limit for intoxication in terms of driving and things like that, correct?
Yes, sir.
This is yours.
And I noticed that the concentration was 1.1 in the urine. Is that right?
No, 0.11.
I'm sorry, 0.11.
Yes, sir.
And is that more than what was in the blood?
Well, it's a higher concentration, but the urine, at equilibrium, the urine will have a higher concentration.
Okay.
The ratio is somewhere around 1.25, 1.3, I believe.
Okay.
So that at the same time that you have a certain level in the blood, if you were to measure the urine being created at that moment, it'll be a bit higher than the blood by a factor of 20, 30%.
Okay, and
the
does
lab,
that
y'all. I
indicate
don't know what
anything at
happened to
all
her
about
body.
whether the blood alcohol content was peaking or coming down or at its top? Can you draw anything from the urine?
It would certainly be consistent with equilibrium.
All right. Now, you also found 0.15 milligrams of diazepam, correct?
Yes, sir.
Which is commonly known as Valium.
Aragorn.
And I think Dr. Radish indicated that that would indicate that she had taken somewhere between 5 and 15 milligrams at some point shortly before her death.
It would be consistent with a sort of an average dosage, yes, sir.
And you're aware of the potentiating effect between alcohol and Valium, are you not?
Yes, sir.
In essence, what happens is if you take Valium and alcohol, the sum is greater than either of the parts.
Yes, sir. It certainly can be the case.
And you also found evidence, did you not, that Kathleen Peterson had been taking 2 other prescription drugs on or about December 8th, 2001, correct?
Yes, traces of 2 other medications were found in the blood sample.
Well, let's talk about those 2 because I'm not sure we've had evidence about those before. There were some trace amounts of cyclobenzaprine, correct?
Yes, sir.
Which is commonly known as Flexeril.
Yes, sir.
And that's a muscle relaxant.
Yes, sir.
Indeed, there's a warning on that drug if you take it by itself that it may cause dizziness, correct?
Again, I'm not familiar with all the warnings, but I wouldn't doubt it.
You're a doctor and you don't know the side effects of medication? Even if you're an ME, you should still know side effects of medication, especially if it can contribute to someone's death.
You familiar with a website called Medscape from WebMD?
No, sir.
All right.
He's not familiar with WebMD. Okay, then. Darn it. I lost my hook again.
Let me show you. It's the only copy I have, so we have Courtroom. Yes, thank you. Let me show you what's now been marked Defendant Exhibit 297 and ask you whether it appears to be a printout from Medscape at WebMD with regard to drug information about cyclobenzaprine or Flexeril.
Yes, sir.
And does it indicate that among the side effects it may cause dizziness?
It's one of the side effects, yes, sir.
And when rising quickly from a sitting or lying position, dizziness or lightheadedness may occur.
I did,
That's
but
what it
his
says,
head
yes, sir.
popped off.
Change position slowly and use caution on stairs.
Yes, sir.
And it talks about interactions with other drugs, does it not?
It mentions interactions, yes, sir.
And says that you should tell your doctor before you take Flexeril with any of the following medications, and it lists things like tranquilizers, right?
Yes, sir.
And anti-allergy drugs, correct?
Oh,
Yes, sir.
that's
And it also says alcohol adds to the dizziness and drowsiness caused by cyclobenzaprine, correct?
That's what it says, yes, sir.
Limit alcohol intake.
Yes, sir.
The most frequent adverse effects of cyclobenzaprine are drowsiness, dry mouth, and dizziness, correct?
Yes, sir.
Do you disagree with any of that?
Well, again, those are standard warnings, and certainly all medicines have side effects. And I'm not that familiar with Flexeril, but I don't doubt that if they have them down there, that those have been reported as potential side effects.
And it says here not to take it with anti-allergy drugs. In fact, Kathleen Peterson had trace amounts of an anti-inflammatory drug, did she not?
An antihistamine.
Antihistamine, correct?
Chlorpheniramine is an antihistamine.
And on that one, the warning is that, again, it may cause dizziness. You familiar with that?
Yes.
And change from a seated or lying position slowly to avoid dizziness. Use caution in performing activities requiring alertness. You wouldn't disagree with that, would you?
No, sir.
Limit alcohol intake. You wouldn't disagree with that.
If it says to, then certainly wouldn't disagree with it.
Tell your doctor of all medications you may use, both prescription and non-prescription, especially muscle relaxants.
Yes, it says that.
And are you aware that chlorpheniramine, thank you very much, acts as a depressant on the central nervous system?
Flowers.
Yeah, the antihistamines can have that effect if you have enough of them.
Don't eat them.
Patients should also be warned to avoid consuming alcoholic beverages while taking antihistamines, since alcohol may potentiate these CNS or central nervous system effects.
And make you more drowsy.
And more dizzy. Patients already receiving other CNS depressants, e.g. tranquilizers, should be warned not to undertake self-medication with an antihistamine without first consulting their clinician. You wouldn't disagree with that, would you?
Sounds like good advice.
And all of those things that were on board at the time, the alcohol, the Valium,
Why are you looking at Grogu?
whatever trace amounts there were left of the antihistamine and the muscle relaxant would all have a potentiating effect with each other, correct?
They could.
That's all I have. Thank you, Doctor.
Redirect. Just a few
Melissa.
Dr. Butts, in beating cases where deaths occur and the beating is localized to the scalp or head, do you always see epidural, subdural, subarachnoid hemorrhages?
In any particular case of head trauma, you're going to see a combination of things, and what you see is going to depend upon how much force was applied, where the blows were struck. For instance, a blow to the face, because of the bony structure there, you're going to be more likely, given a certain amount of force, to get a fracture there than you would here. But every injury situation is an interaction between the person injured and whatever mechanisms are involved in causing the injury, the nature of the object if they're struck by something, or the surface if they hit it. Each of those plays a factor in determining how much injury you're going to have. So you can't say you're going to have to see something in every case. You're going to see a group of things, and it's going to just depend upon the factors involved and the nature of the individual, where they're struck, and then also their individual factors. Some people's bones are stronger and tougher than others, and for instance, elderly individuals have much more fragile bones, and they tend to have fractures when a younger individual would have no fractures.
Okay. So if I understand you correctly, then you don't necessarily have all or any or some combination of those in a beating cases. There are variables to that. Is that fair?
Every case is individual. Again, it's going to depend on the nature of the interactions and to some extent the fitness or conditions related to the individual that is injured.
Because you don't have an epidural, subdural, subarachnoid hemorrhage or brain contusion, can you necessarily conclude that automatically the cause of death, whether scalp lacerations, is due to a fall?
I'm sorry, I don't know.
If you don't have those things, can you automatically say that because they are not present, this is a fall?
No, you're in the same situation with the fall as you are with the beating. if you're going to say that someone dies as a result of head injuries, then you have to have a mechanism by which those injuries cause death. It doesn't make a difference whether you're smacked with something or you fall and hit something. If that's going to lead to your death, it's going to have to do something to the vital organ that we know as the brain to lead to the death. It doesn't make a difference as to whether it's a fall, motor vehicle wreck, or beating. There still has to be a mechanism by which it occurs. And certainly in the case when we looked at Ms. Peterson initially, that was the issue that we were confronting. We had the injuries. We knew that she had been injured. We knew that there were multiple sites of impact, but we had relatively minor internal brain injuries, and that is just some subarachnoid hemorrhage. And then that leads you to the point, well, how did these injuries then cause her death? But that has no direct bearing on whether she was beaten or whether these injuries were incurred in a fall. It's the external evidence of injury that we felt ruled out fall and put us in the category of inflicted trauma, in this case beating.
All right. And with respect to your opinion that Ms. Peterson's death was due to concussive brain injury, the absence of an epidural, subdural, subarachnoid hemorrhage, or brain contusion doesn't necessarily cause you, well, just because you don't have those things, you ought.
He doesn't know how to word the question.
If you don't have those things, you can still have concussive brain injury, even though you don't have any other external injuries to the head or to the brain. Or to let me back up. With respect to concussive brain injury, you've indicated that you have the opinion that that was the cause of her death, right?
Certainly, in my opinion, yes, it's an important factor in her death.
Okay. We obviously don't have an epidural, subdural.
I thought she didn't have any brain damage.
There is some slight subarachnoid hemorrhage. In concussive injuries in others that you have seen that died, do you necessarily have to have any of those other injuries to have concussive brain injury and cause its death?
No, you don't, and I should explain that when we have a subdural hemorrhage or an epidural hemorrhage, we have an expanding mass of blood inside the closed cranial vault, and it actually pushes on the brain, and there that the mechanism of death isn't necessarily concussive. There it's actually a pressure effect on the brain itself. It's forcing it down. But we certainly see instances where people are struck and fall over dead and have no external injury, let alone an internal injury, what we often refer to or is referred to as commotio cerebri, or commotion of the brain.
Okay.
And that's believed to be a purely concussive kind of effect.
Now, with respect to your specific experience as it relates to deaths caused by falls, in all of your experience, and it looks like you've been working for the medical examiner's office for nearly 28 years, have you ever seen more than 2 lacerations to the scalp where there was death due to reported fall?
I've never seen a minor fall, and I would say by minor fall, falling down from standing or falling down a few steps, where there have been multiple lacerations. I've seen certainly cases where there were more than one laceration, people that have fallen, off of roofs or off of ladders on the side of a building, or greater falls. And I certainly see lacerations where a person falls and the skull is broken, and the broken bone actually tears the skin, so you see more than one laceration. But I don't ever recall an instance where I had someone who had what I would call a more of a simple fall, where there were multiple lacerations, certainly never to the extent that is visible in Ms. Peterson.
With respect to the fall cases that you actually have had, what are some of the other types of injuries, or what are the types of injuries that you've seen? And specifically those that relate to falls and staircases, if you recall.
Overall.
I recall a few, other broken bones, and people can break their arms. They can fracture clavicles. We had a few broken necks, and of course, we also see other things like occasionally cracked skulls and facial contusions, bruises, scrapes. You can get a whole variety of different injuries.
Now,
you just don't get lots and lots of lacerations across the back and top of the head, in my experience.
Continue to fight this fire. Decoy Road is open and Highway 17 is open. The
No,
North
go back
Main
to the
Street fire
map.
in Gainesville remains at 106 acres with 25% containment.
Please stay alert. Observe all burn bans, keep vehicles off open
I
grass,
live
and dispose of cigarettes properly.
right.
This is the Florida Public Radio Emergency Network with an update on the wildfires across the state of Florida.
Quit moving.
You can track the latest fires by downloading the free
I live
Florida
right in,
Storms mobile
every
app.
time I get it,
Dry
they
weather
move the
and
map.
low humidity have made conditions more favorable for the spread of wildfires across inland Florida, particularly north central and central Florida. There are more than 100
486-5155 or
25% containment.
Please stay alert. Burn bans, keep vehicles off open grass.
Avoid boating.
Okay. I live right in here. Can you guys see my cursor? Yeah. I'm just west of Gainesville. Look at, no wonder there's smoke all over the place. Look at all that red. So the whole state's on fire. Or no, that's drought. I don't know, because I paused it at a weird spot. That's drought. Okay. Where's fire? Air quality. Oh, that's south. Humidity. Oh, I don't care about humidity. Where's the fire? Oh, good gravy, Murray. Alachua County is Gainesville. I live in Gilchrist, which is the next county over. Fire risk. Fire risk, but it's all gray. That doesn't make any sense. I'm in this gray area right here. Does that mean I'm good? I don't know. Oh, the whole state's in a watch. Great. So there's fires. So that's Alachua. Wait a minute. That must be Levy. So maybe that's where I live. And that's Dixie. I live in the Tri-County area. There's a road in Dixie County. Half of the road, one side of the road is Levy County, and the other side of the road is Gilchrist County. And then when you cross the bridge, you're in Dixie County. So there's 3 counties touching, and then Gainesville touches Gilchrist on the other side. So I'm right in here. Uh-oh, did I forget to pause? I forgot to pause. Sorry. I guess I just muted it.
More solid than this had been used to beat Kathleen Peterson over the head, she likely would have had skull fractures and brain injury.
I don't know what she testified to in that regard.
You would disagree with that statement, would you?
I would say that no, one couldn't say that it's astonishing sometimes what some people's heads will sustain without fracture.
But it hasn't happened in your office in the last 12 years, has it? Based on the statistics that we put forward.
Well, you didn't compare your statistics, each blow, for instance, with an underlying fracture. I mean, a person can be struck 20 or 30 times on the head, and you get multiple lacerations. It's not always a fracture under each one of those.
That's all I have. Thank you, Doctor.
All right, so you can come down.
You want to make Dr. Bester release, please?
Yes.
Oh, yay.
State
Detective
and the
Holland's
defendant
back.
are going to be allowed to publish the evidence to the jury so that they can have one final opportunity to look at it. Tomorrow, the state is going to, at this point, arrest its rebuttal case, but would reserve the right to publish the state's exhibits to the jury as soon as the defendant completes his rebuttal.
That's
all right, is there further evidence from the defendant?
Yes, sir, Your Honor.
All right, you can call your witness.
We call it Holland consent.
He's up. The witness continues to be on oath.
Detective Holland, after the last time you testified, which was during our case, I guess you then were called as a rebuttal witness by Mr. Harden, correct?
I believe that's correct.
After that, you produced to us through Mr. Harden a number of notes and reports that had been prepared from, I think, June of 2002 up to the present, correct?
That's correct.
And included in that material was a report related to a statement made by Candace Zamperini, correct?
It's very possible.
All right. Let me try to refresh your recollection. You remember that crime scene technician George and crime scene technician Campen testified about not spraying any luminol on that north wall a number of weeks ago, like towards the beginning of the trial. Remember that?
That's true.
And then Agent Deaver was cross-examined about that north wall and whether any luminol was sprayed on that and how those drips got on there around the middle, towards the end of middle to end of August, right?
That's correct.
And did you not provide to us last week a report that you prepared on August the 29th of this year relating to
a statement made by Candace Zamperini.
That's correct.
Now, you recall Ms. Zamperini testified that she had sprayed some cleaner on that wall. Remember that?
Yes, sir.
And let me show you what's marked as Defendant's Exhibit 299.
Yes.
Showing you Defendant's Exhibit 299, is that a report that you prepared on August the 29th, 2003, just about a month ago?
That's correct.
And does that relate to the topic that we've been talking about right here?
That's correct.
And is it correct that what that report indicates is that on August 28th of 2003, that you were informed by Mr. Harden that Candace Zamperini had told him the day before, in other words, on August 27th, that she had attempted to clean the north wall after the police released the house back to Mike Peterson, and that she sprayed something on the wall and that she cleaned, blood ran down her arm?
That's correct.
And that was the very first time, to your knowledge, that Ms. Zamperini ever reported spraying anything on that wall, right?
That's correct.
And that would have been weeks after the jury saw those drips in those pictures, correct?
I don't know how many weeks, but
some period.
A couple, maybe.
Now, it's also true, is it not, that in your handwritten notes, you have a couple of notes about the search that was done in June of 2002, correct?
There should be. I would assume so, yes.
And is it not a fact that those notes indicate that the total time spent in the bomb shelter in the basement in June of 2002 was 10 minutes?
I would have to take a look at my notes, sir.
May I approach you?
Yes.
Sorry.
Well, it has it.
2305, it indicates that you gave me a copy of the inventory, correct?
That's correct.
And then it indicates 2315, that'd be 11:15 p.m. Bomb shelter and basement.
That's correct.
And you recall that at about 11:15 that night or 11:05 that night, I had asked you whether or not at least the kids could get back in the house, and you said yes, but that you still needed to search the basement and the bomb shelter. Do you recall that?
To basically go through there with our technicians.
Yes.
So at that point, that's when everybody, along with myself and the technicians, went through. I mean, I had been down there previously, but not with the technicians with the cameras and videos.
Now, you were present at the SBI when Agent Deaver conducted his experiments on those steps, correct?
Yes, sir.
And do you remember me asking him why he didn't actually use blowpoke?
Objection.
Overruled.
I honestly cannot recall.
Okay, that's fair. Well, let me ask you this. You did bring this blow poke with you to the FBI on September 12, 2002, the day that Deaver did the experiments, did you not?
I believe that's correct.
And do you know why he didn't use this if he had it there?
Objection. Let me answer if he knows.
If you know.
I have no idea.
When Mr. Hardin called you back on rebuttal, he showed you this blow poke that was found in Mr. Peterson's home. You remember that?
That's correct.
And he asked you to compare it in State's Exhibit 72.
Correct.
And I think he asked you something about, well, how long would it take to do DNA testing to see if Kathleen Peterson had blown into this? Remember that?
Yes, sir.
And you said 6 months. Correct?
Well, I didn't say 6 months. I think Mr. Hardin made reference to taking that long at the State Bureau of Investigation.
You're right. He said, and would it take 6 months to get that done at the State Bureau of Investigation? And you said yes.
I agreed with him. Yes, sir.
All right. And remember I made a reference to LabCorp on my questioning?
Yes, sir.
Now, at that point, I didn't actually have your notes about what was done at LabCorp, did I?
No, I don't think so.
And what was actually done at LabCorp was some DNA testing, correct?
That's correct.
What happened was Margaret Ratliff, Mr. Peterson's daughter.
Objection. Robinson.
Overruled. Had sent a letter to Mr. Hardin about the exhumation of her mother, correct?
That's correct. No, the letter was not in reference to the exhumation.
What was the letter in reference to?
The letter was in reference to Margaret requesting that the district attorney's office pay late fees to Blockbuster Video.
All right.
What?
And you actually took that letter and
What?
brought it to
I have a
LabCorp,
question.
to get DNA off what the stamp or the right?
That's correct.
And that was to try to determine if Margaret Ratliff was the biological daughter of Mike Peterson, right?
Correct.
To try to establish a motive for why on earth Mike Peterson would have had anything to do with the death of Elizabeth Ratliff, correct?
It's possible, yes.
And you gave that to LabCorp on June the 5th of this year, correct?
If that's what my notes say, yes, sir.
Approach. Yes, sir. Show me Defense Exhibit 300. Is this a copy of your report written on, looks like it's written on June 24th of 2003 regarding the DNA testing that was done with regard to Margaret Ratliff?
Yes, it is.
And move 300 into evidence, Your Honor.
Hello.
And does it indicate that the envelope from Margaret Ratliff was given to LabCorp on June the 5th, 2003?
That's correct.
And Margaret Ratliff was excluded as being the daughter of Michael Peterson, was she not?
That's correct.
He raised her because he had agreed to do it, not because she was his biological daughter. That's what you found out, right?
Objection.
Sustain.
And sir, it didn't take 6 months to get those results, did it?
Not with LabCorp, no, sir.
It took 8 days, right?
That's correct.
And that's how long it would have taken, is it not, if you had wanted to see if Kathleen Peterson's DNA was inside that book, correct?
It's possible.
Now, you heard Ms. Zamparini move a 299 in evidence as well, Your Honor, and 298.
So,
Now, You heard Ms. Zamperini testify that she gave, I think, 3 or 4 of these to various people back in 1986, correct?
That's correct.
She liked the one she'd gotten the year before, and she then ordered 3 or 4 for gifts, right?
That's correct.
And after we discovered 288, Ms. Zamperini asked those other people to send to the district attorney's office the blowpokes that she had sent them at the same time she had sent the one to Kathleen.
Your Honor, I'm going to object to him saying that they discovered that blood poke. There's been absolutely no evidence as to when it was discovered and by whom.
All right, Mr. Deputy,
I'll rephrase it.
Well, I have to address another issue. If you take the jury to the deliberation of this room.
Issue as it relates to this witness being able to talk about and then have these blowpokes moved and entered into evidence through him. We won't object to a stipulation. If they want to prepare a stipulation and make sure we're comfortable with the language and have that done first thing in the morning, we're happy to do that. Otherwise, we don't think there's a foundation for those blowpokes coming into this witness at this point.
Judge, first of all, if this witness hasn't done anything to follow up on getting these blowpokes after Ms. Zamperini had them sent by other people, if he's done nothing to authenticate them, to do anything to establish that, in fact, they are exactly the same as the one that Mr. Peterson had, then that's relevant to go to the investigation and bias in the investigation. In addition to that, Rule 901 doesn't set forth any absolute requirements. It says the requirement of authentication as a condition precedent to admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims. Now, the evidence of that, of course, is Mr. Hardin's own statement here in open court on the record that these 2 blowpokes, which have been put, I mean, State's exhibit labels are on them. There's State's Exhibit A and State's Exhibit B. They had those when we got them from Miss Black not an hour ago. And to say that somehow Mr. Hardin's own admission on the record that he got these as a result of Ms. Zamperini having the people who got them from her in 1986 send them is not sufficient authentication for the court to allow it in under 901 is just incomprehensible to me. Moreover, under 901 B,
who's the proponent?
I'm the proponent.
Proponent?
Yes, sir. I'm moving these into evidence, and the authentication is the statement that Mr. Hardin, who is a party opponent representing the state in this case, an admission by a party opponent, that these are in fact the blowpokes that Ms. Zamperini had sent to his office for comparison purposes. Moreover, under 901 B3, they can be authenticated simply based on Ms. Zamperini's testimony that the blowpokes she sent to various people were all the same, and comparing these with the others and seeing they're the same. Moreover, I mean, to the extent he says, well, we'll enter into a stipulation about it, he's conceding that these are in fact what we say they are. There's no doubt that they're authentic. The only question is whether we can cross-examine Mr. Holland about the fact that he did nothing to follow up on this. And I think that that's perfectly appropriate cross-examination. So we'd ask to be allowed to introduce these into evidence through Mr. Holland, who either did or did not do anything to authenticate them himself.
Well, you know, I've heard numerous people who apparently have not read the rules of evidence that you've read that indicate to the court that numerous pieces of evidence have come into this case without authentication.
Well, the rule says what it says.
Yeah, the rule does say what it said. Ms. Hardin. I wish we heard further. All right. Objections overruled. Okay. Where are we now? We're ready? We're ready. All right. Yes. All right. Questions?
Thank you. Yes, Detective Holland, I think I was asking you whether or not you recalled Ms. Zamperini testifying that after she got what's been marked State's Exhibit 72 for herself, that the next year she had 3 or 4 other blow cloaks sent to various folks.
I don't know what the time frame difference was, but I was aware of that, yes.
All right. And you're aware, are you not, that after Defense Exhibit 280A was introduced into evidence, Ms. Zamperini contacted those other people to ask them to send their blow books that she had given to them at the same time she gave Kathleen this one to the district attorney's office for comparison purposes. You're aware of that, right?
I heard that was done, yes.
And you're aware that in fact occurred with at least 2 of the other blow books, correct?
There's 2 here.
And indeed, the state had actually put a State's Exhibit label on these 2, State's Exhibit A and B.
And that's to keep them from getting mixed up?
Yes, sir.
Yes.
And Mr. Harden informed me over the lunch break, or just before the lunch break, that the state had these, and he had sent me a fax about that over the weekend. You were here for that, right?
That's correct.
And you know that we went up over lunchtime to take a look at these, right?
That's correct.
Yeah. Did you actually remember when you compared Mr. Harden, I think, asked you to compare Defense Exhibit 280A with State's Exhibit 72. You remember that?
Yes, sir.
And you noticed certain differences, right?
That's correct.
For example, obvious difference, this one didn't have a tip, right?
That's correct.
And it also didn't have a place for screws.
That's correct.
And it also had a little bevel thing on the blow end, right?
Correct.
Any other differences that you can recall?
Later, that the inside of defendant's exhibit was threaded.
It's threaded, right, and this one is not.
That's correct.
All right. Now, have you had a chance, since the other 2, by the way, let's mark these as Defendant's Exhibit 301 and 302. Defendants 301 and 302 are the other 2 blow pokes that Ms. Zamperini had sent to the district attorney's office that we just got over lunch, correct?
That's correct.
And have you had a chance, sir, to compare Defendant's Exhibit 301 and 302 with Defendant's Exhibit 280A, the one that was found in Mr. Peterson's home?
I've only observed one of the 2 that was sent, not both of them.
All right, well, why don't you take a look at the 2 of them here? Good. And by the way, I think this one, does this screw off? Yeah, that screws off. I'm sorry. So that's a screw as opposed to there being a external screw like that one, right?
That's correct.
So I mean, if we were, well, never mind. Can you let's just take a look at these 2 appear to be the same, right? 301 and 302.
This one screws up.
Well, it was hard to do that. I didn't want to break it, but if you.
Well, I mean, from the end of the cylinder to the other end, yes, they're consistent.
Yes, sir. And it doesn't appear like this other one that has a tip on here has any outside screws, right?
It has no outside screws.
So it appears as though, although it's stuck and hard to get off, it appears as though it's threaded internally the same way as the other one was, right?
It kind of looks like it's been soldered.
Ah, okay. Like maybe it came off one time and then.
I don't know how.
Question?
What's this thing?
No.
Well, in any event, I think, could you, this is 280, correct? The one that was.
Yes, sir.
Found in Mr. Peterson's home, and this is 301, one of the ones that was sent.
Yes, sir.
Can you compare those 2 for the jury? They're the same height?
defendant's exhibit's a little taller, length's a little longer.
Have the bevel there?
Yes, sir.
Threads inside?
Yes, sir.
So can we agree that the missing blowpoke has been found?
Objection. Sustain.
We move 301 and 302 to that.
It's allowed.
Have permission to pass these to the jury?
It's allowed.
Yes, sir, now. Investigator Holland, you were asked about whether there was any discussion about testing the blowpoke that the defense brought forward. Do you remember that?
I was asking court.
Right. You were asked just a few minutes ago about whether there was why that blowpoke wasn't sent off for DNA testing. Is that correct?
That's correct.
And he brought to your attention that a letter that was sent off took 8 days. Is that right?
That's correct.
There was discussion about whether, amongst ourselves, about whether we should test that blowpoke.
No objection.
Was there not?
Black wants to get on the stand. I'll be happy.
Well, he did the very same thing.
Oh.
Objection.
Post against me.
That is like, I'm so done with this trial.
Were there discussions about whether to send the blowpoke off for further analysis to the SBI?
That's correct.
And was it sent off?
No, it wasn't.
Now, did you hear the testimony from the photographer that went over to the Peterson's house about a week ago?
Yes, ma'am.
May I approach the witness?
Yes.
Did you get a look at these defendants' exhibits 283?
I think he's already testified as a rebuttal witness after Mr. Rosenthal was on the stand. I didn't get into Mr. Rosenthal, so I'd object as being beyond the scope of the direct here.
Overruled.
Down in Watson.
Yes.
Look now at Defendant's Exhibit 283, State's Exhibits 232, 233, 234, 235, and 236. Look at those carefully, please. Right. Do you remember those photographs as being testified to by the photographer that went to the Peterson's home just about a week ago?
Yes, I do.
And you see the condition of that item, the blowpoke with the cobwebs, the dead bug, the dust.
Yes, I do.
Would you expect that an item like that, that's in that particular condition, would be a viable candidate to be tested? For instance, for fingerprints.
No, I wouldn't.
Would you expect an item that's found in that type of environment to be viable for testing?
It could be tested, but I don't think the results would be significant.
Now, you testified about the receipt of the other two blowpokes by our office.
That's correct.
Now, in conjunction with that, would it be worth the delay that it would take to test all these blowpokes together at the SBI at the tool mark analysis lab?
I'll object to that, Your Honor. Worth it to who and for what purpose?
Well, we've been sitting here since May 5th.
Well, since my client's life's at stake, I think the answer to that is yes.
Well, I think if he has an answer, then worth it to who would be his answer, Mr. Rudolph. So if
Object is vague.
If she wants to ask him that question, that's over.
Let me ask you this question. How many times did you search that basement at Peterson's home?
On what day?
How many times?
Total.
On whatever days, yes, the total times.
Well, I would say on the 9th and the 10th
of December.
2001. You know, maybe twice.
2 times on each of those days?
Object to leaving.
He called me his room.
There was a lot of time spent.
Exactly. It's wrong. You're witness
There was
right
a lot of
now.
time spent while the testing by Agent Deaver was being administered up and down, you know, the basement, upstairs, second floor. Same on the 10th. I mean, I can't give, you know, I didn't note every time I went down in that cellar, basement, garage, whatever you want to call it. On the 12th, we also, you know, I would say approximately twice going down in that area, and prior to leaving, I believe it's noted in my notes that each time we left the Peterson residence, a walkthrough was done of the house, and then of course on, I think it's June 27th
of last year.
You know, there was a lot of measurements being taken, a lot of photographs being taken, and again, the house was walked through. Prior to leaving, we went down out through the garage area when the family was let back into the house. So I mean, I would say a minimum thoroughly 5 times.
And when you say thoroughly, are you satisfied that you looked at every corner of the basement as best you could, or the garage?
As best I could, yes, ma'am.
And were there others with you that were doing the same thing?
Yes, ma'am.
About how many different people searched that particular garage or basement area?
I'd say approximately 4 to 5 people.
Are you satisfied based on your search as well as the search of other people?
Object to what he's satisfied about, Your Honor.
May I finish my question?
Finish your question.
Are you satisfied based on your search and the search of other people that Defendant's Exhibit 280A was not in the basement or the garage the last time you were there?
Object as to what he's satisfied about.
Overruled.
That poker was not in that basement.
And you're satisfied with that?
I'm satisfied, yes, ma'am.
Other questions, Mr. Reed?
Yes, sir. Of course, you recognize that ultimately the question is not whether you're satisfied, but whether the jury's satisfied, right?
Objection.
Did he say basement? I thought they were talking about the garage. I thought he said basement, though. It was found in the garage. Why would it be bent if it was used, Wiggles? Because regular fire pokers don't get bent. So why would it be bent? It would have to be able to stay straight if you're gonna blow through it, right? I don't know. I don't know much about fireplaces, even though we had them. Well, if he hit her with it, it would be bent. But not if you're just poking a fire with it. Oh, really? I missed that yesterday. I totally missed that yesterday. Yeah. It was found in the garage. So if he's thinking basement,
and it wasn't in the basement, then that makes sense because that's not where they found it. They found it in the garage. Oh, if he had hit her with it, it would be bent. Right. Yeah. So obviously that's not the murder weapon, but that doesn't mean that he didn't do it. See, that's the thing that's irritating me is that stupid blowpoke. But the jury still finds him guilty. But I feel like so much time was wasted on the supposed murder weapon. You know? Like, they've wasted a lot of time on this stupid blowpoke.
I take it he understands that, Mr. Reed.
Now, when defendant's 280A came in, it was in the plastic, right? Plastic tubing.
That's correct.
And at that point, did you call anyone at the SBI and ask them to come down and look at it?
Objection.
Do you want to be heard briefly?
Well, if you're going to overrule it, I'd like to ask the question to be heard. You haven't made your ruling yet.
I intend to overrule it, yes.
Well, then no, President.
All right. As I had indicated, it's overruled.
Ms. Black asked you whether or not it would have been worth testing this for DNA or anything else, given the condition it was in those photographs. You recall that?
I don't know exact terminology she used, but she asked.
No substance. By the way, do you know how you test something for DNA?
That's out of my realm, sir.
All right. Well, did you call anyone at the SBI lab, whose realm that is, to say, take a look at this, come over here, take a look at this blowpoke and tell me if we could test it for DNA?
No, I didn't.
You can come down.
With the exception of some exhibits that we may or may not have already introduced into evidence, we'd like to reserve the right to move in any that we haven't already moved in. The defense rests its rebuttal case.
All right.
I think that concludes our evidence, except for those.
All right, Mr. Deputy, take the jury to the deliberation room so we can talk about our schedule. All right, we've talked when we could at the bench about potential.
They had so many. So many. Because I think Candace got everybody that she'd bought one for to send it to them. So however many she bought for people, plus hers, plus the one they found in the garage, Michael Peterson ordered 2 more blowpokes during the trial. I don't know if he ever got them or if they ever came into the courtroom. I don't even know why he ordered them. It was just mentioned that he ordered them in the documentary, and I don't know why. I don't know what came of them. I don't know why there's so many ding-dang blowpokes. I have no idea. There's a lot. I think they said he had 5 fireplaces in that house. Well, 4 inside and 1 outside. And I don't know if the outside was like a fire pit. That's what I'm thinking for outside. I've never seen an actual fireplace outside. But he had 1 in his bedroom, 1 in his study, 1 in the kitchen, 1 in the living room, and then 1 outside. So yeah, 5. So yeah, it would make sense to have 1 by every fireplace. But after all this, would you be ordering them during the trial? I mean, I don't know. It's just weird. Oh, he had? Okay, maybe it was before the trial then. My bad. I thought he ordered 2 more during the trial. Maybe that was before the trial. Okay, I could be wrong. So 3. It could be. He could have had another one that never showed up that was the murder weapon that maybe they got rid of or something. But it doesn't matter, because I mean, you don't have to prove motive, and you don't necessarily, it helps to prove what the murder weapon was. Like if you're shot, you want to make sure, tie the murder weapon to the bullet, because you can check to see if a certain bullet came out of a certain gun. But in a beating death like this, all you have to do is prove they've been beaten with something. You don't necessarily have to have the exact murder weapon in a beating death. There's plenty of cases where they've never found the murder weapon and they've still gotten a conviction. I don't know. I don't know why I know why now Rudolph is so weird about the blowpoke is because they found the one in the garage. But why there's blowpokes all over this courtroom, I have no idea. Like, they're on the tables and there's several of them. It's like, why are there so many blowpokes in the courtroom? I don't know.
Schedules, you all want to talk about that now?
Yes, sir. And I know the state has asked for permission to publish the exhibits to the jury while they're sitting in the box. By my count, there are over 500 exhibits jointly in this trial so far. And I don't think if they're going to be passed some, we can pick and choose. They would have to be passed all of them. If each juror took even 1 minute each looking at each of those exhibits, we'd be literally here for days having the jurors look through those exhibits. They have taken extensive notes. Every exhibit, to my knowledge, has been published to them at the time that it was offered, if either party asked. The court was very liberal. The court never once that I can remember said, no, don't publish it now, publish it at the end of the case. Every single piece was published. It was shown to the jury. Then it was passed to the jury. They each individually had a chance to look at it. And it seems to me that the jury has had ample opportunity to look at all these exhibits, to make notes about them. I think every single juror is making notes. And moreover, we are perfectly content to consent that any exhibit that has been put into this case, if the jury wants to see it during the deliberations, that they be permitted to have it back there if the court wants to do that, or that they come out and look at it in court. I've done it both ways. Whatever the court wants to do about that is fine with me, but it strikes me as an incredible waste of time to have all of us sitting here for a couple of days at least, while jurors one by one look through all the evidence that they've already looked through without any context, without any discussion, without anything other than looking at it one more time. And so we'd object to that. We would not, however, object to the court making arrangements and informing the jury that anything that they wish to see during deliberations will be provided to them either in court or back in the jury room.
Well, it's not going to happen that way. Meaning that we're going to be here for days while they're looking through it. Now, I don't know what exactly Mr. Harden had in mind. I have tried other cases with him, and he has indicated that the jurors who wish to see some piece of evidence can go through there and see whatever they want to see. I don't think it was his intent to pass each item to the jury and let them look at it. Now, that might be a possibility. Maybe nobody wants to look at anything. They can just sit there. Mr. Harden, what did you have in mind?
Yes, sir. I think the state is entitled, before it rests its case.
Yeah, we know that, but what do you have in mind?
Well, what I have in mind is that it'd be kind of a blending of what has been done in the past, pass certain items to them, and what my thought would be is that the documentary evidence be passed to them, but all the other things, the photographs, make sure that we have all the boards squared away, put those out so that they can be displayed, have a table, have all of the items of clothing, things of that nature laid out on the table, allow the jurors that want to look at those again to come look at those at the table, but then pass the documentary evidence to them to the extent that they want to look at it, they look at it. If they don't, they pass it to the next juror. That would be my suggestion.
And just passing the documentary evidence. I mean, let's just think about that for a second. Passing each document, just passing it around the 16 people. Each document is going to take a minimum of a couple of minutes, even if they don't look at it at all, to pass around. If one person looks at it, then obviously the whole process stops while that one person looks at it. And in terms of the other exhibits, given the number of boards we have here, what are we going to do? Is it the state's boards get put up first on one day, and then our boards get put up a second day? Our photographs get offered, a second day or a third day, and their photographs get offered a different day. It's simply unnecessary and unwieldy. I have no problem if the court wants to ask the jurors if there's any piece of evidence they want to see, either before they start deliberating or after they start deliberating, that they be permitted to see that. I think they're entitled to that. But to go through this process, I think in this case, is simply a waste of time.
I've not counted how many pieces of evidence there are, how many exhibits there are, but if there are 500, how in the world will these people remember? Yes, I want to see specifically item 302. I think it needs to be laid out and displayed so that they can make a decision about what they want to see or not see. If they don't want to, they can sit in the box. If they want to come up and look at something, they ought to be entitled to do that. And quite frankly, the state's entitled to have them do that.
I think Mr. Rudolph was willing to work with you on that. I think he was somewhat questioning you passing out documents for them to read. I mean, you might make available the documents so that they can look at it if he wants to. But I thought I heard Mr. Rudolph say something that, of course, you all know it. Other people may not know it. In North Carolina, might be a real concession as far as documents already in the evidence. As you all know, if one party objects to the document going in the back room, then it doesn't go in the back room. And if Mr. Rudolph is conceding that if the jury wants to see a document and they can see it in the back room, that prevents us at some point in this trial from having to bring them back out here and go through the evidence out here. So that's a real concession. If Mr. Rudolph was making that concession, I'm not sure he was, but
I am, and indeed I would suggest that they get a list of exhibits. We have computer-generated lists, so that if any of them want to see anything, they'll see the description of it, and they can say, "Gee, we want to see the Kathleen's pants," and it'll go back there. I've got no problem with that.
I think we ought to do it a combination of both ways. I think, Mr. Harden, if you want to lay out all the exhibits out here, I think we ought to tell the jury if there's a specific item they wish to review. Now, we may have to identify it for them. And just ask them, is there some document? Let them discuss that. And if somebody who wants to see it can see it, I think we should tell them, if during the trial, if the defendant makes that concession, that all items that have been introduced in the evidence, they can view in the back room if they so desire.
Well, Your Honor, it's my understanding that if one party objects, the evidence doesn't go back into the room. And I would like to make that decision on an individual basis. I wouldn't like to just say carte blanche, anything can go back there for any purpose. I would like to look at it and evaluate it on an individual basis. So I don't intend to ask the court to do that. I'm not asking the court to do that.
I've never heard you make that objection in any case I've ever tried that we participated in.
Your Honor, this case has been absolutely a succession first. without question.
Okay.
I don't know why we should stop now.
I know why we should stop.
I was going to provide a few reasons, but
yeah, I actually want the first to stop. Actually, I don't think that you're going to get very many takers, Mr. Rudolph, going through lengthy documents that have already been introduced. I don't really think that's going to happen with these jurors. I kind of agree with the defendant. I think if there's something specific they want to see, they should ask for it. I don't think you're going to get what might be a nightmare for us if it happens, which is we're standing here watching people reading, which is... but I can't make either one of you concede on that point about it going in the back room.
Just so the record is clear, on behalf of Mr. Peterson, we are conceding and stipulating that any piece of evidence that the jury wants to see, whatever it is, whether it's a state exhibit or a defense exhibit, we would agree can go back to the jury room during their deliberations.
All right. Well, I think what we'll do, Mr. Harden, we'll tell the jury that all the exhibits are out here. If they desire to read or see an exhibit, they can do so. I really don't know. I agree with Mr. Rudolph. I really don't know how you're going to handle passing out documentary evidence. What had you planned on? How had you planned on doing that? Without them asking for the particular document by name or by some kind of reference, how were you going to make sure you were just going to pass them out?
How are they going to remember every document?
There's a whole lot of evidence in this case, is my point.
How are they going to remember?
You could do it, Judge. My suggestion still would be that we lay out the physical evidence, maybe put into groups or categories.
I got no problem with that. But when you say, well, go ahead, maybe I cut you off too short. What I'm really concerned about is documentary evidence, papers, reading, identifying them, and
for example, well, what my thought was is that with respect to various types of documents, we categorize them. For example, these are the SBI reports, these are the police reports, these are the notes, and lay them out so that they can see what all of this is. And then my thought was to pass it to them, but if the court's not going to do that, at least lay it out so they can find it fairly easily, and then if they choose to look at it, they'll have that opportunity.
Okay. Well, let's see how that works.
Just so I'm clear, though, we're not going to have jurors talking to each other before the deliberations start.
Well, no, I don't think they can talk to each other other than to say, will you pass me that document? I don't.
Right. So if they're milling around, sort of like a yard sale, how are we going to control if one of them starts saying to the other, well, look at this over here? I just don't understand how that gets
tell them
controlled.
not to do that. They're not kindergartner.
Well, most of the time, actually, they don't. So I've done it many times. They don't actually talk about it. I mean, I'll tell them
Rudolph,
not to talk about the substance of the documents. I mean, I'll tell them, if you want to see that document, you can tell your fellow juror, may I have that document when you finish or something like that. But they're not supposed to talk about the substance of the document. That is close to deliberation. And I'll just have to tell them that. And most of the time they don't. They don't discuss the particular item. I agree. You need to tell them that.
Can we discuss a schedule for closing arguments and jury instruction?
But I take it we're going to do that the first thing in the morning, Mr. Harden. All right, at 9:30. Yeah. And what else are we going to do?
Before we leave that, Kurt, because I know that you all have to check to make sure all your exhibits have been moved in, and we have a couple. Maybe we're probably not going to start that process at 9:30 in terms of the jurors actually will see things, and maybe they should come in at 10. So that we can get it set up and get all the exhibits, make sure they're in. If there's ones that aren't in, that they're not inadvertently given to the juror. I doubt we'd be actually showing the jurors anything before 10 o'clock, I guess.
That's fine. With respect to the schedule, can we talk about that in the morning? I need to make a couple of phone calls, and I think I'll be in a much better position to let the court know at least what the state's position is if we were to do that tomorrow morning as well.
I'm confused.
Well, we had to have some kind of idea of what the schedule is tomorrow.
Oh, for tomorrow?
I'm talking about tomorrow right now. Yeah, we have to know about the rest of the week too. Yes, we don't have to know that right now though, but we kind of have to know what tomorrow's schedule is. Well, we have to have some idea what tomorrow.
My thought would be that we publish the evidence to the jury, and then as soon as that is concluded, have a charge conference.
I don't know if that's what you are planning or not.
I don't think a charge conference will take that long.
All right.
And start closing usually the next day or the day after.
You know, at some point we're going to have to decide, for purposes of your jury arguments and the jury's deliberations, what kind of days we're going to have. And I think we have to tell, if we decide to go back to a regular schedule, we're of course going to have to tell the jurors before we get there. So I'm taking it tomorrow is going to be a regular day for us, not a long day, a regular short day. And then we will need to start giving them notice if you're thinking that during the deliberations they're going to go to 5 or later. So, okay, we don't have to make that decision today. Well, I guess we will have to take these one at a time, at least as far as tomorrow goes.
Very briefly, before the jury comes back in, just for the record, I assume at this point the state's, other than making sure that exhibits have been introduced, has introduced all of its evidence, and we would, for the record, renew our motion for judgment of non-suit now that all the evidence is closed to make sure that's covered.
Yeah, I didn't know if you were going to do that today or...
I just want to make sure it got done at an appropriate time.
All right. Are you making it now, or you say
Yes.
You're going to make it at some point?
I am making it. I'm renewing the motion for judgment of non-suit.
All right, then the motion in the court's discretion is denied. Anything else?
We will pass up at the end. Actually, I'll pass it up right now just to have it and give it to the state. And this is relevant to the charge conference tomorrow. And both the state we have a chance to read it. And then it has to do with other illustrations.
All right.
I'm sorry, it has to do with the submission of the lesser included offense. There's some law in there I wanted to give you the opportunity to read that before we discuss it tomorrow.
Right. And just so the record's clear, we are opposing any request by the state, if they make it, and I don't know if they're going to make it or not, that the jury be instructed on second degree or anything lesser than the first degree charge in the indictment.
All right. I'm sure we'll take it up later if you bring the jury out. All right, members of the jury, I'm going to send you on your overnight recess or call the instructions I've given you throughout the course of this trial. Now, counsel, let me make sure I understand exactly what you want to do. The jury's going to come back at 10, but we're going to be here at 9:30? Okay, we're going to be here at 9:30, but you will not have to appear until 10 o'clock tomorrow. So you report as you usually do at 10 o'clock. This time the jury is excused until 10 o'clock.
Maybe one thing we can do for a moment, we have a few exhibits that checking the clerk's list may have been introduced, may not have in terms of check marks, and just to clean that up, if I could move to introduce those, or we could do that at a later time, whatever suits your honor. If it's okay with Mr. Hart, I'll just indicate what the numbers are. The first group is exhibits 284 through 302, which were basically the most recently introduced, and with one exception is 285, which is these other set of tongs that we would not be moving to introduce. I think we've already moved 284 through 202, but to make sure those are all in, with the exception of 285, we've moved their introduction.
So allowed.
Okay. These other ones I think have been introduced, but they weren't checkmarked. So to make sure, Exhibit 102, which is a report by Gregory, we move it to admission. 103 was a court order about preserving notes. We move its submission.
Why don't we do this one? Why don't you move them? If you don't hear an objection, they come in.
Okay.
Let's make it
Exhibit 216, which is Amy Beth Berner's fire statement. Exhibit 236, which was a blow up from one of the books that was used. And then exhibits 255, 258, and 259.
All right. Does the state have any objection?
No, sir.
All right. They are allowed.
I need to address some of the housekeeping items as well. The first relates to item P235. Apparently there are two of those. Those are photographs. The one that is marked P235 is a photograph of the bedroom floor at the top of the stairwell. There's also another P235. I've marked that as P235A. That is a photograph of the top of the stairwell, which is Dwayne Deaver and Eric Campen depicted in the photograph. We'll ask the court to move each of those and allow the second 235 to actually be marked as 235A.
Any objection? It's allowed.
We have 34A and 34B. Those are packages for material from Kathleen Peterson's hair that appear not to have been entered into evidence. The items enclosed were, but apparently the packages themselves were not. We'd move 34A and 34B at this time.
No objection.
It's allowed.
What?
I believe item 144 was actually moved and entered. That's a search warrant that was on the 11th of December of 2001. And item 145, that is part 3 of Investigator Holland's supplement. I believe that is a note. We'd move items 144. Again, I think that one's already been moved in, but I want to make sure the record is clear on it. And we would also move 145 at this time.
I just take a quick look at those.
They're somewhere in this stack.
They're up for sale.
Are these in?
You know what else?
You know, the defense hadn't had much success in going through boxes.
Your Honor, with respect to 144, and we just enough so you can take a look at it. I think we previously objected. It may have been overruled. Just for record, I believe we had back objections, and now we're off. We wanted to do more objection on that.
Okay, hold on. I don't think we did that with Yeah, so that's my recollection.
Okay, just want to make sure we maintain our objection.
It's allowed. Mr. Harden.
Now, we would also move item 145.
Okay, hold up. Because Mr. Deputy, you got somebody else at the door, okay? Because he's going to have to stop those jurors if they come here.
Yes, sir, Your Honor.
As a matter of fact, they need to report to the jury pool.
Yes, sir, Your Honor.
If you can't find it, it could be in my lap.
All right, Mr. Harden.
It's fine. Just like a cup.
Okay, what is, Mr. Harden? What is?
It's item 145. We would move that that be.
And there's a reference in there to Ms. Sutton being outside, which we would move to strike that reference as it relates to an attorney. And I think most of those references have been struck throughout the exhibits. We may have missed that one when it was first offered.
The bottom of the page.
It's the next to last paragraph, I believe.
Okay, and you want to do what?
Move to redact that paragraph.
The state was to be heard as to that?
No, sir.
Okay. Well, you all have to figure out how to do that, but we'll do that.
Your Honor, we would move 161. That's the.
Hold on, Mr. He's talking about this.
I think I've already put it up on the table.
It's right here.
Just don't know how much of that, or just that paragraph.
Going about Miss Sutton.
Yeah, this paragraph. Yes, yes.
Yes, sir.
161, Your Honor, that was identified by Mr. Kimmer. It's this exemplar of a hard drive. We did not actually move that into evidence. We would at this time.
That's just the sample hard drive, not the.
Yeah.
They want to see hard drives.
All right, it's allowed.
Item 201 is a photograph of the east wall. We would move that at this time.
Okay.
It's allowed.
Item 70, which is apparently a sub-item of Kathleen Peterson's sweatpants and sweatshirt, which I believe are subsumed within another package.
Subsumed? What is subsumed mean?
We'd move that.
All right, it's allowed.
And item 75, which were some latent prints and photograph of, wine glasses.
I don't know what her deal is.
It's allowed.
And otherwise, I think that completes our housekeeping.
All right. Anything else, Mr. Maher? Anything else as to these?
Not as to exhibits. I do have a logistical issue that I want to raise at some point.
Okay, well, first of all, what is it exactly we're looking at? What is this? This is
some of the state's evidence, I believe.
Mm-hmm. Yes, sir. None of the defendants? Okay. All right, there's some issue you want to raise?
Well, as the court may have gathered, I'm not quite sure where we're going to put our evidence unless we pile it on top of the state's evidence, which I suspect they might have a problem with.
You think?
So, and I guess we could bring in another couple of tables, but then the jurors wouldn't have much room to move around. And when we set up the refreshments, I don't know where we do that. And it just seems to me that
There's refreshments involved?
while this might work okay in a trial without 500 plus exhibits, in a trial with this many exhibits, it's pretty unwieldy. And I'd again object. I think it's going to be, I don't even have a sense of what are the jurors going to come down from the box and walk around and, go through and pick up things, and somebody will be waiting in line, and, there'll be
saying, "Excuse me, I want to look at this thing," and
Take it
I
back
have
to
no
the
idea how it's going to be
room.
controlled. I have no idea where our exhibits are going to be, and I have certainly no idea how this can work in any reasonable way. It seems to me that the logical thing to do here is to tell the jurors that both sides, hopefully, have consented to anything they want going back to the jury room during their deliberations. Each side will have closing arguments. Mr. Hardin can point out what he thinks are the relevant exhibits. They're taking notes. He can refer to exhibit numbers. He can say, when you get back there in the jury room, I really urge you to take a look at Kathleen Peterson's past. It states exhibit number such and such. The judge has already told you or will tell you that you can have anything you want back there. And please take a look at that. He can put up a list if he wants with all the exhibit numbers that he thinks are important, and the jurors can take that down. But to have this all sort of laid out here like this, and I don't think this is even all the state's evidence at this point.
That's what you guys decided yesterday.
Unwieldy and impractical, and I just don't see how it's going to work. And so we object to this, and again renew our offer to consent to allow anything to go back to the jury room, and do it the way I've seen it done for 28 years in courtrooms all over the state.
Exactly.
Which is the jurors ask for something, it goes back there, they look at it during the deliberations, and they come to a decision.
For once, I agree with Rudolph.
It's not exactly the same issue. I agree with you that there are ways of dealing with the case once the jury starts deliberating. And normally it is that they ask for, but that's once they deliberate. I think Mr. Hart is talking about a different issue, and that is publishing all the evidence that has been admitted to the jurors. It's a slightly different issue, but for all practical purposes, it appears to me to be somewhat unmanageable, Mr. Hart. The defendant would also have the same right that you have to publish to the jury his documents, and I'm not aware of that unless it happens during the course of the trial, before the end of the trial, that there's a procedure for handling that. Let's say we want to do it the way you want to do it. Where would his exhibits go? Or would he have to wait until the jury examine your exhibits and then he set up his exhibits? It appears to me that this is looking fairly unmanageable just with your exhibits. So he makes a good point. I'm not sure what we're going to do about it yet, but how do you respond to his argument that there's nowhere to put his exhibits?
Well, we could theoretically consolidate some of these things. We were laying them out so that we could get a handle on putting them in groups. We've not completed that process. I can consolidate some of them and make more room for their exhibits if they want to put those out. I guess the other option is let them look at our exhibits, then look at the defendant's exhibits. I don't know that is the best option, but I do believe they're entitled to see these things. I believe the state would be entitled to have them published to the jury at this point. So I'll do whatever the court tells me to. I can put some of these things together and they can look at them if they choose to. They may not look at any of it, but I think they're entitled to the opportunity. I will consolidate these things. I'll give him half the table. I can move some of these other boards over. He can have at least half the space that's left for the boards. I don't mind doing that at all. We were trying to get them organized so that they were at least in classifications. So my suggestion would be, let us consolidate these things, give them the opportunity to use half the table and half the space that's left around the rest of the courtroom, and then let the jurors have an opportunity to see if they choose to.
Judge, I think that all of these items, every single one of them, has been published to the jury at least twice already. every single photograph was shown by a witness to the jurors. And then at the end of that witness's testimony, Mr. Hardin asked the court to allow him to pass those around to the jurors. And we took hours and hours of court time collectively.
What about that, Mr. Hardin? Now, he's saying, in essence, you've already had an opportunity to publish. I hear him saying each one of these items has, in fact, been published at some earlier time, as opposed to them not having a chance to handle it or see it. Do you agree with that, or do you not? I mean, I don't know whether you've published each one to the jury.
I don't know. I have published everything to the jury. I certainly haven't published everything to the jury twice. But when you publish things to the jury while they're sitting in the box, I think they feel a certain amount of pressure to look at it quickly and pass it on. To the extent that they have that time pressure, they've not fully considered the evidence. This is their opportunity. If they want to look at anything, they have that opportunity at a more leisurely pace to do that. If they want to look very closely at a photograph, instead of having somebody right beside them wait or anticipate that they're going to get that photograph pushed to them very quickly, it gives them that opportunity. That's all I'm asking.
Does each one of these exhibits have either not these particular, but the ones that are in evidence, do they have a state sticker and a defense sticker, a red and a blue?
They each don't have both. Each has one or the other.
Yeah, one or the other.
Yes, sir.
Not both. I'm trying to figure out if you put them here jointly, does the jury know exactly whose exhibit it is? And the only way they would know that is if you told them the red ones were the state and the blue ones were the defendant.
Well, it says state's exhibit on the red ones, I think.
Well, no, if they're on there. If the stickers are on there, that's why.
Yeah, they're all on there, I think. But, Judge, I didn't see any juror rushing to read anything. For the most part, there were multiple copies given to him, and I remember a number of times when the deputy would be sitting there and 15 people would be finished reading something, and there'd be one juror in the back still reading, and we'd all wait until he finished. And there was nothing done to hurry a juror. There was certainly nothing done to hurry people in looking at photos.
Okay, well, look, I don't want to spend too much time on this issue. I did want to see what it looked like and see what your arguments are. But it appears to me, Mr. Hardin, that it's going to be somewhat unmanageable doing it the way you want to do it. The bottom line on this, it still goes back to me not being able to force either one of you to consent to sending exhibits in the back. That's what I understand the North Carolina law to be. I mean, I could do it over your objection, and it could be error. It probably won't be reversible error, but
it won't be if we're consenting.
It could be, but I'm thinking this process is going to take a whole lot of time that we don't really have. I'm thinking that I will instruct the jury probably that if they want to see an exhibit on either side that has already been introduced, that they do have the right to do that. I'm confident that's the North Carolina law. But of course, if there's an objection from either side as to it going into the back during the deliberations, then they still have a right to see it. As I understand the law, they have to just do it in open court. And that might resolve the issue as to them wanting to see an exhibit and not having seen it before that particular time. I think that's probably the way to handle it, because you still got problems identifying what it is that they would want to see out of 500 plus exhibits. But we can figure that out, I think, among all of us. I just think it's unmanageable, Mr. Hardin. So that being what I'm thinking about, how do you respond now? What do you want them to do? Take all this stuff out of here now?
Well, our request would be that it be put away. We can prepare a list. We'll be happy to work with the state to do this, a joint list of all the exhibits with a description of each. We already have a list like that. I think the state does as well. And I have no objection to that being marked as an exhibit so that the jurors can look at that. And if they want to look at it now, if Mr. Hardin wants to put that together now and give the jurors a chance to look through that and say, gee, we'd like to see this one more time before we go back to deliberate, I don't have a problem with that. But to have them mill around like this is my problem. So my suggestion would be we put together a list and either give it to the jurors so that they can ask for materials during their deliberations, or if Mr. Hardin really wants to, that we put together the list right now, hand it out to the jurors, and if anyone wants to see anything in particular, they can see it.
Mr. Hardin.
Well, I can't just automatically produce a list in a few minutes. I have our list, which would have to be sanitized, and I mean that would take several hours to do that.
I think if you look at the screen, I think we have a list of everyone's exhibits. It's pretty accurate. It's up on the screen there.
I'm not seeing it. Before I can respond, I'd like to have an opportunity to look at it.
Assuming we can do this, then you want to do what with that list?
Well, my suggestion would be...
See, the problem you have is now, I mean, if you want to get real technical about it, you raised the issue about the jurors walking around discussing things. What are you going to do with that list? Have them go to the deliberation room and tell you what they want to see?
No, sir.
And this juror number 1 talks with juror number 12. Oh, yeah, I want to see that list. Don't you want to see it?
No, sir. To hand out 16 lists.
Right.
And then if any of them let each one of them look at their list and basically say to them, and I'm not advocating this, I'm just saying if Mr. Hardin wants this, I don't have an objection to.
You're the only one advocating.
Well, no, I'll withdraw my suggestion. I mean,
no, it's a suggestion. I think it's a good suggestion. I'm just trying to figure out how to.
Just that each one would have the list, and you could instruct them if there's any particular exhibit that you want to see before closing arguments, just mark it on the list. And, we'll take it out, and then it ought to be passed to everybody. So, maybe, everyone marks one exhibit, and, you end up passing 12 exhibits to the jury or 16 exhibits to the jury. I don't have a problem with that. So that's one way of dealing with it, and we're happy to make our list available.
Well, but I really don't want the jury to get confused. I think if you do that, I think you have to tell the jury it's not their last opportunity to.
Yes, sir.
To see you.
I agree with that 100%. Yes, sir.
An exhibit, and that they would have a right to raise the issue during deliberations, because if you do that, they mark them all on.
Oh, and I agree. No, I agree with that 100%. Or to just tell them that here's a list of the exhibits. They have the right to see them during deliberations. Do any of them have any desire to see any of them before?
Yes, sir.
Your Honor, if the court's contemplating doing it that way, I would suggest a slight compromise, that the items at least be consolidated here, leave them in the courtroom, and let them see them now if they choose to. Have the bailiff deliver them while they're seated in the box, and that way, if you don't want them milling around. But I would ask that they at least be available in this room. I don't want to gather all this stuff up, put it back in the clerk's office. It's going to be impossible to find it in a timely manner.
Well, have that also. I mean,
what I said was we'll move these things over. We'll consolidate these things. If they want to see something off the list, very simply go to it. It's already categorized, and hand it to them.
It's real simple. They've been put back in order, and whatever they want to see will go fine. It's not rocket science to find something that's in numerical order. And I object to them walking in and in essence seeing this potpourri of exhibits. I mean, by definition, when they walk in, whether they want to see it or not, they're seeing it. And I object to that.
Well, I don't think that there's a valid objection as to whether the court could do it that way. The court just doesn't choose to do it that way, because I think it's going to take more time to do it that way. So I'm going to order that you to compile a list of all those exhibits We're going to tell the jury that they have a right to see exhibits before deliberations. They don't have to view them at this particular time. Any exhibit that has already been introduced by the court by any party, the jury has a right to see. Now, I don't think I need to tell them that they can see it in the back room or out here. That's not germane to what they have to do. But that guarantees that if there's some exhibit they want to see, either beforehand or during deliberations, they understand they have a right to see it, and we'll notify them how to do it. Now, look, I mean, how much time is it going to take you for lawyers to get your list together? I mean, the clock's running. We're wasting time.
Well, Your Honor, what we have is we have a spreadsheet for the state, for the defense, that we can print out so there's no notes, it's just the exhibit number and a very generic description of the item that I can hand over to Mr. Hart and he can take a look at it. It's on my computer. We can make changes to it fairly quickly. And I think print out there probably a couple pages.
Well, just give me a ballpark figure as to how much time you all think you need, because you know we have a very important issue we got to deal with this morning.
I would suspect, we've tried to make the description generic. I would think 15 or 20 minutes we would have 2 acceptable lists, the state's list, the defense list. I can't merge them together easily, but we could have 2 lists with the exhibit numbers and a generic description for everything that's been in probably 20 minutes. I will print out the state's one first so Mr. Hart can begin to look at it. And because it's a spreadsheet, I can print just the columns that are generic from the number, not notes about who testified to it or things of that nature.
One other item that's not related to this, we'll take care of that, but the court sealed Mr. Shabani's testimony and exhibits. I've gotten several requests from lawyers who have cases in which he's testified where I think in one case they've already filed a motion for a new trial, where they want access to the transcript of what he did here and how he did it. And I've had at least one request from a scientist who wants that for purposes of providing it to a professional organization. So I'd ask the court, and if you want to just wait till the conclusion of this trial, that's fine, but to unseal the transcript of Mr. Shabani's testimony, at least at the conclusion of this trial, so that other judges, lawyers, whoever in the criminal justice system or elsewhere needs it would have access to it.
Yeah. Does the state have a position on that?
We don't object to that, Judge.
All right, that's
thank you.
Okay, we're going to take a break so you all can have your discussions. How long are we going to take?
15 minutes.
15 minutes, Mr. Dillon.
Court stand recess for 15 minutes.
Oh.
Jared, do you want to do that at the bench, or you want to do an open court?
I think I better do it in open court, Mr. Rudolph.
Yes, sir.
All right.
Judge, as you know, yesterday at the bench, we discussed a problem that had arisen during Professor McElhaney's testimony. And just so the record's clear, during that testimony, notified the deputy jury clerk that she apparently knew Professor McElhaney. Indeed, that their families had socialized when they both lived in West Virginia a number of years ago. And initially, everyone thought that was the extent of the contact. Subsequent to that, we were informed the next day, I believe, or perhaps that afternoon, that in fact they had social contact much more recently while here in Duke. And I can't remember exactly how long ago it was, but it was within the past 5 or 6 years, I believe, maybe 7 years, where they had been in each other's homes and that sort of thing. Obviously, that raises concerns, given the fact that it's not just an acquaintanceship, but close enough to have been in each other's houses. And it's one of those unfortunate things that obviously Mr. Hardin didn't know at that point to put Professor McElhaney on the list. He probably wasn't even a witness at that point, but was honorable enough to let everyone know that she knew him. And obviously with that information, if we had had it at the time, we no doubt would have exercised a peremptory challenge, of which we had a number, to eliminate having anyone on the jury who would have a personal relationship of any kind with an expert witness called by the state. In light of us finding out about that at this point, we are going to make a motion, and given the fact that we're at the end of the trial and we still have all of our alternates, we're going to make a motion at this time that excused from participating in the jury.
Oh, they're blocking her name out.
Based
Okay.
on her prior relationship with Professor McElhaney. And we just feel like it's in everyone's interest to make sure that all the jurors assess all the witnesses' credibility without any kind of a preconception at all. And we think rather than being sorry later, it's better to be safe now. We'd ask that she be excused.
Well, I think unless Mr. Harden is not going to object to your motion, that he needs to put on the record something that may not be exactly clear as to the extent of knowledge. Now, he has had the benefit of talking to Dr. McElhaney, which the court did not, as far as I'm aware, defense counsel did not, but upon learning of the information from the juror, and of course he knows what information she supposedly related to the deputy, then he was able to make some determination. He had a discussion with Dr. McElhaney, and maybe Mr. Harden, you should once again, for the record, tell us the extent of information that you learned from talking with your witness.
Yes, sir. As I
you did that outside of court, so there was no hearing, no testimony about that.
Yes, sir. And as I believe I indicated at the bench conference when the issue arose, Dr. McElhaney indicated to us that he did not recognize Ms. But when it was brought to the court's attention, his attention, he did indicate to us that he had known in West Virginia some 30 years ago, that they had been across the street neighbors, that while he's lived here in Durham, within the last 6 to 8 years, he wasn't sure about the time frame. He had seen her in social situations, had been, and I can't recall, I think he said that he had been in her home or she had been in his home. And their children were the same age, and they had some commonality there, and apparently their children used to play together when they were in West Virginia. And that was the extent of what he had indicated to us, and I believe I informed the court of that when we found out about it.
All right. I thought there was a statement about them vacationing at some point.
They were on, I think they socialized together on a boat. They went out, they went on a boating trip over a weekend. I think he said. That's correct. I'd forgotten that, Judge. I think I said that at the bench when it came up.
Yes.
And just so the record's clear, our concern is not just with the fact that there's obviously a prior relationship there that's closer than simply an acquaintanceship. Our concern is also with the fact that she would feel, since she does have that relationship, some concern about voting on a jury that, in essence, was rejecting a position that Professor McElhaney had set forth here in testimony. So it's a concern not just based on her knowledge and how it might affect her, but also how knowing him and being in that social situation might affect her in the future.
Well, one of the problems is there's some unsaid things about this situation. You know, we all know who her husband was at the time. And he's still her husband, but his position has changed. And the court has its own idea about intercollegiate athletics and stuff like that. It's one thing being a famous coach in this area, in the research angle area, where you can have, Duke and Carolina and State and Wake Forest, and have multiple coaches that share in the limelight. It's another thing to be the head coach at the University of Indiana, where there's only one major university. There's some other universities that play basketball, or the state of West Virginia, which, Mountaineer basketball, like Kentucky, might be the only game in town, or the largest game in town. You have a person who was a successful head basketball coach at the University of West Virginia, and the impact that person might have as a friend, I don't know. If we don't talk about it, you get an understanding of
what
the
does
impact
basketball have to do with whether or not you know someone.
He comes to Durham, and he takes over the basketball program at Duke University. Well, at that time, it was the best basketball program in the world is one thing, but still, he's a major figure now. I'm not sure, Mr. Harden, her husband was the basketball coach when they made contact again with your witness in Durham. Based on the time period you're talking about, he probably wasn't. The present coach was probably the coach at that time, but I just think that's a big impact. It's not like her husband wasn't a major athletic figure in the state of West Virginia at the time. I've got a feeling he was. And all I'm saying is the impact would seem to the court to be much greater than just being colleagues and friends and next door neighbors. That her husband was a major player in West Virginia at the time that they were taking these vacations and trips, and the children were playing together. I'm thinking it was a big deal.
All I can do is recite to you what Dr. McElhaney told me.
Yeah. All right. Well, I didn't get the state's position on the defendant's motion.
Yeah, we don't wish to be heard.
I really do hate to excuse, especially since she did everything a juror is supposed to do. She's the one that brought it to our attention, first of all, and certainly she was acting properly. We went through a process, as I've said on other occasions. I don't know, particularly as to Ms. Waters, how long you all examined her, but my figures were that each one of the counsel for each side, questioned these jurors about an hour and a half. I've said it before, it's about 3 hours that you all had to ask them any question that you wanted to ask, and I was very liberal in letting you ask. Now, one of the things that we came up with quite late in the proceeding, but I think we had it before all the jurors were questioned, was this potential witness list. And as I recall it, you told the jurors that this was a list of people who could testify, they might not, and you asked them to identify them. And actually, several times, I can't remember asking Ms. Waters, but right in the middle of the selection process, you let them look at the list, or go in the back and look at the list, or gave them the list before they came down here. And the problem is Dr. McElhaney's name wasn't on the list. She knew that witness or recognized his name, she wouldn't have been able to tell you at the time the list was published. As a matter of fact, I don't know when. Mr. Harden, you knew that you were going to use Dr. McElhaney. Do you have a recollection of when you were sure he was going to be a witness in your case?
Not until Dr. Bandak testified.
Okay. Well, see, she could not possibly have have known that he was going to testify. It's just, I'm not saying the state is being unfair, but it's certainly an unfair position to put her in. But I think it's a fundamental fairness issue for the defendant. It's a fundamental fairness issue. It's not unreasonable that he would have been able, had the juror known about your potential witness, he would have questioned that juror about that relationship that they had. And it's not unreasonable at all that he may have thought that she would not have been a good juror for the defendant, based on trips she may have taken with the doctor, or their kids socializing, or them being neighbors. As he indicates, he had plenty of peremptory challenges that he could have used. And from the standpoint as to who should bear the burden, I mean, I think I have an idea that in this case, the state should bear the burden. It shouldn't be the defendant. And I just think it's a fundamental fairness issue. I'm struggling with it a little bit, but not a whole lot, because I'm satisfied, quite frankly, that had even Mr. Rudolph known at that time that you were going to have Dr. McElhaney, and he could have been able to discuss it with some of the jurors, as he did with some other jurors. Some other jurors did know witnesses on the list. He was very careful in asking specific questions about their fairness. He had no opportunity to do that. I just hate that it took her, it took us 4 months to get to this issue, but I don't think there's anything we can do but excuse her from participation in this trial. I guess the court could examine her and question her, but questioning her after the jury has been impaneled, I don't think it's the same thing as questioning her before the jury is sitting. And by the way, Mr. Ruff, that's an issue in itself that you probably already know, but the statute addresses excusing a juror and what the rules are and what the statutes require before the jury's impaneled. And there is no statute that deals with what the judge is supposed to do after a jury's impaneled and the motion comes up. Now, there's case law, as I'm sure you and Mr. Maher know. There's no statute that deals with it. And as I understand it, the statute makes it discretionary with the court.
And I want to stress that I appreciate sincerely bringing this matter to our attention. Obviously, it must have made her at least a little bit uncomfortable, and certainly, I think for her, being in this situation where she would have to judge the credibility of a former neighbor, someone whose kids she took care of and whose kids played with her kids and had a relationship with, is a difficult position for her to be in as well. So while it's difficult, I think that it came up at this point, at least we know about it and can do something about it. And I think it's not just fair for both sides here. I think it's also fair to the juror to not put her in that situation where she's got to judge the credibility of someone she's obviously had a prior relationship with.
All right, well, the court in this discretion will excuse me. I don't know when or how you want to do it. Are there other issues you want to deal with now, or should we go ahead and do that and replace her with the next juror who?
Yeah, it seems to me we ought to, rather than keep her around unnecessarily, that we ought to excuse her if she's going to be excused, and the court may want to give some thought to what to instruct her about talking with media and other people at this point. I don't know if the court's given that any thought at all, but that's. Well, I suspect that she'll be contacted after she's excused.
Well, two things. One, I don't have any intent to restrict her from talking to the media. I'm going to tell her that's up to her. However, she might very well want a sheriff escort out of here, and I will make sure she gets that.
Yes, sir. Other than that, I think Mr. Hart and I have talked about scheduling issues, and perhaps we can address those now. He's got some witnesses who he's trying to get in, not witnesses, I'm sorry, some spectators interested.
Especially since she told them when he testified. They should have done it right then if they were going to do it. And so now she's had to sit through how many more days? And be there and come back and in and out and whatever. Let's take a break a million times. Yeah, I'd be ticked.
Persons who he's trying to get in.
I can handle that witness.
Yeah, I know you could.
Pretty easy.
I know you could. And he and I talked about a schedule that would permit him to do that, give both of us a full day tomorrow to prepare our arguments.
Okay, but I'll tell you what we need to do. Why don't we go ahead and take care of Miss... Tell you the truth, I don't know what the jury's going to do about these exhibits. I think it's going to run smoothly, but that may affect
yes, sir.
What you're talking about.
Yes, sir.
So, Mr. Deputy, we need to have Miss... I'm telling you, she's probably going to need a security escort where she wants to be. I'm not saying it has to be you, but can you make arrangements to have someone down here when she gets here?
Yes, sir.
All right. All right, now members of the jury, our first alternate, Mr. Where are you? If you just raise your hand. All right, sir. I'm going to place you in seat number 3. So if you all can stand, or at least let him slide down to the seat that's empty. No longer our first alternate juror. You are a member of the 12-member jury. Obviously, that means that the juror who was seated in your seat, juror number 3, is no longer a member of this jury. I'll instruct the jury at this time that that juror was excused. I will instruct you that it had nothing to do with any misconduct on the part of the juror, and that the jury should not have any concerns as to why she was dismissed. You're to put it out of your mind and carry on as if Mr. Higgins had been sitting there the entire time. Now, the juror did relate to the court that she had bonded with most of you all, and that you all have some plans that you intend to carry out if this trial ever ends. And you're no longer a member of a jury. I will tell you the same things that I told that juror. It is not the court's normal practice, and I won't do it in this case, to tell you once your jury service has ended. Either you reach a verdict, or you didn't reach a verdict, or at some point the court is going to determine that you're no longer jurors in this case. And there's nothing in the North Carolina law that the court knows of that prevents the jury from meeting and having parties or social gatherings or anything you want to do, including with the juror who was no longer a member of the jury, who was excused. Now, there are some things, however, that cannot take place before you've been excused as a juror. I've explained to that juror not to have conversations about this case with any presently sitting juror until this case is over and that juror has been excused from court. So at that point, you can have discussions with her or anybody else you want to. And before that time, of course, you can't have discussions with her, even if she was a member of this jury. And you can't have discussions with anybody else about the things that we've already been talking about all the way through the course of this trial. So once this case is over, you've been excused. You can have conversations with each other, or you can have conversations with any other person who was being excused, or who have not been a part of that jury. I need for you all to understand that. Does anybody not understand that? If you don't understand what I'm talking about, raise your hand so we can talk about it now. I mean, I don't see any hands. I think you understand what I'm saying. I mean,
That's the way they say it in North Carolina, because that's the way the judge in the Murdaugh trial said it too. Juror. I mean, technically, I guess it's right. It's like when Spock says censor instead of censor.
at this point, I'm neither approving or disapproving whatever you all want to do once this case is over as jurors. That's up to you all. I actually thought I said during the course of the jury selection process, maybe I did not, that the court will not restrict what you do with the press or anyone else. That's up to you all once the verdict has come in or you've been excused from participation in this case. You can have whatever conversations you want about this trial with anyone, family members, press, anyone you want to, or you can tell them you don't want to discuss that. And that's up to you. That's your prerogative under the First Amendment. There is no law that I'm aware of that controls what you think or what you say about your jury service once you've been excused. But until that time, of course, there is a law that prevents you from discussing any matters. Actually, you can't even discuss it among yourselves until it's time to deliberate. I have not heard that anything other than that has been the case. And so I'm not really addressing that. But I do understand that there are some things that you may or may not want to do at the end of this trial. And that's going to be up to you all. Now, do you all have any questions about what I just went over with you? Do you understand what the status of the juror is at this particular time? Do you all understand that Mr. Higgins is a member of the original 12 jurors and he's no longer an alternate juror? Do you understand? Now, I'm going to send you to lunch until 1:15. And of course, during the lunch period, remember all the instructions I've given you throughout the course of this trial. And I want to tell you before you go to lunch what we are trying to do as far as exhibits. In the state of North Carolina, either the state or the defendant or both can do what we call publish exhibits to the jury. That is, all the exhibits on each side that have already been formally introduced into evidence, the jury would have a right to look at them. And that's what we call publish. It simply means like you publish in the newspaper. You look at the item. You have a right to do that. That will not be the jury's only opportunity to see items. Once the jury reaches the point of deliberation, that is, after all the arguments have been made by the lawyers, after the court has given you the law in the state of North Carolina that you ought to consider, and you will be instructed to go into the deliberation room and deliberate, the jury has a right to request any exhibits that have been formally introduced into evidence. Now, you have a right to ask for those that haven't been introduced, but you're probably not going to get them because the law doesn't really allow that unless they've been formally introduced. And the reason I say this is that during this viewing process, the way we're going to do it is this. There have been so many exhibits introduced into this case that the court has made a decision that it would not be practical to place all of them in this courtroom and allow you to look at them. I think it would be unmanageable. What we have decided to do instead is to have a list of the exhibits submitted by the state, introduced and accepted by the court, and those items by the defendant that have been submitted for your consideration and accepted and introduced in evidence by the parties in the court. And that if you want to see at this point a particular item that you check off or you identify it on the list that's going to be provided to you when you get back from lunch. That way, and I might add to when you go to lunch, now you should not discuss among yourselves what lists you want to see and have discussions with your other jurors, because that sounds a lot like deliberations, which you're not supposed to be doing at this particular time. So when you come back, each individual will be given a list, and you will check off individually without assistance from the other jurors as to what it is you want to see. Now, it may be that if you cannot identify the item and you have some kind of idea what the item is, that I will give you an opportunity to talk to us in court so that we can identify the item that you're talking about. I mean, I don't expect that you're going to remember the number or anything of that sort, but you might remember a general description of the item. So I just want to give you ahead of time an idea about what we're doing, because once we get back, I anticipate that those of you who do want to see items, and as I indicated, you do not have to see an item if you don't wish to at this particular time, but if you do wish to, then we'll try to accommodate you. Once again, I keep saying it because I don't want you to forget that once you get into your deliberations, you have the same rights to view along with your other jurors, where discussions will be permitted, because that's what deliberations are. So think about that over lunch when you get back. That'll be what the process will be. Now, at some point when we finish that process, I anticipate that the lawyers and I are going to have to talk about when they're going to do their jury arguments and some things that have to do with jury instructions that you don't have anything to do with. And you will probably break for today and come back on another day. Exactly what day that is, I have no idea right now, but it's something that we're going to be talking about. I'm just trying to give you some kind of idea what the process is going to be. So once you finish examining these exhibits, you're going to be excused for a period of time. The lawyers and the judge are going to talk about the jury instructions, and when you're going to come back and hear the final arguments, we'll have to figure out what that day is. And really, the only things left to do is for you to hear the final arguments, for me to instruct you as to what the North Carolina law is, and for you to go back in that back room and see if you can reach a verdict. So I realize that we have talked a great deal about what our schedule will be, and we have not had the opportunity to discuss it with you because there are a couple of things that should be done before you know what our schedule is going to be. We are near the end of this trial, so you need to get focused in the back of your mind as far as your lives are concerned. This case is going to end pretty soon. Okay, we're going to lunch, 1:15. Yes, sir.
Will we be here opportunity to look at testimony and transcripts?
Well, you may or you may not have that opportunity. At an appropriate time, and it'll probably be once you go into the deliberation room and start your deliberations. And there's a reason for that. The reason for that is that, as I told you before, or if I didn't tell you before, I'll tell you now, there's a reason why 12 jurors will go in the back and consider the deliberations. That's because our law is that 12 people have heard probably different things in the course of this trial. Part of the deliberative process is to give those 12 people the opportunity to express their opinions and to tell you what they remember and to get from you what you remember, and for them to try to clarify something that they don't remember. So once the jury goes through that process, it may be that you want to see an exhibit. It may be that you want to hear some testimony or have the court refresh your recollection about some testimony. And whether that happens or not probably should come after you've had some discussions with your fellow jurors. Normally the procedure is at that time that I will instruct you later on that if you have a question or if you have a request, that you have your foreperson or some person assigned by the foreperson. Once you pick that person, write that down, knock on the door, give it to the deputy. The deputy will bring it out here. We will talk about it and determine whether or not that's a request that the court can comply with. So there is a procedure that I will certainly tell you about, and actually I just told you about, whereby the jury can make certain requests. I would prefer that happen once you go back into the jury room to deliberate, so that you all can have a better idea of what it might be that the jury wants to see. So pretty much, I'm sure that's the procedure we're going to follow. Does that give you some kind of idea? Okay. So if you have questions, if you have requests, and it wouldn't be unusual for the jury to have questions or requests, the better practice might be to wait until you start your deliberations, and then those requests will be made, just so that we can have 12 people thinking about after some discussions what it is that they want to see if they have a request. All right. Does that clarify it for everybody? Okay. Y'all have any other questions just right now? No. Well, one that comes to mind, I don't want to take up too much of your time, but quite frankly, once y'all finish, when you come back once and you finish this process, then you're going to be free to go. I'm not. The lawyer's not, but you're going to be free to go. So I'm not particularly worried about the time right now, but I anticipate that at some point, we, meaning the lawyers and the judge, are going to have to talk about what our schedule is going to be as far as the jury. What I'm saying is that it may be that we will have to go longer than the time period that we have been going, but that decision has not been made yet. I do want you to think about that, because it may be that at some point I will ask you all kind of what you want to do about that, and I'm going to have to give great deference to what you all think, because we're putting on this entire trial for the jury. So I think I've tried to work within your schedule what I told you would be during the trial of this case. And I think I may have told you all, I don't specifically remember for each one of you, that schedule may have to change. We'd be forced to change when we get to a particular stage in the trial. We'll still give the jury a great deal of latitude in giving some suggestions as to how they want to proceed at that time. I mean, am I talking around this issue too much? I mean, you know what I'm talking about? I'm saying we may have to have long days, but I'm probably going to let you all decide. I mean, I haven't discussed that with the lawyers. There's some things I can't break up. You know, the lawyers have to argue for a certain period of time. And it may be that you may not hear all the jury arguments at one time, but I have to work out a schedule where I don't break a lawyer right in the middle of his or her argument and have them come back another day and start the argument again. I'll see the problems that I may have. I can't really do that and be fair to the parties, but we'll try to work out a schedule that's satisfactory to everyone, taking into consideration what your schedules are, and we know what they are pretty much. I think the lawyer's going to be very reasonable. I think the jury's going to be very reasonable. So we haven't worked out all the kinks yet. We're going to do that today, though. We're going to work them out. So why don't y'all go to lunch, and I'll see you now in about an hour. You lost 15 minutes with me sitting up here explaining this to you. Huh?
Can you make it one that
Well, they don't. I'm not gonna worry about it then, I bet. Okay, now we're gonna have to really work to get something done by 3:15 today, because at 3:15 you're gonna lose your judge, and we're gonna have to work out some other way to deal with this, which we can do. I mean, we may have to meet later. Now, certain things start happening when we do that.
To say
We
this
may not
is
have a
what we're
court
doing
reporter.
and do it.
I don't think that's really essential for the charge conference, because any objections can be placed on the record at a later time. I think we'll get it done, but we're gonna really have to hustle to get it done. So 1:15.
All stand? Yes, County of Durham, stand recess until 1:15.
All right, where do we stand, Council?
Yeah, I was just going through their list of exhibits, and there were 3 or 4 where there's what might be termed an editorial description as opposed to a generic description. And I was just pointing those out to the state, so we may have to make a couple changes on a couple pages and recopy those. And I'm just finishing looking at that right now. I've let the state know which ones they are.
Does that mean that there's notes on it that say why it is like why it means he's guilty or something? Like, what does that mean? Generic versus editorials. I mean, it's going to be stamped defense or prosecution, so they should know what.
A couple more on the same page. So.
Whether it says it on it or not.
And we have our exhibit list ready.
Well, Mr. Rudolph has identified P233A in the caption describing what the photograph depicts. It indicates Polaroid photo of a blood mark in parentheses blowpoke. The next is P233, photo enlargement of Polaroid dash blood mark in parentheses blowpoke. With respect to those are the state's contentions. We'd ask that you allow the description remain. It identifies the photograph. If they want to look at it, they have a better idea of what that photograph depicts. Again, it's state's contention, so I would ask that you overrule that objection. With respect to P256, that's a photograph of the wall, and it indicates photo of wall canvas cleaned. That's our contention. That's what the state's evidence shows. I'd ask you that you overrule that. Item 166. Is in quotations, less work on our marriage, in quotations. Outside of that, it says email. That's an email that was tendered to the jury. It was read into evidence. Again, that's what the state's evidence tends to show. We'd ask that you overrule that. And then the last one they show is 178, which is a poster showing blowpoke mark. That was something that Agent Diva produced. Quite a bit of
all the ones that say
testimony
blowpoke
about that. That's the state's contention. We'd ask that you overrule that as well.
But the other one, no.
Mr. Rudolph, do you wish to be heard?
No, sir. If the court does overrule our objections to those, though, I'd ask that the court at least instruct the jury that where there are descriptions on either set of exhibit lists, that it be made clear that these are simply the parties' contentions and not that that in fact is what it is.
All right, the objections will be overruled. Now, how is it council wants to proceed in this process? Do you want to bring the jury out here and do that, or?
Yes.
Yes.
All right.
Yeah.
And
we have 15 sets. I want to be sure.
Your list are clearly marked.
I'm sorry?
Are your lists clearly marked?
Yes, sir.
Defendants, prosecutor, or
Yes,
state's list?
Your Honor, I also have enough copies for the jurors. Mr. Rudolph's suggestion that it be marked and entered as an exhibit in
Thank you, Marty.
If the court would mark these as court's exhibits, so that they can be preserved.
All right.
Or I'll hand up a copy of the states. Dave, you got a copy?
We need to make one more copy. We only made enough.
All right, and what particular instructions do you want me to give to the jury? They are to examine the list and mark. Is there a particular method or place you want them to mark? You want to circle it?
Circling it's fine.
Okay. And then you want them to pass them in when they finish? You want to pass them to the end?
That'd be fine. They probably need to put their names on the top of them.
All right.
I'm not sure they need. Well, I'm not sure they need to put their names on it because I think anything that's requested by one needs to be seen by all.
I think all of them have to see it, so
that's fine.
Doesn't really matter.
Yes, sir.
All right, Mr. Nick. We'll make it court's exhibit. Whatever it is, again. Yeah. Whatever it is. I don't know what it is. All right, members of the jury, as I indicated to you, we're getting ready to pass out a document that has a list of exhibits that are already been introduced in evidence by both the state and the defendant. That doesn't mean that they did both of them, but the state's evidence is clearly marked on the chart. The defendants are clearly marked on the chart. And what we're going to do is pass you, each one of you, an individual list. What we ask for you to do is go through the list without conferring with your fellow jurors and circle the exhibit that you wish to view at this particular time. Once we get that list, then we will be in a position to put the list together. I think you need to understand that if any one of you marks a particular exhibit, then all of you will get a chance to see the exhibit because that's part of the deliberative process. We wouldn't just let one juror look at the exhibit. So anyone that you mark individually, all the jurors will have an opportunity to see. I will also tell you that some of the descriptions by either the state or the defendant have a description behind it. Sometimes that description will represent what that party contends that exhibit shows. And when you see such an exhibit, then you are to remember that ultimately, if you consider that exhibit, then what its value will be, what its worth will be, in fact, what it is will be determined by the jury and not necessarily the party. So if you see a description of a exhibit that you think favors either the state or the defendant, recall at this particular time that is what they contend the exhibit describes, and it will be ultimately for you, the jury, to determine based on the evidence and based on the discussions with your fellow jurors what that exhibit, if it is considered by the jury, what it will mean in fact. Do you all understand that? All right. Mr. Deputy, if you'll pass out the exhibits, I take it all of you have a pen or writing utensil. If you don't, if you raise your hand, we'll get you one. All right, members of the jury, if you will just hold on for just a second. I've conferred with the lawyers and they have consented to allow you to go back into the deliberation room to fill out your exhibits so that we can carry on with some other business that is related to this particular trial. I would ask, however, that you continue not to confer with each other And then if one of you, of your own selection, will determine when all of you are finished, if that person or someone on that person's behalf will knock on the door and let the deputy know, we'll take it from there. So go ahead and finish your exhibit. Don't confer on them. However, select someone to be your spokesperson so they can determine when all are finished and you can knock on the door so we can go ahead and get the exhibits and do what we need to do with them. All right, you all understand? Anybody not understand? Okay, everybody's clear. All right, you all have consented to have to at least begin your charge conference at this point? All right. I typically start with the state and ask, are there any requests from the state? You can do it any way you want to do it. That's where I normally start.
Yes, sir. The first instruction we would ask that the court give, I'm assuming that a lot of these are perfunctory and you're going to give them. I just want to make sure it's on the record that we are asking for. 101.05, the function of the jury. 101.10, burden of proof and reasonable doubt. 101.15, credibility of the witnesses. 101.20, weight of the evidence. 101.35, your concluding instructions. And I'm doing these in numeric order. So 101.36, highest aim of every legal contest. 104.05, circumstantial evidence. 104.10, motive. We would ask that you give the pattern instruction that you previously given to the jury regarding 404B evidence. That would be 104.15, evidence of similar acts or crimes. 104.50, that relates to photographs, maps, models as illustrative evidence. 104.50A, relating to photographs, videotapes as substantive evidence. 104.94, testimony of expert witnesses. 206.14, relating to first-degree murder. We also ask that you give 120.12, definition of serious injury.
Say it again. What's the number?
120.12, definition of serious injury. And that's all on behalf of the state, Your Honor.
We don't have it. Now this goes higher.
And so we're clear on that. We would ask that that language regarding serious injury be included in the pattern instruction for first-degree murder behind the language describing a deadly weapon. it would state a deadly weapon is a weapon which is likely to cause death or serious injury. Serious injury is such injury as causes great pain and suffering. Also, with respect to that same instruction, after the fifth element, where it begins, premeditation or deliberation is usually susceptible of direct proof. They may be proved by proof of circumstances from which they may be inferred, such as, and there's a list of circumstances we'd ask that you instruct on and include in this instruction: lack of provocation by the victim, conduct of the defendant before, during, and after the killing, infliction of lethal wounds after the victim is felled, brutal or vicious circumstances of the killing, manner in which or means by which the killing was done. So in essence, the only two you would strike from this instruction at the state's request would be threats and declarations of the defendant and use of grossly excessive force. Those would be the only two that are struck. But the others would be included.
Your Honor, what we've done,
Just for clarification, because I haven't looked at every single one of these, I take it the state is not asking for a lesser included offense?
Absolutely not.
Okay.
well, that may save some time. Let me hand up, if I could, and then we can go through these. I've already provided these to the state. The first is just numerically by having instruction numbers, so we go through. There's a fair amount of overlap. The second are two proposed alternative additions to the instruction dealing with the use of what we call 404B evidence. And it might make sense just to go through numerically what we agree with and what we disagree with in terms of pattern instructions, and then deal with the substantive instruction, and there may not be much disagreement about that as well, and then discuss what we propose as additional language on the use of 404B. We've given the state copies of those. The first couple of these, we would agree with the state. We've also asked for 101.05, the function of the jury, 101.10, burden of proof and reasonable doubt, 101.15, credibility of witnesses, 101.20, weight of the evidence. We have listed here 101.30, but we would ask the court to hold open the issue about whether to give that instruction until we make a final determination on that. But we've listed it there. 101.35, concluding instructions. We would object. Now let me turn to the page, make sure I'm looking at the right instruction. I believe we would object to 101.36. And I don't know if Your Honor has the pattern instructions before you there, but 101.36 is titled Highest Aim of Every Legal Contest. And our concern with that is twofold. One, it really adds nothing to the law that the jury is to apply, and it may well confuse the burden of proof. The issue, of course, before this jury is whether they have been persuaded by the state beyond a reasonable doubt as to each of the elements of first-degree murder. The instruction on 101.36 risks confusing that issue, and we would object to that instruction being given.
Well, that's my least favorite instruction out of all the ones in the pattern jury instruction.
Well, I would agree with you, actually, and it's one of the ones that probably does nothing to advance the jury's understanding of their job, while potentially confusing them as to their job on that.
Well, actually, I was thinking more that it implies that justice in a garb or robe or some language of that sort, indicating the judge will step in and find the truth, which rarely happens in any trial.
And you're right, it does say justice steps in garbed in its robe and tips the scales.
That's why I don't like it. You might like it for another reason, but.
So we object on that.
Is there a particular reason you want it in there, except that part about the jury having no duty to assuage victims and that kind of language.
Well, the primary
What
was
is the language? Are you looking at it, Mr.? Are you looking at that?
Yeah.
Jury instruction? What is the language about?
Well, in addition to the justice steps in garbed in its robes and tips the scales, and then goes on to say, in this case, you have no friend to reward, you have no enemy to punish, you have no anger to appease or sorrow to assuage. Yours is a solemn duty to let your verdict speak the everlasting truth. Well, much of that is true. It's probably not really an appropriate jury instruction. Clearly, in closing arguments, both sides can point out that they are here to do a certain duty and not to make anybody happy one way or the other on the other side. I just think it's inappropriate as a jury instruction.
Ms. Hart, do you have anything you want to say about it?
No, sir.
All right, then that request is allowed, but the court will not give that.
Okay. As to, we then asked for 104.10, which I think the state has as well, motive. We've asked for 104.20, which has to deal with the testimony of interested witnesses, jury mate, and that instruction simply allows a jury, if they find that a witness had an interest in how the case came out, to take that into account. We've asked for both 104.50 and 50A because I believe we've had diagrams. Yeah, I'm just going to go ask for. Expert witness, we've asked for 104.95. I don't believe the state had asked for, which is opinion testimony by lay witnesses. I think there were a number of people who were not formally qualified as experts who may have given opinions, so that it would be appropriate to have that as well. 105.20, which is impeachment or corroboration by prior statements. There's a great deal of testimony about prior statements in this case, and the jury would probably be instructed on those. 104.05, circumstantial evidence. We've asked for 104.90, which is identification of the defendant as a perpetrator of the charged crime. It may, in a sense, go without stating, but I think it's important the jury be told that that is part of what they are doing. And then finally, we've asked, and I think this is what the state is asking for, is 206.14 for premeditation and deliberation. I don't believe there's any felony murder theory in this case. So in addition to there being no lesser included offense, it would be only the elements of premeditation and deliberation.
I would presume so.
And so what I'd like to address then is, obviously we have objected to the evidence, the 404 evidence concerning Elizabeth Ratliff, but what we've drafted are two alternative instructions that would inform the jury of what they need to initially find before they would even consider the evidence for the limited purposes. And really, when you think about it from the jury's perspective, this type of evidence is a two-step process. First, they have to find that, in fact, the bad act occurred. In this case, Elizabeth Ratliff was, in fact, murdered, and that Mr. Peterson was a perpetrator. Because both of those are not true, then that isn't evidence that has any relevance in their assessment.
Yeah, what's the major difference? One talks about the
major difference.
Burden.
Yeah. One is a request, as we made earlier, that they be instructed that they have to make those findings by clear and convincing evidence. Mm-hmm. I recognize North Carolina doesn't have a case that says that. We want to preserve that. Well, obviously, we want Your Honor to give it, but if you don't, we want to preserve that request for later review if need be. So we drafted a second one that followed the more traditional formulation that doesn't have a clear and convincing standard. Otherwise, I think they're identical. Mm-hmm. The only difference is changing the standard.
Mr. Harden, what's the problem with the second one he's indicated?
With respect to both of them, we'd indicate that they are argumentative, that they place an additional burden on the state beyond what is required by the rule. In essence, they're asking that the jurors find that all of these contentions of the parties, of the party here that's the proponent of the evidence, is actually true. All they have to do, according to Stager, is to consider this and whether, and the standard is, where there is substantial evidence tending to support a reasonable finding by the jury that the defendant committed a similar act. They don't have to absolutely find the truth of it. There just has to be substantial evidence tending to support a reasonable finding by the jury that it existed and happened. I think this instruction changes that standard. It puts a much higher burden on the state of North Carolina. I'd ask that you completely disregard it and just give the pattern instruction as you've already done.
Mr. Maher?
Yeah, if you look at the pattern instruction, first of all, the language from Steger has to do with your Honor's obligation to assess whether there's substantial evidence to even allow the jury to consider it. I'm not aware of any jury instruction that incorporates that language because that's the court's kind of gatekeeping function before the jury gets it. What 104.15, which is a pattern instruction, says is simply evidence has been received tending to show that, and it says state-specific evidence. I would assume here it would be that Michael Peterson murdered Elizabeth Ratliff. And then later at the end, it simply says, if you believe this evidence, you may consider it. What we've tried to do is take that concept and make it clear to the jury that you have to believe this evidence, which is what the pattern instruction says, before you can consider it for these limited purposes. And only if you make that conclusion do you then use it. The state has a burden of persuading the jury that, in fact, Ms. Ratliff was murdered and that Michael Peterson did it for it to have any relevance. If the jury doesn't believe that, then it has no relevance and they shouldn't be using it for some other purpose. It would be improper for the jury to consider it in this case if they haven't first made that assessment. So the law already requires the state to persuade the jury at some level of the truth of that allegation. We have one that simply incorporates what I believe to be the existing law, which is they're simply told, do you believe it or do you find it to be true? And then secondly, what we believe would be appropriate here, the clear and convincing evidence standard. But under any standard, clearly a jury has to find this evidence to be persuasive before they could use it for the limited purposes the court would be instructing them to use it for. And I may, hold a second. And clearly any instruction, the court shouldn't be expressing any kind of opinion on whether that evidence supports a finding or not. It's simply an instruction here that says this is what the state's contended. You can use it for limited purposes if you find it to be true. That's, I believe, a correct statement of the law. It doesn't suggest that the court has any opinion on the matter one way or the other. It's not argumentative. It's clarifying the steps the jury must go through. That's important in the case when you've got an allegation of a prior murder that has a great potential, if misused, to cause unfair prejudice. And what we've tried to do, both with directing the jury's attention to the process and then arguing that there should in fact be a higher standard, is to build in safeguards to make sure that that potentially unfairly prejudicial evidence is used properly for the limited purposes this court has adhered it for.
What do you think the pattern instruction says? I mean, what is your contention that it actually says?
Well, the pattern says evidence has been received tending to show that, in this case, it would be Elizabeth Ratliff was murdered by Michael Peterson. If you believe this evidence, you may consider it. So it requires them to reach a decision to believability. It doesn't tell them what the standard for believability is.
Can believability be the same thing as truth?
Yeah, I think you believe things when they're true. And I think for a juror, there wouldn't be a difference between saying I think that's true and saying I believe it. Those are two ways of expressing that you have a level of confidence that the contention has been proved.
Mr. Harden, you think the use of that word true, as far as I can see, it comes down to whether you think there's some significance to the word if you believe it or if you think it's true.
Well, I think there's a lot of difference in terms of the standard that one would apply. If it, and straight out of the pattern instruction, evidence has been received tending to show that. It doesn't say evidence has been received and you must find that it is true.
Yeah, but
I think they're two very different things.
But it does say if you believe. Doesn't it say that?
Yes.
We don't. It says if you believe this evidence. If you believe what?
That's the query.
So is if you believe it's
absolutely 100% true, or is it you feel like it's true, you believe it even though you're not absolutely certain? I think they're two very, very different things. And I think that this proposed instruction tends to send the responsibility and the burden on the other end of that scale. So we would object and ask, you've already given the instruction once.
Well, I understand.
We just ask that you give the same instruction.
I also indicated that in the final instructions, I may give a different instruction.
Your Honor, in addition, when you gave this instruction, I believe, before the evidence about Ms. Ratliff was introduced, at our request, I believe the introductory language was changed from tending to show that to language saying that the state contends or is attempting to show. So the court wasn't commenting in any way on whether, in fact, the evidence, in fact, tended to show that. We would ask that the same language that was used before be used again, if that language is to be used. Because there's a risk that if Your Honor's up there saying evidence has been received tending to show that a jury will hear that you have made some finding that the evidence in fact shows what the contention is.
Is there something else?
Making sure that I was covering the right objection.
All right, well, let me talk to you all the people before we go further.
We'll request 101.30 as well.
All right, it's allowed. All right, Counsel, I've told you at the bench which one of the instructions that you already don't have very much contentions about, and counsel are going to work those out and put them in some form. As to the 404B, also indicated that I'm going to get a combination of the one that I gave earlier that I've showed you a copy of, and the incorporation of the one that talks about truth and not the one offered by the defendant talking about clear and convincing evidence. And counsel on both sides are going to meet, are going to develop the instruction, and if the state has an objection to it, they can put that on the record at the appropriate time. I guess they can put it on the record now if they object to it. I assume they are objecting to it. There are some things that both of you agree you want to include. I just don't know exactly what the language is. I think you can do that as to the illustrative and substantive evidence. The defendant agrees to the first-degree murder instruction with the exceptions that the state wishes to take out. The only issue I have is I need to see the final offer of the instructions for two reasons. One, to give you another chance to object if that's what you so desire, but so that I can also be in a position to offer it to the jury at some time. What are y'all thinking about now? We still haven't heard from the jury. That's actually not a good sign. So I guess we can't finally determine when you're going to do your arguments, but we can really do it without regard to the jury, because we can meet anytime before they do it. What do you have in mind as to when we're going to have a final set of instructions we can look at? Okay, you all want to meet in the morning at 9:30. We'll go over that, and I take it the jury won't be coming in tomorrow. Is it your intent to have the jury come in tomorrow? I don't know if they want to look at these things today. I'm not sure what you have in mind.
Well, my request would be that we go ahead and schedule closing arguments, defense closings for Thursday, prosecution closings for Friday. If the jurors want to look at any exhibits, they can do that tomorrow. But I think if we don't stick to that schedule, then I'm not going to be comfortable, and probably Mr. Harden wouldn't be either, with me arguing Friday and him arguing Monday. So that would push us back a number of days. And I don't see any need for that. I don't see any need to keep the jurors any longer.
Was that Thursday and Friday? Is that what you said?
That would be my request, Your Honor, that we go Thursday, that we do regular days. In other words, 9:30 to 11:30 and 12:45 to 3. I doubt I'm going to take all that time, but the jurors probably won't complain if they get out a little bit early. Same thing for Mr. Harden. And then I think the other question is for them, do they want to go on Monday if they start deliberating? Do they want to go to 5?
Well, we actually have a jury note that we need to talk about.
Yes, sir.
All right, so the defendant is setting forth that we continue under our same schedule as far as the arguments go. And that's going to be enough time for you?
Yes, sir. I'm going to make sure it's enough time by forcing myself to.
I'll be honest with you. I didn't actually time your opening statement, but I thought it was about an hour and a half.
It was probably it was close to that, if not that. But that doesn't necessarily mean that my closing has to be proportionately longer.
And I thought about that at the time you argued. I thought we could deduct from your closing argument, since you're only supposed to get one closing argument, that you would use part of that as your closing argument, and we work from there.
I guess then the question becomes, what are we deducting it from? Is the critical issue.
Into some of that time, and if for some reason they don't finish tomorrow looking at the evidence, then where does that leave us?
Okay, what do you mean eat into the time? What are you talking
about? If they take longer than tomorrow to look at the evidence, that would then put us into Thursday, and quite frankly, I don't think it's fair to either one of us for one of us to argue on, say, Friday, and then the other to argue on Monday. I don't think that's fair either way. So I guess I'm a little bit concerned that what they might do would affect the schedule. And just for planning purposes, because the defendant has offered evidence, the state has the opportunity to make an opening and a closing, and we will be waiving our opening, but Ms. Black and I will each argue finally in conclusion. Mm-hmm. We're going to split the argument up. So,
well, you've heard his recommendation as to time. Do you have assuming we could do this Thursday and Friday, you would be going on Friday?
Yes, sir. I don't have a problem with that, assuming the jury finishes with what they've got to conclude.
Well, today is Tuesday.
Yes, sir.
And you are thinking the jury might look at these exhibits until?
No, I'm just wondering if they don't finish tomorrow looking at the exhibits, they would then go to Thursday. And I don't know what their position is about arguing on Thursday after the juries still continue to look at the exhibits. I don't know. I'm just concerned about that, and otherwise the schedule's fine. I think we ought to stay on the same schedule. I think that's fine.
All right. Well,
I guess I'm trying to understand.
I've never seen the jury look at exhibits that long. I mean, I don't know if that's an indictment of the process or an indictment of the jury, but so I have no idea how long they're going to look at these exhibits. Mr. Rudolph, what if they bleed into, if they don't finish Wednesday?
Well, maybe we need to remind them that they're going to have a chance to look at these exhibits.
I did it as clearly as I could.
I know you did, but maybe you need to do it after lunch as well as before lunch. I don't know. The mere fact they're going through all these doesn't necessarily mean that they're going to each have a different list. So we may not have as big a problem as we're fearing. But if we do, then I've got a real problem with us taking 2 or 3 days at this point to let the jury relook at exhibits that they've already looked at. We get back to my original point. And if Mr. Hardin has specific exhibits that he did not publish before, then I think he would have a right to publish those now. If he doesn't have specific exhibits that he knows he didn't publish before, I don't think he has a right. I think it's in the court's discretion. And I think the court can exercise that discretion to make sure that we don't bleed into Thursday. And that's my suggestion. I think at some point...
My inclination, quite frankly, is if they take too long to view these exhibits, that I'm going to tell the jury that we're going to proceed with our jury arguments and that they have a right, once again, during deliberations to renew any requests that they have to view the exhibits. I mean, I don't recall right now how many of our jurors have previous jury service, but there is a more appropriate time to review the evidence, and that's really together.
Maybe they have a verdict.
Doing the. I don't think so. Yes, sir.
They're ready to go.
Okay. We're going to do this because I'm going to run into a problem that I need to resolve. I think I can resolve it. We're going to take about a 5-minute break and you just leave them right there, and we'll come back. And I think this is going to take a little longer than I had anticipated, but we'll be back 5 minutes.
Court stand recess for 5 minutes.
I think we'll get an idea of what it is they want to take a look at, and depending on what that is, and the clerk has told me she might be in a position to pull those tomorrow so that they can look at them tomorrow morning. But we had to make some quick decisions here because we're running out of time. What is it you want to do? You want him to collect the...
If we can all take a look at them,
okay,
we'll have a sense of what...
Why don't you just... Yes, sir. I thought you were going to say something.
I just want to see if you want me to retrieve them and hand them directly to the clerk.
Yeah, why don't you just stand there, just open the door and just tell some representative to collect all of them and hand them to you.
Okay. And then be seated?
You be seated? Oh.
No, did you want them to be seated or you just want me to collect the material?
No, they can stay back.
Okay, all right. Okay.
We just need to look at them. We'll make a quick assessment and then we'll determine what needs to be done. I just don't want you to go all the way in there. You can just stand right there. Okay, how do you want to do it? Do you want to come over here and look at them, or
That's fine.
look at them up here, or
Why don't we look at them up here?
okay, and just get some kind of idea of what we're talking about. Yes. All right. We've had a preliminary indication of how much they want to see, and based on that preliminary indication, Mr. Hardin, I think it's going to be an unreasonable position. It's going to be unmanageable for this jury to view the documents before the deliberative process. I think at the bench, the defense has made a suggestion, Mr. Rudolph, that I'd ask you to repeat on the record. My understanding is the state is going to object to that, but they understand the court's reasoning. So
my suggestion was that we take those lists and prepare a master list of all the exhibits that any juror has indicated interest in seeing, that tomorrow, with the assistance of the parties, that the clerk pull those exhibits together, and that at the time that the court instructs, or over the rest of the week for that matter, and then at the time the court instructs the jury on Monday, that all of those exhibits that have already been identified be sent back into the jury room with the jurors to begin their deliberation, so that they'll understand that we paid attention to what they were wanting to see. They'll have it back there if they want to see it, but we don't have to slow down the process by having them look at it now and then perhaps requesting the same things again once they begin their deliberations.
Well, I take it the earliest that they are going to deliberate would be Monday.
Yes, sir. That's why I said we don't even have to do it tomorrow. We could just do it sometime the rest of the week.
Well, I wanted to tell them that for a reason also, because I actually have a note from a juror, and without reading through all that, I don't think that's necessary. Mr. Deputy, if you would just show the note to the lawyers before we send for the jury. As you read that note, she may very well be gone Monday before the time she's requesting it. If we stick to our regular schedule, she would be gone. Okay, now for all practical purposes, I'm telling the jury we'll see them Monday morning at Thursday morning at 9:30.
Yes, sir.
For the closing arguments. Now we are going to meet tomorrow. The lawyers are going to meet tomorrow morning at 9:30 to clear up the jury instructions. All right, is there anything else you all want to tell me at this point? All right, Mr. Deputy, if you'll bring them out, please. All right, members of the jury, we've looked at the documents that you all have completed, and you've given us an idea of the exhibits that you would like to see. And the court in its discretion will allow you to see those documents, but I'm going to have to change at my discretion the timing of you seeing those documents, because I think there are so many documents that it will be unreasonable and unmanageable for the court to get them to you before the jury arguments. So what we're going to do, we're going to collate all the exhibits, the things that you marked, the requests that you've made. We're going to have the clerk identify all those documents, exhibits that you do want to see. And we were going to give you an opportunity after the jury arguments, when you're deliberating, to ask for additional documents or exhibits, which you would have been in your right anyway. So you're not losing any particular rights. There's no exhibit that you haven't requested already that will not be shown to you. And you still have the right later on to make additional requests for other exhibits, but it will just happen. Your examination of those documents and exhibits will happen during your deliberative process, which will be after the lawyers have made the arguments to you and after the court has given you instructions. So with that in mind, I'm getting ready to excuse you until you hear the final arguments. Now, I need to have you back Thursday morning at 9:30. And at that time, with some instructions that I'll give you on that particular date, you will hear the argument by the defense counsel, who will go first. And I'll tell you more about that on Thursday. And we will be on our regular schedule on Thursday from 9:30 to 11:30. So that shouldn't be a problem as far as your ability to get here or stay here. And the lawyers are well aware of the length of time they have to argue. You will hear the state's argument, which will be the final argument, 9:30 the next morning on Friday morning. All right. Now, I've got your note, Ms. Farrell, as to what your situation is on that Monday. It is the intent of the lawyers to continue with the schedule that we have now, at least through the arguments. So the earliest you could deliberate would be on Monday. And they intend not to go past the time period we're already doing. So if that's the case, it shouldn't be a problem for you. But you and anybody else who thinks you have scheduling problems, continue to tell us what those situations are. (9:30 to 11:30) on Thursday. I was just trying to indicate the normal schedule that we would go to. We'd break for lunch at 11:30. We'd come back and still have the afternoon schedule, but we would leave by 3. I just didn't say all of it. That's what I meant. All right. Is there anything else for me to counsel? Anything we didn't address that you want to address?
No, sir.
All right. With that, then, I'm going to excuse you. I'll see you 9:30 of this trial. I'll keep an open mind. Don't decide the issues in the case. Still continue not to read about the case. Don't watch TV about the case. Don't do any independent research. We'll see you 9:30 Thursday morning.
Muted. Okay, I'm not muted now. Good morning, Al. We're not going to be done with this today, y'all. Dang it, it's almost 3:30, and Rudolph's closing argument is 3.5 hours long. So we're not going to get through it, but we'll start it.
The evidence has already been presented. The evidence has been the sworn testimony that you have heard presented by the witnesses, and any documents or exhibits presented. That has been the evidence. Although these arguments are not evidence, they are nonetheless important. This is an opportunity for the lawyers to be persuasive with you, try to convince you that their version of the facts is the correct version. Do
you guys want to skip this part to save some time? Where he's just reading the instructions to the jury? Elle got here just in time.
True version. The version that you should adopt and accept when you return to the deliberation members of the jury. You will first hear the
You'll see something else here. I'm going to show it to you. Heard Mr. Rudolph talk with you about the fact that we didn't have a weapon. That's true. We don't have the actual implement that Mike Peterson used to cause this injury. Wounding, lacerations, the back of Kathleen's head. But we have an identical weapon. Where do we get it? Kathleen's sister Candace gave several family members a blow poke, just like this one, to several members of the family. She gave one to Kathleen. She gave it to Kathleen when she was originally married to Fred Allen. Kathleen had this in a home for years and years and years. We will show you photographs where the blow poke that's identical to this was in the home. But mysteriously, December the 9th, it's gone. Now you will hear expert testimony, and it will describe how this implement, just like it, can cause these injuries. It's hollow, it's white, easily used. When we continue to this or something like this, it's the article that was used to inflict these wounds.
That was, as you probably all recall, Mr. Hardin's opening statement almost 3 months ago. It's hard to believe. It's been, maybe not for you, it's not hard to believe, but it's been 3 months. And I'm sure you remember that he stood up with State's Exhibit 72, and he told you that something identical to this is what inflicted the lacerations that he also showed you pictures of on Kathleen Peterson's scalp. And now it's 3 months later, and what do we know? Well, we know that the blow poke is not mysteriously missing. It was in the basement of Michael Peterson's home, and it's been introduced as Defendant's Exhibit 280A. It wasn't missing, it just wasn't being used anymore. How do we know that? Well, there were photographs that we showed you. And you can see the canes up next to the fireplace. That one was taken, I believe, in '99. Then there was another one. That one was taken, I believe, November of 2000. Again, you can see the canes. The blow poke wasn't missing. It was just downstairs. We also know for an absolute fact, if there was any question, that this Exhibit 280A is in fact the blow poke that Ms. Zamperini sent to Kathleen Peterson back in 1986. How do we know that? Well, we know that, and you remember that initially when we brought this in, Detective Holland was being questioned by Mr. Hardin, and he pointed out there were some differences. For example, the screws here, which we didn't have on this one. And so I guess if we were trying to be funny and match what Mr. Hardin had said was the identical one, we would have gone out and bought one like this, and then we really would have been in trouble, because guess what? It's not identical. It has little grooves inside that you screw the thing into. How do we know all that? Well, we know that because Zamperini had the other two people who got this blowpoke from her in 1986 sent them to the district attorney's office. Because I think there was an assumption made that, well, we hadn't found the real blowpoke. It must have been missing. We must have done a switcheroo. And so I guess the assumption was that if they found the other two, it would prove that we had done a switcheroo. Well, there's no switcheroo. There's no little screws. It matches exactly. This is the blowpoke that was sent to Kathleen. Most importantly, what we know about 280A is that it was not used to beat Kathleen Peterson to death. Every one of the state's witnesses who looked at this, Art Holland, Deborah Radish, Dr. McElhaney, they all agreed that if this thing had been used, actually at that point I think some of them were, I guess with Deborah Radish we were talking about this one, but with Art Holland, he said that if you hit somebody with this, it'd be mangled. And I think Dr. McElhaney, I showed him this. He was a state's witness. I had no idea what he would say. I mean, he could have said, well, looking at this tip here, that looks like it's the result of a beat. No idea what he would say. And he was an honest witness, and he took it in his hands, and he looked at it. And he testified, state's witness, this was not used in a beating. And of course, common sense tells us that, because when you pick this up, you can just imagine what would happen if you hit somebody over the head with this. It'd be bent, it'd be dented, mangled, whatever word you want to use. What else do we know at this point, 3 months after the openings? Well, we know from undisputed evidence that Kathleen Peterson was at work at Nortel on Saturday, December 8th, 2001. She hadn't been laid off. She hadn't been optimized. Nothing had happened. She had gone to work that day just like she had for years and years and years. We know from undisputed evidence that around 10 p.m. that night, Christina Tomasetti came to the house. She was just a friend of Todd Peterson's. She was coming to meet him to go to a party. No big deal. She walked in. She knew Mr. and Mrs. Peterson. She saw them sitting in the den, watching a movie, drinking some wine. I think she said in her statement that she saw Mrs. Peterson and Mr. Peterson. I think she said she saw Mr. Peterson coming back in with a bottle of wine, and we're watching a movie. Nothing going on. No tension, no arguing, no anger, nothing. A night at home with a movie. We know that 11:08 p.m. Helen Prisslinger talked with Kathleen Peterson. How do we know that time? We know it from the phone records. Saturday, December 8th, 11:08, Brampton, Ontario, 4 minutes. So from 11:08 to 11:12, and Helen Prisslinger testified here, and she said it was a normal conversation. She could hear Michael in the background. Kathleen saying, hey, could you tell me what your email address is? She needs to email me something. My computer's at the office. Nothing going on. We know undisputedly that on that evening, at whatever time, Kathleen Peterson had been drinking wine. She had taken Valium, somewhere between 5 milligrams and 15 milligrams. And those of you who are nurses or those of you who have taken Valium know that 5 milligrams is a pretty hefty dose and 15 milligrams is a mighty big dose. She had been taking Flexeril, and if any one of you have ever taken Flexeril, you know what that does to you. and she was taking an antihistamine. And she was taking them all together. And those have what's called a potentiating effect. Each one adds to the effect of the other. 1 and 1 equals 3. 1 and 1 and 1 equals 5. 1 and 1 and 1 and 1 equals 7 or 8. We know that at least 30 minutes before my...
That's called a synergistic effect. Where did you go to nursing school, dude?
Michael Peterson found Kathleen and called 911. She had lost enough blood to cause those red neurons in her brain to begin to form. We know that from Dr. Bolden, from Dr. Snell, from Dr. Leedsma. There's no dispute about that. We know, perhaps most importantly, that the injuries that Kathleen Peterson sustained were not consistent with the kinds of injuries you generally see when someone is beaten to death with a blunt object. How do we know that? Well, I'll get into it in a little bit more detail later, but we put up some summary charts. And you don't have to take our word for it. If any of you want to look, all 257 autopsies are right here. Nothing's hidden. You don't have to take our word. You can go and check us. Anyone who wants to, check us. 257 autopsies. Multiple impacts in 143. Well, we know that Kathleen had multiple impacts. Out of those 143, skull, facial, and other fractures, 133 out of 143. That's just good common sense. You get hit multiple times with something like this, and you're going to get a fracture. It may be a skull fracture. It may be a fracture of the jaw. It may be a fracture of the eye. It may be a fracture of the rib. You're going to get a fracture if you get hit multiple times with a blunt, hard object. Out of the 10 cases where there were no skull, facial, or other fractures, traumatic brain injury. Now, I'm not talking about a subarachnoid, which you can get from falling down, hitting your head lightly on a wall. I'm talking about subdural. I'm talking about brain contusions, coup or contra coup, edema, swelling of the brain. Every single case where there were multiple impacts, you either had skull, facial, or other fractures, or traumatic brain injury. Every single case. That's not a representative sample. That's every case in North Carolina since 1991. And Kathleen Peterson had none of that. None. And of course, there is absolutely no dispute that Michael Peterson never, ever acted violently or meanly or abusively towards Kathleen. You may remember my opening statements, I used the term soulmates. Well, that wasn't my term. That was a term that her sister, Candace Zamperini, used with the police in December of 2001 when she first came down, when she was saying, there's no way. I know these people. I know this relationship. Before she saw the autopsy photos, and we'll talk about those in a little while, we'll talk about the power of the autopsy photos and what that does to folks. We talked about it in voir dire. We talked about it in opening. We'll talk about it again. But before that, when she was just talking about what she knew about their relationship, her sister had found her soulmate. And don't all of us wish that we had that to live for. Now, all of that put together, I would submit to you, clearly shows that if you're balancing You know, which is more likely? Did she get beaten to death by Michael Peterson or did she fall? It's far more likely to conclude, based on all of that, that she fell. Can I tell you, can anyone tell you how that accident occurred? No. And we haven't tried. It would have been junk science. It would have been trickery for me to come in here or one of my experts to come in here and say, I can look at these injuries and tell you all exactly the sequence, how this happened, how many times she hit her head here, how many times she hit her head there, how many times she got up, how long she laid bleeding on the ground there, how long it took for the blood to form sufficient to cool enough so that she could step in it and get it on her feet. We can't do that. And we didn't try to do that. What we did do, what Dr. Bandak did, was to take Deborah Radish's opinion. And remember, her opinion was, these injuries are not consistent with any fall that I can even imagine. That's what she said. I said to her, well, what kind of fall were you thinking about? You know, were you thinking about a fall just down the stairs, tumbling? Were you thinking about one where the person gets up and falls back? Were you thinking about one where the person goes into concussive convulsions? What kind of fall were you thinking about, Dr. Radish? And she basically said, any fall you can imagine. Couldn't be. Well, our job at that point becomes, let's see if that's accurate. Let's see if that's true. And who do you go to? You go to a biomechanical engineer. You go to the person who ran the head injury department for the United States Department of Transportation for years, who actually does teach at George Washington University, who actually does go around and produce papers that are published in peer-reviewed journals. And what he did was to sit down with Dr. Lietzma, the forensic neuropathologist, and say, okay, could these injuries have happened in an accident scenario? And he described to you one such accident scenario that could account for these injuries. And he showed you an animation, not some Disney cartoon. It was an animation that was designed to illustrate his expert opinion about how this could have happened. He tried to take into account the bruises that were on the body. Not that this is necessarily how they were occurred, just it could have been. He tried to take into account the locations of the different lacerations and their shape and their orientation. He tried to take into account the fact that there was blood on the bottom of her feet. Now, could we say how long she was lying there? No. But we know she was lying there long enough to get enough blood pooled so that she would step in it. Can we say she stepped right there? No. We're just trying to show you that Dr. Radish's testimony is not accurate. So thank you. Could the lacerations and the bruises have been caused in a scenario like that? Absolutely. Even Dr. McElhaney on the witness stand said, yeah, those could happen. He disagreed about how many impacts there might be because we had a disagreement about where her head might have landed. But he said there clearly be enough force from a fall from that height to cause those kind of lacerations. And what you see there are complex stellite-type lacerations. They're not those straight lacerations that you saw in, I think it was Defendant's Exhibit 240, the picture from that night book of someone who had actually been hit with one of these things. And what you saw were just straight lacerations. These are complex, just like stellite, like you saw in that Spitz book with the little star shape. And Dr. Bandak, I think, did a reasonably good job explaining to you how that happens and why it happens, what the mechanisms are, and I won't try to repeat it. Could this have happened in numerous other ways? Of course it could have, and Dr. Bandak told you that. He didn't try to get up here and say, I figured it out. Could Kathleen Peterson have hit her head on step 16? Yes. Could she have hit her head on the chairlift? You were at the house. You saw how far out that sticks into the stairway? Yes. Could she have had a concussive convulsion after hitting her head and hit her head a few more times? Yes. Dr. Buds hadn't really considered that possibility because he didn't know much about those. But he clearly conceded that that's a real thing in the medical literature. Could she have suffered another loss of vision? There was testimony that she had a loss of vision within the last few months. While she was walking up the steps and then been staggering around? Yes. Could she have been dizzy and disoriented from wine and Valium and Flexeril and had trouble getting up? Sure. Could she have gotten up more than once or tried to and fallen back more than once? Of course. These are accidents. We sometimes talk about freak accidents. They happen. And what the state has tried to do with this is to take Dr. Bandak's testimony and say, put it forth as, well, the defense is saying this is the way that the accident happened. And then what they've tried to do is to shift the burden of proof. They've tried to say, well, this is what they say happened, and we can show you that our experts say it didn't happen that way. Now, of course, Dr. McElhaney didn't quite say that, and we know what happened to the other person, but let there be no mistake. The fact that we try as best we can within the bounds of good science to show you how this could have happened, to show you one of many possible scenarios, does not shift the burden of proof in this case 1 inch. Doesn't shift it at all, the fact that I introduced that animation or Dr. Bandak or anything else. We talked about this in jury selection. I talked, I think, with every single one of you, probably longer than you wanted to, about a lot of things. And among those things was burden of proof. And we talked about the fact that it's the state's burden to prove beyond a reasonable doubt that Michael Peterson beat Kathleen Peterson to death in a stairway with a blow poke, as they alleged, on December 9th, 2001. Beyond a reasonable doubt. We talked about this. It has to be based upon reason and common sense. It can arise from the evidence that's presented. It can arise from the lack of evidence or the insufficiency of the evidence. And what is it? It is proof that fully satisfies, fully satisfies or entirely convinces you. We talked some about that in opening statement, and we talked some about that in jury selection. That, ladies and gentlemen, is no mere technicality. That's not something that we sort of wink at and say, oh yeah, but let's really figure out what happened. No, that is bedrock. That's what sets apart our system from every other system in this world. And its purpose is absolutely clear. Its purpose is to prevent innocent people from going to prison, from being convicted based on speculation and guess and conjecture and assumptions, coincidences. It hasn't worked perfectly. We all know. In recent years, there have been a lot of people exonerated just from death row alone.
Objection. Sustained.
It hasn't worked perfectly, but that's the principle. And that's what it's designed to do. And each of you promised me, as I remember,
overruled,
that you would hold the state to that burden of proof. I remember I asked each one of you, if you had a reasonable doubt at the end of this case, would you have the courage of your convictions to come out here and look at Mr. Harden and Ms. Black and say, I know you tried your best, but I've got a reasonable doubt. And every single one of you assured me and assured Ms. Peterson that you would do that. And I remember those promises, and I know you do too. I wouldn't be doing my sworn duty if I took on more of a burden than the law requires me to do. And you wouldn't be doing your sworn duty if you took on any less. And so the real issue in this case is not whether we have proven that Kathleen Peterson died as a result of an accident. No, that's not our burden. The real issue, the one that you need to focus on, is whether the state has proven beyond a reasonable doubt, with proof that fully satisfies and entirely convinces you, that on the morning of December 9th, 2001, Michael Peterson beat Kathleen Peterson to death with a blow poke in that narrow stairway that all of you saw just a few weeks ago. That's it. That's the issue. What I want to do this morning and this afternoon, to the extent we get into it, is to focus on the reasonable doubts in this case. And since we're in the age of David Letterman and lists of 10, I've come up with a list of 10. It's not meant to be inclusive or exclusive. Some of you may have others that occur to you. But I will suggest to you that if any one of these 10 raises a reasonable doubt in your mind, if any one of these says to you, I'm not entirely convinced and fully satisfied, then under your oath, there is only one verdict that you may return. The first reasonable doubt. The missing murder weapon is missing, and it wasn't used in a murder. It doesn't get much simpler than that, does it? The state contended in its opening statement that they would prove that the blowpoke was, as Mr. Harden put it, mysteriously missing. This blowpoke was crucial. I mean, that wasn't just a happenstance. He didn't just settle on that for no reason. Why was this blowpoke so crucial to their case? You heard it from Deborah Rash. You actually heard it from Mr. Harden in his opening just a few minutes ago. He needed something that was light enough to cause the lacerations, but not so heavy as to fracture the skull. But he was sort of walking the tightrope. And this was the tightrope he was walking. What happened here, and I'll get back to it later on, is that the state developed what is called tunnel vision. And tunnel vision is just exactly what you think it is. It's when you put your blinders on and you don't see anything except what you want to see. They just ignored the fact that it wasn't missing. It just hadn't been used for several years. Should they have known that? Even when Mr. Hardin gave his opening? Sure, they should have known that. How should they have known that? Well, one way they could have known that would have been to interview the housekeeper prior to a couple of Saturdays ago. I mean, how incredible is that they are coming in, pinning their entire murder case on a blowpoke based on Candace Zamperini saying that the last time she saw it was Thanksgiving of 1999. And you don't go and interview the man who cleans the house twice a week? I mean, do you really think Art Harlan was telling him the truth when he said he had been looking for him and couldn't find him? Does that strike you as credible? If they had done that, they would have heard what you heard. It wasn't in the house. It wasn't being used. What were being used were the canes. So they would have known that 2 years ago. Or if they didn't want to go to the trouble of doing that, they could have sat back and reread the email that Kathleen's daughter, Caitlin, sent to Detective Holland. Can we get the date on there, please? Go up a little bit. February 13th, 2002. Detective Holland. My aunt wanted me to let you know about the fireplace tools in the house. As I remember it, she goes on to describe it, shovel and broom. I know that there were tongs and one prong on one side and two on the other side. We had a longer brass blow tool that was about a half-inch thick. And I honestly cannot remember when the last time I saw them was. But I don't think they were there by the fireplace in the kitchen all that recently. That's what she said. She didn't say, I saw it there when I came home for Thanksgiving and they weren't there Christmas. She said she hadn't seen it there for quite some time. And because of the tunnel vision, that was simply ignored. Now, is it surprising when you look at this that it was sitting in a dark basement covered with dead bugs and cobwebs? Not really. When you take a look at it, it's got sort of a little bit of paint on the top here. The tip's missing. It's got some discoloration. It's not exactly a pretty piece to keep by your fireplace in the kitchen. And I know that some of you may be saying, well, gee, how come you didn't give this to him before the case even started? I mean, why let Mr. Hardin get up there and talk about a blowpoke if you know you got it? Well, we are not given the benefit of seeing this, the alleged replica of the murder weapon, until May 16th of 2003. The trial was already underway. And so it's not surprising that until you know what it is you're looking for, it's a little hard, if you're innocent, to figure out what you're supposed to have killed your wife with. Nor, frankly, is it surprising that this was not found in the basement by the police. Why do I say that? Well, remember, in December, Campen did luminol going down those basement stairs, but he only went down 5 or 6 stairs. Why? Because he saw no indication that anyone had gone down there, and so he stopped. Moreover, to the extent that anyone after that looked downstairs in that basement, and you heard from everyone that it was dark, there's no overhead lights, you looked with a flashlight, basically. The police didn't know what they were looking for in December of 2001. That was before Ms. Zamperini had come up with this notion that it must have been this blowpoke that was missing. They didn't know what they were looking for. You may have noticed in one of the videos, for example, there was a stick lying in a bedroom. They didn't pick that up. They didn't pick up the glasses. They didn't pick up the sandals. They didn't pick up a bunch of other items. The shoe, the phone, the towels. Why would they have picked this up, laying in a corner with dust and cobwebs on it, looking like a curtain rod? And of course, in June, when they went back to the house in June of 2002, how long did they spend down in the basement? You heard from Art Holland the other day, just a couple days ago, that they did the basement and the bomb shelter at the very end at 11:15 at night with flashlights for 10 minutes. And what they were doing was taking measurements. But regardless of where this was in December of 2001 or June of 2002, assume that Mr. Holland's right and this wasn't in the basement either time. What difference does that make? What earthly difference does that make? The question is, was this used to kill Kathleen Peterson or wasn't it? And you remember what we offered when we brought it into court. We said, it's in a plastic tube. Don't take it out of the plastic tube because you can go test it. You want to test it for DNA? We'll consent. Test it for fingerprints? We'll consent. Presumptive test for blood? We'll consent. Not just on the outside. Cut it open. See if there's any blood inside. Do whatever you want to do. And what we heard back was, well, it'll take 6 months to send this to the SBI to do DNA testing. Well, and then we find out after that that the state sent a stamp that Margaret Ratliff had writ on a letter, unbeknownst to her. No notice to her that they were doing paternity testing. But they sent a stamp that she licked to LabCorp just a couple of months ago to see if Michael Peterson is her biological father. That would have been quite a bombshell to drop on her in this courtroom. Unfortunately for them, it didn't quite work out because he wasn't. And how long did it take them to do that DNA testing? Did it take them 6 months? 8 days. So if they had wanted to, 8 days ago, we'd be sitting here right now with the DNA results. But we don't really need that, do we? Because we know why the state didn't need to test this. Because they knew exactly what we all know now. This is the blowpoke, and it isn't a murder weapon. And so we get back to reasonable doubt number one. The missing murder weapon isn't missing, and it wasn't used in a murder. Reasonable doubt number two. There is no credible motive, and you don't just decide to kill your wife for no reason. Now, again, this is something we talked to you about, everyone talked to you about in jury selection. Mr. Harden, Ms. Black asked each of you, do you understand that we don't have to prove a motive? We think there's one, but we don't have to prove it. Each of you said, yeah, you understood that. And then I stood up and I told you there's two sides. And in fact, what the jury instruction says is, well, if they don't prove one, you can consider that. And you'll hear the judge on Monday instruct you. Proof of motive for the crime is permissible and often valuable, but never essential. Well, and that's all true. And then we go down to the bottom. The absence of motive is equally a circumstance to be considered on the side of innocence. Now, of course, you don't have to decide that Michael Peterson is innocent. We'll talk about that in a few minutes. You know, the verdict is not guilty. In other countries, it's not proven, which may be the more accurate title. You know, not proven beyond a reasonable doubt. It's not we decide you're innocent, it's we decide it's not been proven beyond a reasonable doubt you're guilty. And the absence of a motive can be taken into account in determining whether or not there's a reasonable doubt. Now, Mr. Harden can get up here tomorrow and talk to you for a long time about how he doesn't need a motive. But he's also probably going to talk to you about your common sense. And your common sense tells you that you don't decide to kill your wife in a first-degree murder for no reason. People act for reasons. We all know that. And so the state has been seeking a motive. But they did it sort of backwards. Instead of looking for a motive, and then if they found one, deciding whether or not to charge Mr. Peterson with first-degree murder, which is the way I would submit to you the system is supposed to work.
Objection. Overruled.
What they did was put on their blinders and their tunnel vision. And they got an indictment within 11 days, record speed, called the grand jury back from their Christmas trips just for that purpose. And then, once they had their indictment, they went in search of a motive. You know, I'm reminded of Alice in Wonderland. There's a great little line in there when the Queen of Hearts is having a trial over the stolen tarts. And she says, all of a sudden, sentence first, verdict afterwards. And that's sort of what happened here. Indictment first, look for the evidence afterwards. And I submit to you that's not the way it's supposed to work. So what do we know about motives? Well, the first one they trotted out was money. Actually, they have two, you know, sort of the old standbys, sex and money. Money was the first one. And with regard to money, again, with their tunnel vision, the state simply ignored what Kathleen Peterson's own relatives knew at the time of her death. What do we know? We know that Candace Zamperini was asked by the police about this. Question, did you tell the police that you knew of no financial issues between Michael and Kathleen? Answer, the night I arrived in Durham, yes. And you knew of none. That's what you told the police, correct? Answer,
Of that moment, I knew of none. There's no ambiguity about that, ladies and gentlemen. There's nothing hidden about that. Ms. Zamperini had no motive to lie to the police about that. Her sister was lying there dead. There was no financial motive that really existed, but the state went searching. So, although they did no investigation of finances before the indictment, after the indictment, they send out subpoenas to get financial records, most of which you'll see if you look at them, were actually obtained in 2003, once this trial was scheduled. A strange time to be looking for the motive, I would submit to you. Agent Young, the FBI agent who came in and testified about the alleged motive, wasn't even contacted, I think he said, until March or April of this year. The expert on intestate succession law, I think his name was John Hubbard, the lawyer, he wasn't contacted until Agent Young was on the stand in the middle of the trial. And I've tried to understand the state's theory, and I think, and maybe Mr. Hartnell will write us tomorrow about this, I think the state's theory boils down to this. Because Kathleen Peterson might lose her job in the future, Michael Peterson decided to beat her to death in the stairwell of their home on that particular night. That, as best I can tell, is a synthesis of their theory. But in their tunnel vision, they ignored the facts that didn't support their theory. And that's what tunnel vision causes you to do. For example, and I'll just go through a list, and maybe at that point, if you all want, we can take a mid-morning break. They ignored the fact that Kathleen Peterson had recently gotten a raise from Nortel, that she had recently been given a substantial bonus from Nortel, despite the fact that Nortel was having hard economic times, that she had incredible evaluations every single year, that she had had a conference room named after her, the only executive in RTP to have had that honor, that she had no particular reason to think she would be laid off, and that she had no intention of quitting, as she expressed to her sister, regardless of the stress. She was going to stick it out. They ignored the fact that she had a severance package, that if she was laid off, she wasn't going to be out on the street. She was going to have months and months and months of benefit and salary. They ignored the fact that Michael and Kathleen had literally hundreds of thousands of dollars in liquid assets, assets in bank accounts and retirement accounts that you could get at if you needed to quickly. They ignored the fact that she had deferred 80% of her income for the past 2 years. 80% of $140,000. She was living on what? $20,000 salary a year. And the rest of it was being deferred. And they had that available. They had real estate that they could sell, including one house that had no mortgage on it at all. You could certainly go and get a loan on that. They had a net worth of over $2 million. Tough times in Durham. $2 million, and that didn't count the furnishings and the antiques that at least some of you saw when you went to that home. And I submit to you that it may not have been the purpose, but you can't have gone to that home and looked around what was there and thought these were folks who were in financial trouble. They ignored the fact that, we heard about this college scholarship that was in trouble for Margaret, but by the fall of 2001, it had been reinstated. So what's the problem there? Credit cards. I'm sure you'll hear about that tomorrow. Except that the credit card debt had gone down in the last year.
They had always had big credit card debt. Even when they had millions of dollars in stock options, they had chosen not to sell the stock to pay off the credit card debt. Is that stupid? I might think it is. You all might think it is. Maybe it was. But that was a choice they made, Kathleen and Michael together. And if anything, that situation had improved somewhat from the previous year, if not gone backwards. They introduced a letter from Michael to his former wife, Patty, asking her to maybe contribute something towards their adult son's needs. So, they introduced a letter from Michael to Margaret Martha's uncle, who's a doctor in Memphis, asking him if he can contribute $5,000 towards a tuition and room and board bill that exceeded $30,000. So, he agreed to do it. How did that create stress? They ignored the fact that Michael was in the process of writing a new novel. How do we know that? The computer folks found it on the computer. But maybe most importantly, in their focus on Kathleen and her supposed concerns about her job and about the situation in Nortel, did you hear a single word that Michael was concerned? Did Kathleen say to Candace Zamperini or Laurie Campbell, boy, Michael's put me under a lot of pressure. Michael's really worried about the money. Michael's really worried about the job. I mean, if we're talking about motive, it's Michael's state of mind that's relevant, not Kathleen's. Kathleen could have been worried from here to forever. If Michael didn't care, how does that provide a motive for murder? How? Maybe Mr. Harden can explain that to you tomorrow. There was not a single bit of evidence presented at any time in this trial of any ongoing stress between Michael Peterson and Kathleen Peterson over anything, financial or otherwise. I don't know that I've ever heard of a murder trial of a spouse accused of killing another spouse where there's not allegations of some love triangle existing, or someone goes out and buys insurance, or someone's running up debts and they need money. None of that. None. Zero. Ask yourself how often that happens. And all of it is consistent with what Christina Tomasetti described about the atmosphere in the house that night, that very night. Two people in love, watching a movie, drinking wine in their home. Having failed to establish a financial motive, the state moved on to the other standby, sex. Now, I submit to you that the testimony about gay pornography on the computer and bisexuality was masquerading as motive, but what it really was an appeal to bias. What it really was an attempt to get to your emotions and say, oh man, God, guy's bisexual? Guy has pornography on his computer, yuck. That's really what was going on. I think we all probably know that. Because what is the motive there? I mean, maybe if there was a person who he was seeing in a romantic relationship, you could maybe figure out a motive, but there wasn't. They ignored the fact that Michael Peterson had zero contact with Brad or Brent or whatever his name was for months before Kathleen Peterson died. They ignored the fact that even though they went through his computer hard drive And I venture to say that most of us probably wouldn't want anyone else going through our computer hard drive. Even though they went through his computer hard drive, they found nothing else of contacts with male or female in the months before Kathleen Peterson died. No meetings, no rendezvous, no ongoing relationships. They ignored the fact that those images of homosexual sex, as distasteful as some of you may have found them to be, and I understand that, and that's your right, and I'm not here to criticize that at all. As distasteful as some of you may have found those to be, you also heard that those were almost exclusively in what's called temporary internet files. You go to a website, and it gets loaded down so that you don't have to keep going back and forth. I didn't know that. Some of you may not have known that. And that's what they found. Not stuff that Michael Peterson had downloaded, not stuff that he said, oh, gee, I really like this stuff, let me put it on my computer. It was like the New York Times. You go to the internet, you go to the New York Times, you don't keep going back to the New York Times site, your computer automatically downloads it into a temporary internet file. And that's where almost all of those images
still go back to the site.
So what did any of this
It
add
makes it load faster.
to the case?
You don't know what you're talking about.
Really? No evidence that Kathleen Peterson was angry about any of this. No evidence that she was telling people, wow, Michael is, getting gay pornography on his computer and I've had it. Or that Michael Peterson was worried about that happening. The answer is that evidence, and I think you all know this, but I'll say it anyway, that evidence added absolutely nothing to motive in this case. And so what we are left with is, in fact, reasonable doubt number 2. There is no credible motive, and you just don't decide to kill your wife for no reason. The judge asked me to make sure I let you have a break this morning. Your Honor, if you want to take it at this point, that'd be fine.
10 minutes, Mr. Stephen.
Ladies and gentlemen, we're going to take a break. Please allow the jurors to exit the courtroom bar.
All right, Mr. Ross.
Reasonable doubt number 3. Michael and Kathleen Peterson were happily married with no history of violence, and spousal abuse generally doesn't start with murder. Anyone who knows anything about domestic violence knows that statement is true. There's always something that comes before. Maybe it's verbal, usually it's physical. There's something. In opening statements, I told you all that everyone, I think the way I put it was, everyone who knew Kathleen and Michael Peterson knew that they were very much in love and happy.
Objection.
Overruled.
Quit objecting,
And in fact,
Gordon. It's closing
When
argument.
Candace Zamperini spoke to the police in December of 2001, as I indicated earlier,
I told you I'm terrible at geography.
she used the term soulmate. And when she testified here in this trial, you didn't hear her say anything bad about the relationship between Kathleen and Michael. She said she didn't know who he was anymore. And I understand where she's coming from. But nothing bad about that relationship. When Laurie Campbell testified here on rebuttal, nothing about problems in the relationship between Michael and Kathleen. Sometimes the absence of evidence speaks louder than anything that a defendant could produce. You know how long and hard the prosecution has worked on this case. If there was a single witness, one, anywhere, who could say one bad thing about their relationship, you know you would have heard it.
Okay. Overall.
I would have cross-examined, but you would have heard it. No one came in and testified about any problems in the relationship. Not Kayla, who sat here for most of the trial. Not any of Kathleen's co-workers. Not any of Kathleen's friends. There were no 911 calls to the house. You know, oh, never mind, no problem. No, none. No evidence that Michael Peterson was ever verbally abusive to Kathleen. Even when they were out drinking together in public. No one came in and said, oh, well, yeah, this one time when he was drunk, I heard him get in her face a little bit. Nothing. No evidence that he ever threatened her in any way. No evidence that he ever had any inappropriate physical contact with her of any kind. No one, not even her two sisters, testified that Kathleen Peterson ever said a negative word about Michael Peterson or their relationship. And how extraordinary is that? What does that say? I mean, can you imagine? They're together at their mom's house for that weekend in May when her mom's companion had died. They're sharing a room. They're talking about all kinds of things. If there was any problem, you know, Michael's getting testy, Michael's getting short, whatever, she would have heard it. And we know she would have testified to it. Not a single problem. And so instead, what the prosecution points to, they say, oh, well, we've got evidence that what Candace said about them being soulmates isn't really true. We've got Brad. We've got the emails to Brad. That shows that they're really not soulmates, that Candace was really wrong when she said that. But interestingly enough, even in that email, what did Michael say about Kathleen to Brad? And by the way, interestingly enough, he used his real name. I mean, if he's engaging in some activity he's trying to hide from his wife, here's Michael Peterson, ran for mayor of Durham, writing columns. I mean, imagine the liability that would open up for him if he was worried about his wife finding out and some person could extort her. From Mike Peterson, Sunday, September 2nd. I'm married, very happily married, with a dynamite wife. Yes, I know, I'm very bi, and that's all there is to it. What is the only other evidence of marital problem? I mean, they've gone through his computer, soup to nuts, read every email, searching for terms. Remember, the computer expert was in here. Searching for terms. What do they come up with? They come up with an email that Michael sent to Kathleen. I think it was the Wednesday before she died. Wednesday, December 5th. Here's the scoop on the Independent. That was a party that was being held Friday night. There were no invitations, but we can still go. Let me know if you want me to call in. Or we could just show up at the door Friday night. Now, here's what they point to. You looked great last night. I mean, this is a man who's complimenting his wife. If only we hadn't gone to Powell-Inn. Now, I don't think you need to be a rocket scientist to figure out that what he's saying is that he would have rather been home than out at a restaurant because she looked great. And what does he say? Let's work on our marriage tonight. Now, I know that it's the prosecution there, but we're all human beings. I mean, is there any real doubt in any of your minds
that when he says, let's work on our marriage tonight, after he says, you look great, and I wish we hadn't gone to that restaurant last night, that what he's saying is that he'd like to have sex with her? Is there any real doubt about that?
Supposition.
But that because, let's work on our marriage. I suppose Mr. Hart or Miss Black's going to get up here and say, oh, you see, they needed to work on the marriage. There's the motive. There was a problem. Well, what is he supposed to say to her in an email that's going to Nortel Networks? Is he supposed to be more explicit than that? Do you think she probably knew what he was talking about? I think so.
That's supposed to be euphemism for sex. Let's work on our marriage.
So we get back to reasonable doubt number 3. They were happily married with no history of violence, and spousal abuse generally doesn't start.
We already did that one, doofus.
Reasonable doubt number 4.
Oh.
Michael Peterson's grief and shock was sincere, and no one who was there disagreed. And it's the second piece of that I would submit to you is really, really important. There is one thing that everyone who went to the scene of 1810 Cedar on the night of December 9th agrees on.
Even if I took the rest away from
Michael
right
Peterson
now.
was in profound, deep
What would you do?
shock and grief over Kathleen's death. Every single person who was there agrees with that. We don't have his friend saying he was in shock and the police saying, oh, he seemed very detached. Lots of times you hear that in murder cases. Or his friend saying he was sincerely shocked and the police saying, well, he was acting shocked, but you could tell he really didn't mean it. Lots of times you hear that in murder cases. In this case, you don't hear any of that. What you hear, for example, from first responder Rose, who testified months ago, the closer I got to the front door, I could hear a man sobbing. I noticed the patient deceased legs and lower torso, and the husband sobbing, crying over the deceased. Or first responder Ron Page. We found the husband standing over the patient, crying, appearing to try to help patient. We asked husband several times what happened without success. Husband seemed very upset. Or police officer Wilkins. Mr. Peterson appeared to be confused and was walking in small circles and back and forth. Mr. Peterson was visibly upset and was moving back and forth as if he didn't know what to do or where to go.
They have to pay
Heather
for it.
Ritson, the doctor from
They have to
Duke,
pay
and
for it.
I submit to you that once she finishes her residency and gets her MD license, she is in fact a doctor.
They have to pay for the kisses.
She finishes a medical degree, starts her residency, I should say. Todd said to me, please come see my dad. He's in shock. He led me and my boyfriend to the patio, and I tried to comfort Mr. Peterson, who was crying and very distraught. Mr. Peterson approached her, meaning Kathleen, and bent over her, very distraught and emotional. Or Christina Tomasetti. I picked Todd Peterson up at 9:45 p.m. Saturday night. Todd and I sat and talked in the kitchen for about 20 minutes. And then she says, she talks about Michael Peterson about to open a bottle of wine, went back into the TV room, and then she gets to what happened later that night. She talks about walking in. Heather Whitson had already arrived, as well as Mr. Maynard, and Miss Whitson were close family friends of the Petersons. Michael Peterson was shaking and covered in blood. He was very upset and mumbling, "Oh my God."
No one who was at that scene described him as anything other than sincere. You heard every single person. More than I've just summarized for you, there were more. We don't need to go into them. What I just showed you, what I just read to you, covers it. But not a single person said that he wasn't sincere. Now, the state is going to argue, I'm sure, well, why did he say on the 911 call it was a fall? How could he possibly know that she had fell? He was just setting it up. This was part of his staging. Well, the answer is really simple. It's a reasonable assumption when you find your wife bleeding at the foot of a set of stairs in your house at 2:40 in the morning that she's fallen. You don't immediately assume that some intruder has come in and beaten her to death. It's a reasonable assumption. This is a man who just saw his wife and is freaked. What are we expecting from him? But even more importantly than that, if their theory is, and I think it is, that this was all part of his grand plan to divert suspicion away from him, well, why didn't he try to convince anyone when they showed up at the scene and started treating him clearly as a suspect? I mean, clearly he's treated as a suspect. Does he say to anyone at the scene, well, gee, you know, Kathleen had been drinking? She had been drinking. There's no doubt about that. She had a .07. Did he say to anyone, hey, listen, she must have fallen because she was drinking? No. Did he say to anyone, well, she must have fallen because she was drinking and taking Valium? That was true, but he didn't say that. Did he say, well, she was having headaches? Maybe she had a headache and you know, that's why she fell? That would have been true. She was having headaches, but he didn't say that. Did he say, well, you know, she had a loss of vision. Maybe that's what happened when she was walking up the steps. Maybe she had another one of those ocular migraines and just fell. That would have been true, but he didn't say that. Or that she was having dizzy spells. That would have been true, but he didn't say that. He certainly didn't suggest to anyone that she had a stroke. He didn't do a single thing to try to convince anyone of what happened in that stairway. All he did when they arrived was express his grief and his shock and his loss. That's all. And if he was trying to somehow stage this, don't you think he would have said something to somebody that she had been drinking or taking Valium or having dizzy spells, or something to lead the police to think this was an accident, especially when they started looking at him as a suspect. And so we get back to reasonable doubt number 4. His demeanor, how he acted. It was sincere, and no one who was there disagreed. Reasonable doubt number 5. Kathleen Peterson's injuries are not consistent with a beating. No skull fractures, no other fractures, no traumatic brain injury equals no beating. Now, as I said earlier, Deborah Radish and, on rebuttal, John Butts have testified that the location and number and severity of the lacerations on her scalp are not consistent with an accident. That's their testimony. That's their theory. We told you about that in voir dire. And we told you in voir dire, you probably remember that it was going to be conflicting expert testimony. And I think Mr. Harden said in his opening, well, Mr. Rudolph says this is going to be a battle of the experts. I couldn't disagree more. Well, I think that's what's happened. But we don't have to prove that there was an accident. the state has to prove beyond a reasonable doubt that Kathleen Peterson was beaten to death. And so, as I said earlier, the appropriate question for John Budds and Deborah Radish to be asking and answering for you all is not whether these injuries are consistent with a fall. The appropriate question for them to be asking and answering for you all is whether these injuries are consistent with a beating. Because if they're not, then there's a reasonable doubt about this case. Pure and simple. And so, as I indicated earlier, to answer that question, what we did was to write a letter to John Budds and say, "Dear Dr. Budds, we'd like a list of every single homicide case in the state of North Carolina going back to 1991, 10 years before Kathleen's death, that involved blunt trauma injury to the head. Give us a list." And after we worked out the logistics, we sent people there to copy every single autopsy. And then we read every single autopsy. And we created charts, which are in evidence, for every single case. Multiple impacts or no multiple impacts. Skull fractures or no skull fractures. Other fractures or no other fractures. Traumatic brain injury or no traumatic brain injury. For every single case, 257. And then we had Dr. Leitsma prepare the summary charts. And I went through that one earlier, but if you remember, we did it both ways. We started one chart with the multiple impact cases, and then we did it another way. We said, okay, well, let's take the 257 cases and let's look at it another way. How many involve skull, facial, or other fractures? 215 out of 257. That leaves 42 out of 257, less than 10%, that didn't have any fractures. That might be a reasonable doubt in and of itself. But then you look at those 42 cases, and how many of them had traumatic brain injury? And again, we're talking about not subarachnoid. We're talking about subdural, coup, contra coup, that kind of stuff. 34 out of the 42. So we're left with 8 cases out of 257 that didn't have skull fractures, other fractures, or traumatic brain injuries. That by itself might be a reasonable doubt. But then you look at how many of those cases had multiple impacts, like Kathleen Peterson. None. Not a single one. No case in the history of North Carolina's medical examiner's office going back to 1991 involving a beating death with blunt trauma to the head has there not been skull fractures, other fractures, or traumatic brain injuries. And if that's not a reasonable doubt in and of itself, I can't imagine what a reasonable doubt is in this case. What are the kinds of injuries you see? We made a list. You may get to see it. You may not. Skull fracture? No. Fractured facial bones? No. Fractured ribs? No. Marks on skin consistent with a blow poker. I mean, if you're going to hit somebody with something like this, you're not just going to hit them on the head. You're going to hit them, you're trying to kill them. You're going to be hitting them all over. Is there going to be a mark or marks? No. Subdural hemorrhage? No. Epidural hemorrhage? No. Swelling of the brain? No. coup or contra coup contusions? No. Injuries to the hands or fingers consistent with being beaten by a blowpoke. Let's talk about that for a second. You heard Dr. Radish say that she thought there was some defensive wounds. And then you heard her say, well, did you say that in the autopsy? Oh, no, I never used that term in an autopsy. Of course, then we showed her 4 autopsies where she had used the term defensive wounds. But put that to one side. Imagine somebody defending themselves from someone hitting them with something like this on the back of their head. What are you going to do with your hands? They're going to be just like that, over the back of your head, protecting it. And so what's going to happen to your fingers and your nails when you're being hit with something like this? You all know what's going to happen. You're going to have fractures. Your fingers are going to be broken. Your hands are going to be broken. Your wrists are going to be broken. Some bone, these are not big bones. Some bone is going to be fractured. Did we have any of that? No. We didn't even have a chipped fingernail. Think about that. Defensive wounds from a blowpoke, according to Dr. Radish, and you look at the fingernails, there's not a chipped nail. How does that happen? I would suggest to you that there is no coincidence to the fact of those statistics. When you have multiple blows being struck from someone who wants to kill somebody, you're going to get skull fractures or facial fractures or rib fractures or brain injuries, because you don't sit there, you don't say, I'm going to kill somebody. You know what I'll do? I'm going to hit him on the head just hard enough to cause a laceration that'll cause him to bleed to death, but not cause any other injury so that people will think that she fell down the stairs. Is that credible? Is that really a theory? No. You're going to beat somebody to death, you beat them to death. And you end up with the kinds of injuries that everyone who has been beaten to death in North Carolina since 1991 has. The kind of injuries that Kathleen Peterson does not have. And so if we go back to Occam's razor, you remember that Agent Deaver talked about Occam's razor. And he said it was, keep it simple. That's not quite what Occam's razor says. What Occam's razor says is the simplest explanation is generally the correct explanation. And the simplest explanation for the kinds of injuries that Kathleen Peterson had and the kinds of injuries that she didn't have is that she fell. That she had an
Okay, I know we're trying to get through this, so I'm not pausing too much, but if she had that much on board, the Flexeril, the antihistamine, the Valium, the alcohol, the first hit of whatever he did hit her with could have knocked her unconscious. That's why she has no defensive wounds.
accident, not that she was beaten to death with a blow. Judge, that's a place where I'm getting ready to go into another topic if you want to stop there.
All right, members of the jury, we'll take our lunch break at this time. Remember the instructions I've given you throughout the course of this trial. Even at this point, after all the evidence has been completed, keep an open mind about the case. Don't discuss it with the other jurors or anyone else. Stay clear of the parties involved in this case. Do not watch TV or read about the case in the newspaper. Don't do any independent research or investigations, and we'll see you at 12:45.
Okay, this one's 2 hours.
6 on my list.
I'm not going to make it through
The bloodstain evidence is not consistent with a beating, and the state's real expert did not dispute this. As a part of our defense, we called two of the most well-trained and competent forensic scientists I think that exist in this country, Dr. Henry Lee and Major Tim Pombeck. Major Pombeck, as you know, is currently, while he was testifying here, the head of the Division of Forensic Services of the Connecticut State Police. In other words, he is an active law enforcement officer who had absolutely nothing to gain by testifying here. And I'm sure that any of you with law enforcement backgrounds or knowing people in law enforcement will know that he probably had a lot to lose, a lot to risk, a lot of grief to endure by coming here and testifying honestly. Each of them testified in no uncertain terms, without equivocation, that the bloodstain evidence in that house was not consistent with a beating. Period. I'm going to get to the specifics of their testimony in a minute. I'm going to spend some time on the bloodstain evidence. But I want to remind you that for each of their testimony, Major Pombeck and Dr. Lee, the state had its own very well qualified expert, Terry Labor, sitting on that bench. Flew in here from Minnesota. Objection.
Why?
Overruled.
Shut up, Mark.
To listen to their testimony. He was there taking notes. And despite that, Dr. Labor, Terry Labor, never got up on the stand here to dispute anything that Dr. Lee or Major Pombeck said. They had a rebuttal case. He wasn't part of it. Why not? Well, the first reason we submit is because the lack of cast-off on the walls and ceilings in that stairway defies the laws of physics.
Objection as it will relate to your label.
Overruled. There are two things that are clear from the bloodstain evidence in this case. If Michael Peterson beat Kathleen Peterson with a blowpoke or anything else for that matter in that stairway as claimed by the state, there would be cast-off blood high on the walls or ceiling. It's the laws of physics. You saw the animation. No matter where it comes from, you play it, it goes back. Go ahead. You can't avoid it. It's the laws of physics. When you hit a bloody source, blood stays on the object. When you pull it back, you get cast off. It is also clear that there was not a bit of cast off anywhere in that stairway from a weapon. And I'm going to get into what Dwayne Deaver said about what he called cast off out in the hallway a little bit later. But there's certainly, even he didn't claim that there's any cast off inside the stairway itself, up on the ceiling or the walls or anywhere where it would have been. And you all were out there. You all were in that stairway. You know how much room or lack of room there is there.
Is there room to swing? I mean, you might not have realized it before you went out there. Is there really room to swing this thing with that header right above the doorway? And if there was, if you thought there was, can you imagine swinging it hard enough to kill somebody and not leaving a mark somewhere on the wall? Somewhere? No. The laws of physics are violated if you don't have cast off or marks. Why else? Well, because the spatter on the wall was not created by impacts to Kathleen Peterson's head. As Dr. Lee testified, unrebutted, the blood on the walls is the result of a multitude of actions. You know, we showed you the comparisons, and can we bring those up? Between, you remember the 38 impacts from Mr. Deaver, and we showed you the comparisons. That's the Deaver, that's the C. That's the Deaver, that's the C. That's Deaver, that's the C. Deaver, C. Deaver, that's C, sorry. Deaver. Go back to that last one there for a second. Right there, you can see the cast off. Remember, Deaver said, "Oh, we didn't have any cast off in the test there." You can see it right there on the rosin. Nothing like that. Top is C, bottom was Deaver. The point of that is that you don't get the amount of blood spatter in that space that you had, even from 38 whacks. And we know there weren't 38. Not even the state claims that. What you get it from is a multitude of actions. Coughing, sneezing, shaking of hair, shaking of hands, contact transfer, smearing, satellite spatters, and various other mechanisms by which blood is spattered in a small space. You saw it on that north wall. Dr. Lee testified that there were all kinds of things going on there. Different directions, smears, hair cast off, coughing, and we'll get to the aspirated blood in a second, all kinds of things. And I know that when you all looked at these photos, your initial impression was, well, how could that be from anything other than a beating? We talked about that in jury selection. But pictures can be deceiving. I think you even probably found when you went out to the scene that the blood wasn't as high up as you might have thought it was in pictures. Because the pictures were a little bit misleading. It's lower down. It's not quite as overwhelming as it looks like in the pictures. And if we go to the, well, I got it here. Remember this photo, and it's a terrible photo, but it's here for a reason. This man died of a heart attack. A heart attack. He had a few little lacerations on his scalp. That's documented in the textbook. And yet, look at the amount of blood. Look at the finger marks. I mean, if I showed this to you at the beginning of this trial and asked you what happened, I'll bet every single one of you would have said he was murdered. But you can't jump to that conclusion. Pictures can be deceiving. And that's why it's important to have experts. You know, I know
That's
that
why I have extras,
Kathleen's sisters and her daughter, initially they were supportive of Mike, and then they looked at the autopsy photo without any explanation. And I understand why that changed their minds, but that's why you have experts to come in and explain how this sort of stuff happens. So you don't just jump at the first impression. We know that there was coughed up blood, and there was a dispute. You remember Jan Leedsman came in and testified that he found some blood in the lungs. And keep in mind, we're not saying the blood was aspirated in the sense that it went all the way down and then came up. We're not saying there was any internal bleeding. What we're saying is there was blood coming down her face. You saw some remnants on her eye. It was getting in her nose, it was getting in her mouth, and she was spitting it out. And we know that at least some blood got in her lung, and you have to say, well, how did that happen? But more importantly, if you look, you can see some there. I think Dr. Lee circled them. But you can see, have the right there. What do you call the ghost? And over there. And over there. And over there. And if you look around, I won't take the time, but there's another one right there. If you look at those photos, you see the ghost patterns that even Dwayne Deaver said are characteristic of blood that has been mixed with a little bit of air. Because what happens is a little bubble forms in the middle, the bubble bursts, and what you're left with is the ghost center and the ring around. Just wait for that to form, that's it. There's also no issue, there's also no issue that some amount of time, 30 minutes, maybe somewhat longer, passed from the time that Kathleen sustained her first injury until her death. We know that from the red neurons. We know it from, remember Dr. Lee went through that, I won't take him out, but he went through the PAMPs and showed you how certain stains had to have come after some period of time because they came on top of urine that had partially dried. Or he showed you coagulated blood that had to have taken some amount of time to dry. Or he showed you areas where there were spatter on top of dried smear. And that would have had to have been over some period of time. So we know from that time passed and that this event extended over time. And we know that Kathleen Peterson got up on her feet far enough to get blood all the way up on the insteps of her soles into a pool of blood. And we know that she sat up for some period of time, an extended period of time, because she had blood right around her waist. And I think it was Dwayne Deaver who admitted that you get that from some sort of extended contact. You know, in order for it to get there, she has to be in that position for some period of time. And so what you have when you put all that together is a dynamic situation. I think that's the way Dr. Lee explained it. A situation involving Kathleen Peterson moving around into various positions, creating blood spatter here and there over a period of time. In other words, a scenario that is much, much, much more consistent with a fall, an accident, where someone becomes disoriented, is trying to get up, is partially unconscious for a period of time, maybe totally unconscious, certainly dazed, moving around, getting additional injuries.
I have favorite hooks running.
Moving her hair, clearing her face. Much more consistent with that than it is with a being where what happens is you beat the person, they lose consciousness, and they die. You don't beat somebody and then let them sort of crawl around and die of loss of blood after 30 or 40 minutes. That's not what happens. And so the blood spatter here, despite the amount of it, or perhaps because of the amount of it, is much more consistent with a dynamic event over a period of time like an accident than bleeding. The small amount of blood on the sneakers and the socks is inconsistent with a beating that created the amount of spatter on the walls. I don't need to show you the amount of spatter on the walls again. You saw it. How do you get 10,000 spatters on a wall and that little blood on sneakers if you're wearing them when you're beating somebody to death? How is that even physically possible? Remember I asked Dan George that, and he was honest enough to say, that wouldn't happen. How do you get these sneakers worn in that scene in a beating and not have them covered with blood? And you didn't hear any evidence that these were cleaned up. And the socks, they're buried in here, but if you want to, you can take a look at them. There's no spatters on the socks at all. None. There is no spatter on Michael Peterson's shirt, or his glasses, or his watch. None. Not just little spatter. None. Now, Dwayne Deaver didn't do that test, you remember, until after Terry Labor and Bart Epstein sent him the report and said, hey, gee, you can look at this with a special light source and see. And he then looked at it. And there was blood, there was contact stains, but there was not a single spatter on his shirt. There was not even, the glasses are in evidence. We got them from the scene. There's no spatter on the glasses. The watch is in evidence. He looked at the watch when he did it. There's no spatter on the watch. How do you beat somebody in that stairway, in that kind of close proximity, and not have blood spatter all over your shirt, and all over your watch, and all over your glasses, and all over your hair, and all over your face? When the police would have gotten there, if Michael Peterson had beaten her to death in that stairway, he wouldn't just had blood on his pants. He would have had blood all over him. There's no evidence that he took a shower, that he washed himself. How is that possible? The lack of spatter on Michael Peterson's shirt, watch, or glasses is inconsistent with a beating that created the amount of spatter on those walls. Next, the presence of spatter on the back of the shorts is impossible to explain as a result of a beating. Now, the prosecution made much during Dwayne Deaver's testimony, and I'm sure we'll make much tomorrow, of the spatters inside, I think it's the right leg. A couple of little spatters inside the right leg. They didn't talk at all in their case about all the spatters on the back. And if you remember, Dr. Lee came up and he showed you this. And he said, physically impossible to get these spatters on the back from a beating. And Terry Labor sat there and wrote it down.
I was wondering about that.
You didn't hear him get up here and refute it. Because it is physically impossible. It has to come from some other mechanism. Coughing,
stepping in blood, secondary spatter, something other than a beating. Now, the state wants to focus on the spatter inside, and Dwayne Deaver tried to claim, based on his experiments, and I use that term loosely, that the only way you could possibly get blood inside that was if you were standing like this and beating somebody. No other possible way to do it, Dwayne Deaver says. Well, is that true? Do the shorts get open? I mean, I literally probably have to show you this. You know from your own experiences. You sit down in shorts, the bottom of the leg opens up. There's no rocket science to that. You're sitting over somebody, trying to put towels under their head, cradling them. Your pants are open up. Now, the critical evidence is not the little bit of spatter inside the shorts that could have come from Michael Peterson holding Kathleen or putting towels under her or her coughing or any one of 10 other possibilities with his pants leg open. The critical evidence on the shorts is the spatter on the back. It had to come from some other mechanism. Dwayne Deaver didn't tell you how it got there. Terry Labor didn't tell you how it got there. And I don't think Jim Harden's going to be able to tell you how it got there through a beating. The dilution theory of the state. Does that make any sense? Do you remember his experiment? He takes blood, I think it was on that wig or something, and he puts it on his shorts. And then he goes outside, he pours a jar of water on it. And then he said, although he didn't film this, it didn't look quite right. You know, he looked, compared it to the short. Oh, that's not right. Let me put some more blood on. This is science now. Let me put some more blood on. Let me put some more water on. More blood, more water, more blood, more water. Aha. Now I think I've got it as close as I can get. Why would anyone in Michael Peterson's position who had killed his wife do that? I mean, let's put aside the science for a second. Let's go back to common sense. Why would you take water and pour it on your shorts, leaving bloody water around? Why would you do that? Why wouldn't you take the shorts and put them in the washing machine if you wanted to wash them? Or more logically, if you've gotten rid of the murder weapon, you might as well get rid of the shorts you wore. You know, both can go in the same package, I suppose. And why would you do that, but not wipe the blood off your shirt, the contact blood? But putting aside the common sense of why, Dr. Lee's opinion was that the line of demarcation, I think he called it, on these shorts, was much, much clearer than the line of demarcation on pet shorts. And he said what that indicated was that this dilution was due to some wet thing coming into contact with this, like a towel from a Christmas tree or a laundry room. Not somebody pouring water, because you wouldn't leave a line like that. That testimony was on. We heard a lot about the shoe print on the pants, Kathleen Peterson's pants. And that it was on the back. Now, of course, when you're dealing with sweatpants, back and front can get a little weird at times. I mean, sometimes what was the back becomes the front or the side or whatever. But even more importantly than that, if you remember, Joyce Pretzka, I think was her name, testified to two important things about this. The first one was that the sole is facing away. It's facing that way, away from the head. And I don't think you need to be a physicist to understand that if your shoe's facing that way, you're facing that way. You're not facing towards the person beating them. So we know that whenever this got on there, it wasn't somebody standing over Kathleen, as the state would apparently have you believe, hitting her. And the other thing she testified to is that it was static. No movement whatsoever. So this got put on there, however it got put on there, after Kathleen Peterson was not moving, not during any kind of beating event. And the final point I want to talk about with regard to blood spatter is the void area. You all remember the void area in the middle of that north wall. The void area is a shadow, as explained by Dr. Lee, not cleanup. In fact, if you remember, when Dwayne Deaver first wrote down his notes on December 9th, he wrote down shadow for both what was on the north wall and what was on step 17. That was a term of art. That meant that based on his visual inspection at the scene, he believed that something had come between a source of blood and that surface, creating shadow. He never once called it a cleanup in any single report that he wrote. The first time he ever uttered the words cleanup in connection with those two things was on the witness stand here. I would submit to you that when you look at those pictures, that shadow is much more explainable and consistent with what Dr. Lee said. Somebody having their fist in front of their mouth, coughing and creating a shadow that way, than an attempt to do what? I mean, let's think about this for a second. There's a wall with blood spatter. The state's theory is that what Michael Peterson did was take Windex or something and spray it on the wall in one little area, was like a test or something, and try to make a perfect circle without dripping anything. How do you do that? How do you possibly do that? And for what reason? For what reason would you do that? No, the void area isn't cleanup. The void area is shadow. And so we get back to reasonable doubt number 6. The bloodstain evidence is not consistent with a beating. And the state's real expert, Terry Labor, did not dispute that. Reasonable doubt number 7. The information and documentation from the scene is not reliable. Sometimes referred to as garbage in, garbage out. Some of you may have run into that in your various fields of endeavor. What it basically means is that the end product is only as good or reliable as what goes into making it. That's just good common sense. What do we know in this case about whether the evidence from the scene and the documentation from the scene is reliable? I know that you've heard probably all you want to hear about contamination from me, so I'm going to be very brief about it. What do we know about it? We know that before the police and the EMT even got to the scene, and there's nothing you can do about this, it's human nature, Michael Peterson was in that stairway with Kathleen Peterson. You can hear it on the telephone. You can hear the echo in the stairway. There's no way to know exactly what he did in that stairway. No way. I mean, you find your wife, you're not thinking about what you're doing, you're just doing it. But there are certain things that we do know once the police and the EMT arrive there. We do know that when the EMT arrived there, Michael Peterson was right there in the stairway with Kathleen Peterson's body. They testified to that themselves. We know that the EMTs had to work, obviously, in the vicinity of Kathleen Peterson's body. No way around that. That's exactly what they're supposed to do. We know that after the police got there, Michael Peterson was allowed to go up to Kathleen Peterson's body and to hold her. And that he had to be physically pulled off of her at some point. I think by both Todd and some police officers. We know that after he was pulled off, he was allowed to walk around the kitchen and the dining room area with blood on his hands and blood on his clothes and blood on his feet. We know that he, for example, got some blood on the couch there in the kitchen area. We know that he actually went to the sink at least one time and began to wash his hands. And then when we told him to stop, he immediately stopped. We don't know exactly where he dried his hands off, but one might think that perhaps he did it on his shorts. We know that Todd Peterson was allowed to go to Kathleen Peterson's body. That he was asked to get the bloody phone from inside the stairway. That he was allowed to get cans of soda for himself and his father, despite the fact that he had blood on him. We know that Heather Whitson, the doctor from Duke, was allowed to go up to the body. We know that several other friends and neighbors were allowed into the house and were seen wandering around in various places. And we know that the police did not secure that scene until at least 3:54 a.m. Some of you.
I'm sorry. I thought I was muted when I was yelling at Spike. I didn't mean to bust your eardrums. I'm sorry. Yes, I think Todd and his friends from whatever party they had been at, I think they arrived there before the police did. I'm not 100% positive about that, though, but I think they did.
You may remember in voir dire, I told you that I thought the evidence was going to be that there was at least a 40 or a 45-minute period of time when the scene was not secured at all. And that's what the evidence showed. 3:24 was the earliest that anyone said that that scene was secured.
They were?
We know that Dr. Snell, even after the scene was secured, was allowed to go up to Kathleen Peterson, look at her stuff, and then walk upstairs, up that stairway. We don't know what he did or whether there's any spatter from him on that west wall. We know when the body was moved, there was still wet blood. There was drips, there was blood underneath the body. We know there were 4 or 5 people around the body moving. We know that at that time those sneakers were still sitting right there.
I thought he called Todd first and then called 911. Well, I guess they still got there before Todd did then. Okay, I'm sorry, I was wrong.
The hallway next to Kathleen Peterson's body. We know that towels soaked in blood were just thrown on the floor next to the stairs. And we know for sure that something happened to that north wall to cause the drips coming down from the void area. There are the drips. They emanate from the void area, not from anywhere else, not from the cat picture. They come from the void area. And although
Candace Zamperini testified that she sprayed the cat picture and the wall. Why would you spray to clean the one area of the wall, the void, that didn't have any blood? If you were going to start cleaning the wall, you wouldn't start with the void area. You start somewhere else. And do you see any evidence anywhere of any spraying on that wall other than the void area? Major Pombeck testified that it appeared to him that what was on the floor, I think there was another picture that showed it more clearly, was luminol. That was not rebutted by Terry Lager. He sat here and listened to it, but he didn't rebut it. And let me ask you this. If there's a void area and the police think it's cleanup, why on God's earth would they not try to determine whether there was cleanup marks? I mean, that's the whole purpose of using things like phenolphthalein and luminol. You spray it where you think there's been cleanup, and what comes up are the remnants. You know, the little white marks that are not visible to the naked eye, but come up with the luminol. That's the whole purpose of it. Why would they not spray that? I submit to you that they did spray it. I don't know who did it. I don't know if it was Dwayne Deaver or Dan George or Eric Campen or someone else. But someone wanted to find out if there was really cleanup in that void area. And they sprayed it with luminol, and it dripped down.
Oh, okay.
And what they found out was that there was no cleanup. And that never made it into the report. Indeed, lots of things didn't make it into reports, and that's a whole nother problem. And
I thought they said that he had to move cars for emergency vehicles. So I guess that's why I thought he got there first. But maybe it was additional emergency vehicles that showed up.
the documentation problem. The first responders come up here and they each testify that, they think the blood was dry. Now, of course, they're not quite clear about what blood they're talking about, and they never touched it. But they all say, well, it looked like the blood was dry. Not a single one of the reports that they wrote at the time, not a single one said that. Now they all come in and they say that. Is that just coincidence? That none of them put it in their report, now they all say the same thing? I don't think so, particularly since we know that it's not true. How do we know it's not true? There was blood transferred to the couch. There was blood transferred to the Coke can. There was blood transferred to the kitchen floor. There was blood transferred to the kitchen counter. There was blood transferred to the telephone. There was blood transferred to Todd Peterson's shirt. There was blood dripping 5 hours later. We know that all the blood was not dry, yet there's no documentation about the status of the blood at the time. There's no photos of the luminol spraying, even in the upper part of the stairway, where everyone admits they was spraying. No photos. No photos of the luminol spraying in the kitchen or the dining room, where everyone admits there was luminol spraying. No diagrams of the luminol results in either location. Instead, what you have, and go back and look at this because it's in evidence, you have the reports of Campen and George and Bynum, all of whom disagree with each other about what the luminol spraying in the kitchen and dining room showed. And how does that all get resolved? Well, the prosecution has Campen come in on that big old diagram. He draws a bunch of squiggly lines. Oh, that's it. That's how it was. And Where, Mr. Campbell, is the report that you prepared in April, that we asked for, that we subpoenaed, so I can compare it to what you just drew? Where is that, sir? Destroyed? Excuse me? Oh yeah, I destroyed that. Did you tell Mr. Harden that you were going to destroy it? Oh yeah. Did you know about the court order? Oh yeah. Mr. Harden know about the court order? Oh yeah. Why did you destroy it? Really didn't make any difference. Wouldn't it have been nice for the jury to be able to make that call? Well, maybe. What's that about? What does that tell you about the credibility of that diagram that Campen drew here for your benefit? How about the glitches in the photos? Remember that? I showed you all. Here's a picture of the cabinet, no blood drop. Here's a picture of the same cabinet, blood drop. Both taken on December 9th. What's the deal with that? Oh, we looked at that. That was a photo glitch. Photo glitch? Yeah, photo glitch. Okay, let's get the Deaver in here. Remember these? Yeah. Were these glitches? Oh no, we checked. We looked at the negatives. They weren't glitches. Okay, well, if they're not glitches, what are they? Remember, Deaver said he saw bright red blood on the kitchen counter. We didn't get a photograph of that. Somehow that was missed. We didn't get a photograph of the blood on the cabinet. Somehow that was missed. How is there bright red blood on the counter 12 hours after Mike?
What'd I do?
Counter, and how did it get on the cabinet? You saw the photos. It's not a glitch.
Sorry.
I would submit to you that the failure of the state to adequately secure the scene and to effectively document all the critical evidence that they want you folks to rely on raises a reasonable doubt about how much you can and should rely on that evidence in reaching your decisions. You should not be required, in a matter of this much importance to another human being, to rely on uncorroborated testimony by people who destroy diagrams in violation of court orders. That should not be countenanced.
What happened?
Garbage in, garbage out.
Who did what now?
Reasonable doubt number 8.
How many reasonable doubts you got,
The
Rudolph?
state relied on junk science and ignored the limitations of good science. Junk science is a real problem in courtrooms around this country. There is a proliferation of people who claim to be experts coming in and testifying about all kinds of stuff. And you've heard a lot of forensic evidence in this case, and I told you in voir dire that you would. I told you the case was going to turn on a lot of forensic evidence. And some of the forensic evidence you
That
heard
was me.
good,
I don't know what I
solid
did,
science. I think Professor McElhaney is a scientist. I don't have any problem with how he conducts himself or how he testifies. We may disagree about his conclusions. Dr. Bandak and Dr. McElhaney may disagree. That, there's nothing wrong with that. But they're both scientists, and they both take their work seriously. And neither of them says always or never. That's just not what scientists do. But some of it, because science has limitations. It just does. And good scientists recognize the limitations and acknowledge it.
Some of what you heard was junk science. Dropping styrofoam heads from ladders from 12 feet. Pouring jars of water on your shorts after putting blood on it. Taking pictures of women swinging in chain harnesses. This is junk science.
When did a woman
And the
swing
problem
in a
with
chain
junk
harness?
science, the real problem with it, especially in a courtroom, is that it is result-oriented. Pure science could care less about the results. It's the inquiry that matters. Junk science cares only about the results. It's done with tunnel vision in an effort to reach a particular result. For example, let's take Agent Deaver. Agent Deaver, by 5 p.m. on December 9th, he had been in the house for 2 hours, decided that the death of Kathleen Peterson was a homicide. How do we know that? We know that from the notes taken contemporaneously by Art Hall. This strikes me as a pretty honest guy. I think he testified honestly.
Told him enough times.
1905. 5:05 p.m. He got there at 3:10, I believe. Deaver, homicide.
1905?
No strain done at that point. No detailed analysis. He walked in, homicide. And after that, what did Deaver do? He picked the spatters on the walls that were consistent with his theory. That gave him a point of origin out in space, as he put it. And he ignored the spatters that he didn't like the results of.
You just told him the wrong time, dude.
We know that because
I
Major
missed it too, Bill.
testified that
I
when
think
he
I would
went to
remember
that
that.
scene, he counted 77 spatters on that north and east wall that had been circled by Deaver. 77. How many did Deaver use? 42.
42,
And if you
because
remember,
that's
Dr.
the
Lisa,
answer
part of
to
the problem
life,
is when
the
you have the
universe, and
dynamic
everything.
scene, and some spatter is getting put on top of other spatter, and then it dries, you don't know if you're even choosing the spatter from the same event. But none of that bothers Dwayne Deaver. He erased some of the circles he originally put on. He testified to that. He didn't document with photos or with diagrams any of the spatters he did use. He made it impossible for anyone coming behind him to really check his work, including Terry Labor. He drew on the wall and he ignored what he drew. He didn't photograph the string. You know, Dr. Lee got cross-examined about some string that was documented in his book. Well, you know why he was able to be cross-examined about it? Because he took a photo of the stringing process. That's what you're supposed to do. Because it shows how much the area of convergence, how large it is. You know, these strings don't all come to a single point. That's fantasy. When you're stringing for real, you're getting an area of convergence, not a point of convergence. But Dwayne Deaver made it sound like what you get is a point of impact. Remember? As though the only way you could get spatter that you string and find an area of origin for is an impact. Well, that's misleading. That's not true. In fact, what a point of origin really ought to be called is an area of origin. It's not an area of impact. It's an area of origin. It's an area from which blood, by some mechanism, originated.
Exactly. He said it was 5.
That mechanism can be coughing. It could be your hand. It could be your hair. It could be an impact, but it doesn't have to be. When Agent Deaver talked about junk science, when Agent Deaver realized that he hadn't said anything
in any of his reports about cleanup, what did he do? He sat here and said with a straight face that he drew distinctions between conclusions and opinions. His reports just contained
Conclusions, not inclusions.
They didn't contain opinions. And conclusions were things that he believed more strongly than opinions. And since he didn't believe all that strongly that it was cleanup, I guess, he didn't put it in as a conclusion, he saved it as an opinion for the trial. Now, does that make the least bit of sense to any of you? Does it honestly make any sense at all? That's his explanation for why it doesn't appear. That's all that is. And finally, he realized that the laws of physics required him to come up with some sort of cast-off up high. He realized it late in the game because he had never documented any. And so he came in here and tried to testify to you, under oath no less, that the couple of drops up on the wall outside on the header in the hallway were one continuous cast-off from a blow inside the stairway. And you remember we went through that other cases where he had testified that a single drop could be cast off, even though that was completely false, and people were convicted in those cases. And he testified that he got blood indications from phenolphthalein, even though we know that it's just a presumptive test and it doesn't say blood, it just says possible blood. That didn't bother Deaver in those other cases. And it didn't bother him in this case to say that it was cast off in the hallway. And I don't know what he thought we would do about that, but what we did is we went and looked. You know, I mean, did he think that we had painted over it or something? Maybe that's what he was counting on. I don't know. There it is. You see the two little tails pointing at each other. You know enough about blood spatter now, you can tell whether he's lying or not. You don't need me. Just look at the picture. And all of you went out to the house, and we had a ladder set up there, and I hope you can get a good view of it in person. It's not rocket science, it's blood spatter. But even reputable scientists, and I'm going to give you all a break just a few minutes to bear with me. Even reputable scientists can engage in junk science. And a good example of that was seen with Dr. Radish. Now, I'm not going to sit here and tell you that Dr. Radish is not very well qualified to give opinions about the cause of death. No dispute about that. We didn't even cross-examine about that. But she has no training in determining the cause of an injury. And that's a really important distinction. Forensic pathologists work from sort of the outside in. And they look at the injury that's sustained and they say, how did this cause death? And sometimes, of course, it's obvious what caused the injury. It's a gunshot wound, it's a knife wound, you know, we understand that. What they're not trained to do is tell falls from blunt object beatings. You just don't get any training in that as a forensic pathologist. And so what Dr. Radish did was to go outside of her area of expertise in that regard. Because remember, I asked her, well, if we look at each of these lacerations individually, is there anything medically, forensic pathology-wise, that you can tell us about laceration 1 that means that's not from a fall? No. How about laceration 2? No. 3, no. 4, no. Each individual laceration was completely consistent medically with the kind of laceration you would see from a fall.
as distinguished, for example, from an incised wound, something with a sharp edge, where you would have a complete incision of the bridging tissue. All right, so what does she do then? She said, well, no, if you look at the whole of them, if you look at all of them together, now it's my opinion they're not consistent with a fall. How is that medicine? What does that have to do with medicine? It has nothing to do with medicine, because what she said was, well, the basis of that is my experience and the study I did. So let's take a quick look at those two things. Her experience, 3 fall cases in 10 years. I mean, it's almost shocking. On direct, she says, oh yeah, based on my experience, this couldn't be a fall. Okay, ma'am, how much experience do you have? 3 cases, 10 years. Do you know anything about the circumstances? Well, I know 1 or 2 of them were older people. Well, you know whether they were carpeted stairs or wood? No, don't know that. Know anything about the location? No, not really. And of course, she also admits she knows nothing about, firsthand at least, about the Peterson scene, because she's never been there. Barely looked at photos. And now that you've been there, you have a sense of the importance of going there. You know, I might have said that to you if you hadn't been there. Maybe you would have appreciated it, maybe you wouldn't. But now that you've been there, you get a real sense of needing to be in the space and seeing how that chair works in that space and just getting a sense of it. It's different. It's really different. What about her study? And with all due respect to Dr. Radish, I've got to say that I think her study was the epitome of junk science. I mean, it's sort of, first of all, she didn't do it before she reached her opinion. And that's a little bit like, I mean, imagine somebody in the world of science, they publish a paper, and then they go and decide to do the research to justify the paper. I don't think that's how it works. I think you do the research first before you reach your conclusions. But put that aside. Maybe the most disturbing thing of all that I heard in this trial, maybe, was the reason that Dr. Radish gave for not looking at more of the 289 cases. You remember there were 289 cases of falls on steps leading to death, more than from beatings in the same time period, interestingly enough. She looked at 29. And we talked about why she chose that group and why she didn't go up to age 60. And ultimately what she said was, well, I had other things to do, other important things to do, and I didn't have the time. And she's here testifying in a first-degree murder case. Someone is facing serious consequences. And what she says is that she only looked at 29 cases, and she's prepared to come in and tell you it's not consistent with the fall based on those 29, and she doesn't need to look at the other 260 because she's got more important things to do. Well, I would submit to you that all of us have important things to do in our lives. All of us have other things that we could have spent our time on for the last 5 months. But all of you put aside all of those things in your lives to come here and sit together to judge another human. And I submit to you that you all, having made that sacrifice, were entitled to have a state's witness spend whatever time was necessary to give you meaningful statistics. We spent the time. They're all there. We're busy too. She can choose not to spend the time. That's her business. Mr. Harden can choose to put her on, even though she didn't spend the time. That's his business. And you can choose to ignore that testimony because she didn't do
what she should have done, and that's your business. That's a good place to read it.
All right. How much time do you want?
What's that?
How much time do you want?
Oh, whatever you all want.
10 minutes, Mr.
Ladies and gentlemen, we'll take a 2-minute break. Please
Okay, we're gonna stop there. Okay, we're at right at an hour. Okay. Okay, yay! I so wanted to be done today. But I guess we'll finish tomorrow and then start on Letitia Stalk tomorrow. So I got to figure out what time. So we'll start this at 9, finish it, and then start her. Travis is eating dinner and Spike would like some. And Belle would like some too. So, I'll see you guys in the morning. We'll finish up this. We'll start the Letitia Stout trial. And there's a trial starting on the 28th. Guys, think about it. Do you want to do like we used to do, where I did an old trial for a couple hours in the morning and then we did a new trial? Or do you want to just keep sticking with the old trials? You guys think about it and let me know tomorrow. Okay, guys. I love you all so, so much. Thanks again, Judy, for the gifted memberships. Was that this morning or was that yesterday? I can't remember. Anyways, thank you, Judy, my wonderful mod. Thank you, everybody, for being here. And I will see you guys. Oh, sure. I have to put her ears on and do her shoes. And she has some more details on her face. Amigurumis don't have mouths, and I don't know why. But when I put them on, they look weird. So I just go with it now. Amigurumi is it's Japanese for crochet doll. And they don't have mouths. I don't know. But there they are. And they have wire in them. I'm going to have to she just has pipe cleaners in her arms. I'm going to have to put the wire. He has wire. I don't like wire if I'm going to give it to a kid. But this is for an adult. So it won't hurt. But sometimes the wire will poke through. And if it's for a kid, I don't want, them to get poked with a wire. So I do the pipe cleaner. But the pipe cleaner's not quite strong enough. But he put his arm around her. There we go. There we go. Okay, guys. I will see you in the morning. Be kind to people. Love your family. And Jesus loves you, and so do I. Love you guys. See you tomorrow. Have a great evening. Bye.